Good morning, everyone. Welcome to the last planning committee of this term's council. So members of the public, you are advised that our meetings are webcast live by the City of Hamilton and temporarily archived on the city's website. Other individuals and the media may also be audibly or visually recording this meeting. I also want to let you know at this point in time, please shut off any electronic equipment if it goes off and annoys me. We don't like that. So, Madam Clerk, are there any changes to the agenda?
We have a number of changes today. We have quite a few delegation requests. There are four for item 8.4, which is the Barton-Tiffany Urban Design Study. There's also one for the medicinal marijuana. We also have one that was approved previously at the last 8.1 and 8.2, which is the Hamilton Gateway Marquee Partnership and the sign variance at 900 Woodward Avenue. And then we also have a delegation request from Matt Johnson respecting an in-camera item, which is 12.3, the Shoppers Drug Mart Limited. We also have 3 items of added correspondence for item 6.5, which is 1292 Old Highway number 8. And then we also have an additional item of correspondence respecting medicinal marijuana from Ed Fothergill on behalf of 381 Highway 8 Dundas. And then just one added item to be added to the list of items to be removed from the outstanding business list. It has been dealt with at the Ontario Municipal Board, so it's no longer in effect, and that's 55 Rymel Road East.
Thank you. May I have a motion, please, to approve the agenda as amended? Councillor Pearson, Councillor Pasuta, all those in favour? Carried. And just to let everyone know that Councillors Collins and Partridge have sent the regrets, but they will be here by noon, so they'll be showing up shortly. Yes, Councillor Pearson.
Madam Chair, yes, and as I mentioned to you earlier, that I have to leave for a conference call at 10 o'clock, but I will come back as soon as I'm
Okay, thank you. And just to let the people in the audience know that when my colleagues get up to washroom breaks or to refreshments and fill up their coffee mugs, we can hear that's in the antechamber, and so can the staff when they're in their antechamber. So, are there any declarations of interest? Seeing none. Approval of the minutes of the previous meeting. This is the one from... Oh, sorry. I'm sorry. So we don't have them in front of us. I'm sorry. Okay, so we're going to go right to delegation requests. Delegation requests from Jasper. I'm sorry. This is going to be awful for me to do the names. Kajawski. I'm sorry. Respecting item 8.4, Barton-Tiffany Urban Design Study. May I have a motion to approve the delegation to request to speak to 8.4? Councillor Pasuta, Councillor Pearson, all those in favour. Thank you. We're not even going to try the next one. It's 4.2. This is the delegation respecting item 8.3, Bill. Review of the medical marijuana. May I have a motion to approve the delegation respect 8.3, Councillor Ferguson, Councillor Pearson, all those in favour. Thank you. Delegation request from Sarah Mayo. Respecting 8.4, Barton-Tiffany Urban Design Study. May I have a motion, please, to... Thank you. Councillor Vale regarding the Barton-Tiffany Urban Design Study. May I have a motion, please? Councillor Pearson, Councillor Farr, all those in favour. Thank you. And we have another delegation on 4.5, and this is respecting Barton-Tiffany Urban Design. This is Steve Radaniki. Can I have a motion, please? For Councillor Ferguson, Councillor Farr, all those in favour. Carried. And we have a delegation request from Glenn Gibson and Jeremy Kramer respecting 8.1 and 8.2, Hamilton Gateway Marquee Partnership and sign variance at 900 Woodward. Councillor Ferguson, Councillor Clark, all those in favour. Thank you. And just to be 4.7, delegation request from Matt Johnson respecting 12.3, appeals to the Ontario Municipal Board by Shoppers Drug Mart. May I have a motion, please, to approve that delegation? Councillor Pearson, Councillor Ferguson, all those in favour. Thank you. And just to remind folks that unless you're speaking to an item that starts with the number 6, you will have a 5-minute time limit. Number 5, consent items, revisions to Parkside Hill Phase Draft number 2 plan of the subdivision in Waterdown Wharf 15. May I have a motion, please, to approve item 5.1? Councillor Pearson, Councillor Ferguson, all those in favour. I have a request for 5.2 to be tabled. The applicant could not make it, so we'd like a motion, please, to table it to the December 9th planning meeting. Councillor Ferguson, Councillor Pasuta, all those in favour? Thank you. 5.3, Hamilton Historical Board minutes from July 15th. May I have a motion to receive 5.3? Councillor Pearson? Yep, Councillor, because you're on the board. Councillor Pearson, Councillor Ferguson, all those in favour. Thank you. Now we're on to the sixes. 6.1, these are our public meetings. The first one is the proposed zoning bylaw amendment affecting lands located at 252 Governor's Road in Ward 13. Members of the public, in accordance with the provisions of the Planning Act, please be advised that if a person or public body does not make oral submissions at a public meeting or make written submissions to the Council of the City of Hamilton before Council approves the zoning bylaw amendments, the person or public body is not entitled to appeal the decision of the Council of the City of Hamilton to the OMB, and the person or public body may not be added as a party status to the hearing of an appeal before the OMB unless, in the opinion of the board, there are reasonable grounds to do so. Is there anyone here? We just want to do a straw vote. Is there anyone here to speak on 252? Thank you. We've got members of the public. So what I'd like to do right now is ask Tim Lee from our staff to come down for the staff presentation.
Hello? Okay. Good morning. Good morning, Madam Chair, members of committee and the general public. The application before you I bring today is the amendment to the Dundas zoning bylaw in order to permit a day nursery within the extent of the existing single detached dwelling. So I'm going to start off with a location map just to show you where the property is located. The property is located at 252 Governor's Road, which is located here where the red box, which currently contains an existing residential use. So the nature of the application is to propose a day nursery, which will be contained within the existing building only, and the amenity area would be located in the rear yard, and no additions to the building are being proposed. So as you can see in the this is where Governor's Road and the amenity space will be located in the back. The children drop-off and pickup, along with the entryway to the rear yard, will be located in the existing parking area of the St. Mark's United Church, which is here, and is located municipally known as 1 to 5 Lindell Drive. An agreement with the church would be required to safeguard the passenger drop-off and pickup, which will be provided in conjunction with the proposed use. The location of the drop-off provided off-site will ensure that the parents will be utilizing the church parking at the time when the church is not in use, notably during the weekdays in the morning and the afternoon, and leaving the existing driveway to staff parking only. So this air photo, just want to show you, is just kind of the context. You can see there is a variety of single detached dwellings along Governor's Road, and the church property is actually located here with the parking area immediately to the rear of the subject lands. And there's a commercial residential development here, and I believe a retirement home is located here as well. So what do we have before you is just some clarification that is required to committee members with respect to parking and the size of the daycare operations. So firstly, I just wanted to point out that in the staff report indicates a total of 10 employees would be present at one time under one shift. Just a clarification that 3 employees would be present per shift with a total of 3. So as a result, 3 employees would be present at any one time. And the modification as before you is to The modification is to reduce the number of required parking spaces from 7 to 2 parking spaces. So under the draft bylaw, it indicates that one space for each 125 square meters of gross floor area that can be accommodated. And in addition, it will be provided within the required front yard and also in tandem as well. The reduction in the parking spaces is supportable, and the modification of the parking requirements is consistent with what is found in the Hamilton zoning bylaw 05200 as well, where one parking space is required for 125 square meters of floor area. Furthermore, as 2 required parking spaces are to be provided within the existing driveway, no additional alterations to the driveway, such as a hammerhead, would be required. And as a result, in the staff report indicates that site plan may be required, and because there is no additions to the existing dwelling and also there's no changes to the driveway, that site plan would not be required. In addition, the second clarification is that staff report indicates that the daycare will have a capacity of 41 children. As before you in the motion, there has been discussions to reduce the number of children from 41 down to 26, and that is what is included in the revised bylaw as presented to you in the yellow sheet. So in accordance with the Council's public participation policy, the application was circulated as part of a notice of complete application and pre-circulation to 74 residents in May of 2014, where 3 letters have been received expressing concerns with the application with respect to the traffic and also the number of children occupying the proposed daycare, day nursery use. So what I'm going to do is just very, very briefly talk about the concerns. So the concerns that were raised respecting traffic that would be created with the day nursery use, especially cars entering and exiting off Governor's Road. So I just want to refer you back to here. So as shown in the concept plan, the drop-off and pickup location will be located off-site at the existing parking lot at the church, located immediately to the rear of the subject lands. So this will prevent parents from entering the driveway onto Governor's Road and utilize the parking area of the church and exit back onto Governor's Road through the signalized intersection on Crichton. And in addition, as mentioned in the staff report, the day nursery would cater to more of a local market than more regional market, and it is anticipated that the majority of the children will be coming from the local residential community. So based on the foregoing, staff have no further concerns with respect to traffic. The second concern is the size of the day nursery. So as I mentioned, the original draft bylaw indicate that 41 children is proposed, and this has been now reduced to 26 children. And again, staff have no further objections to this application, as the number of children has been reduced down to 26, and as mentioned, the amenity space can be accommodated in the rear yard of the property. And in addition, there are no plans for any additions to the existing building is proposed at this time. So in conclusion, staff recommends that the application be approved as amended based on the above reasons, and I will be happy to answer any questions. Thank you.
Thank you, Mr. Lee. Councillor Pearson.
Thank you, Madam Chairman, and thank you, Mr. Lee. I just want to confirm, and as you're speaking, I found the green sheet, so I just wanted to verify we will receive confirmation that they will have agreement with the church, and that will have to stay in good standing for this to continue. Is that correct?
Through to the chair, that is correct. So what will happen is that they will have to enter into an agreement with the church property to ensure that the passenger drop-off and pickup will be there.
And we will keep a copy of that, a record of that on our file with this application, so that we keep it in our historical records.
Through to the chair, I believe that is correct.
Thank you.
Councillor Clark.
Thank you, and that's helpful. Does the church have the right to revoke it I'm not sure we can issue a request an irrevocable clause.
Due to the chair, I mean, I guess once the agreement is in place, there'll have to be an agreement with the church in order for that agreement to take place. Not sure if legally.
I was going to say, can we direct
yeah.
this to the
Through
legal
you, Madam
department,
Chairman,
please?
Quite best.
Mike?
Good morning, Mike.
Good morning, Madam Chair. Through you, an agreement is just that. It's an agreement between two parties. If it doesn't contain terms as to the length of the agreement and termination provisions, both parties can mutually agree to terminate it at any point. It all depends on what the agreement says. I believe this is just a rezoning that is before committee. Am I correct in that? It's difficult to place conditions on a rezoning that can be enforceable. As you all know, the Planning Act does not allow conditions on a rezoning. So it is a difficult matter for the city to enforce. You can have agreements registered on title. They, if there's a right granted for more than a certain period of time, you have to get a consent for it. So I'm not aware of the agreement. Legal has not been consulted on the agreement, so we don't know the terms of it.
Is the applicant here today?
Yes.
Okay, thank you.
And I would like to ask some questions, and both my vice chairs are absent at this moment. So can I ask Councillor Pasuta, please, to take the chair? That was my first question as well, Tim, because my understanding is that this is okay with traffic and with parking because there's this agreement that's attached to the back end of the property. If this church did not exist and was not there allowing this to happen, would you approve 26 children to come into this building if it was just a standalone application?
Just asking clarification, without the drop-off?
Without the agreement with the church. You have a house here that's beside other residential homes, and you clearly said you're not changing the parking. So would this application be recommended for approval if the agreement with the church was not in place?
With you to the chair, I would have to look back and re-review the application. In that case, we would have to look at concerns respecting just the parking and traffic again. Honestly, I'm not too sure, sorry.
And I think that's where, and when I was reading through the concerns, that was my concern. I've been on Governor's Road as well as most of my colleagues have, and you just understand how windy and how busy it can be. So to have a drop-off and pickup point, this is no different than a school where you're going to have peak hours in the morning, peak hours in the evening, where people are coming before and after work to pick up their children. And if they didn't have this behind them and weren't assured and had some comfort level, and the neighbors didn't have a comfort level that this agreement behind is binding and it will go with the daycare, and if that agreement is gone, then the daycare either A, finds other alternatives or agrees not to continue, then I think the comfort level would be there. So that's just my questions, and I just wanted to ask you if, okay, so I'll take the chair back. Thank you. Can I have Councillor Whitehead?
Madam Chair, actually, I have someone that's looking and making the same inquiries regarding Stone Church, which is, like Governor's Road, a very busy street right next to and very close to the roundabout, 25 children daycare in a house. So obviously it's a concern to me from a traffic point of view. Do we not have any ability to say 25 is just too much for that particular location?
Through to the chair, there's also a couple of things. The number of children that can be accommodated is also under the Day Nurseries Act. That's one aspect. And of course, the other aspect is looking at the traffic. On this application, we are proposing that there is that off-site passenger drop-off and pickup. It is to my understanding that there is kind of an agreement to have that agreement in place, and that's why in the draft bylaw that we have said that an agreement in title is the best way to go.
Yeah, again,
the
question I'm asking is, I don't have issue with a daycare. There's needs for daycares everywhere. My issue is the amount of traffic and parking that's driven by the amount that that particular daycare is going to service. So the proposal is for 20, is it 25?
26.
26. The proposal is 26. Obviously, if the proposal was 15, it would have less impact. Was there any discussion about whether that number makes sense for this location?
What I would say that there was some kind of discussion, and I think that's why that we've reduced the number of children from the 41 down to the 26. After discussions with the councillor, that 26 was much more amendable, and that's why we have revised the draft bylaw to include 26 and not the 41.
Councillor Whitehead?
I appreciate that. I mean, the location I'm talking about is currently being serving as a mosque on Stone Church. It's a house that was sort of converted into, the parking lot.
Councillor Whitehead, is this about this particular application, please?
The analogy is there, Madam Chair. If
I
you allow
get
me to
that,
finish.
but I just need questions for this, please.
This is I'm making a point. Thank you. And the point, well, look, if you don't want me to ask questions, and that's how democracy works, then we can do that. If you can allow me to ask the question,
questions
let me
regarding
finish
this
it.
application,
It
please.
is. You haven't let me finish. The issue is that the traffic load, especially at peak hours, as indicated by the chair, has created a huge problem in regards to the traffic loads at those times on that particular road. Governor's Road is no different in regards to the peak time, peak hours. It's one of the major arteries into and out of Dundas. So when you do unfortunately, when we do our traffic studies, we do those traffic studies on a 24-hour time frame. Is that correct?
Through the chair, I believe, yes, that's correct.
So do we isolate it in any way at peak hours? What impact would it have during peak hours?
Through to the chair, in terms of the peak hours, I mean, we've looked at the concerns respecting traffic on Governors, and I think that's why we have restricted the passenger drop-off and pickup away from the single driveway, the driveway onto Governors, restricting it only to staff parking. And that would prevent any of the vehicles to back up onto Governors, creating a dangerous situation. And I believe that is the reason why we had, it is proposed that the drop-off be provided off-site so that it at least provides a more safe access for cars, but also a safer way to pick up children and to drop them off in a manner that's where there's fewer traffic passing by.
So clearly there was identified a concern in peak hours, and this is the accommodation.
That's yes, that's correct.
No other questions? Councillor Ferguson.
A point of order. The document says 41 children, but I see an amendment here for 26 children.
Right, 26 children.
And I saw an email from Councillor Powers, the board councillor, saying that he's supportive of this, of his 26 children. I assume the applicant, and I can ask the applicant later if you'd like, Madam Chair, but I assume
And the applicant would like to speak after the public, so I was going to mention that before we brought the public down.
I'll make sure I ask her that question.
Perfect. Thank you. Can I have a motion, please, to receive Mr. Lee's presentation, please? Councillor Farr, Councillor Ferguson, all those in favour. Thank you. I would now like to hear from the public, please. Anyone who would like to come down, please come down and introduce yourself. And when you're finished introducing yourself, please sign in at the book that Vanessa is going to put at the table right there for your convenience. Mr. Lee, you may want to just... Thank you. Hello, sir. How are you?
Good morning. How are you?
Good. And your name, please?
My name's Jeffrey Hughes. I live at 4 Creekwood Place, just off Governor's Road.
Thank you.
I have lots of concerns with the traffic flow. And it's always during peak hours. And I understand we have lots of need for daycare and have nothing but admiration for the guy putting it all in and putting it all together and all the work he's gone to invest money to do this. And I hate to be here objecting. But Governor's Road's a nightmare already. And now we've got another school, or at a half a school being put up there, and you can hardly get out in the morning. So I'm glad the additional traffic is limited to maybe 2 or 3 parking spaces on the front. So that leads me to the back. My daughter lives in the back. And when she bought there, she said, oh, great, a church, 1 day a week for most of the traffic. Now we're going to 26 kids and 26 drop-offs in the morning, 26 drop-offs in the afternoon. That's a lot of extra traffic on a residential street. So I'm thinking, I didn't even see the sign until I walked by it one day. It's a beautiful, big, huge sign. I hardly ever see them. So I walked by and I saw 41, and I thought, if I was on the street behind, I'd never know. That sign should have been on the back street too, because all the people that are going to be mainly affected are on that street. So sure, they got notice. Because I said to somebody else, I get all kinds of stuff in the mail and I put it to the side, then I forget about it. I don't think that the people in behind really know how it's going to affect them, and they weren't given proper notice. And since the church is an integral part of this, the 400 meters should be from the church property as well, not just from the subject property. So those are my main concerns. So that's all.
Thank you, sir. And what we do is we hear everyone out, and then we ask the staff what you've been presenting to the your questions to the committee. He did sign in.
Yeah.
Thank you, Mr. Hughes. Yes, sir. We'll do them all at the end. We have correspondence too. Good morning. And your name?
Bruce Lockhart.
Bruce Lockhart. Thank you.
And I'm next door to the proposed property. And I think we've discussed and had concerns about the traffic. It's no doubt. I've lived there over 25 years. And now with 3 schools up there, you got to remember that we have a retirement home across the street. And the peak hours of traffic would be when the children get dropped off and picked up, and that's a huge concern. As far as having an agreement with the church, as of last night, I know there is no agreement, and we don't know at this point in time if there is going to be an agreement. And so that's something I want to bring up. Now, the last thing, and it has to be very important to me, is, again, I've been living on Governor's Road for 25 years, and bought there, did a lot of improvements to the house, put an addition on, planned to stay there as long as I could. And then all of a sudden, I'm going to have a business next door, and just seeing, and it wasn't brought up by Mr. Lee as one of the issues, but it's my single biggest investment, and we know realty-wise it could affect the property value, and I've been told, and it also could have a great effect on saleability as somebody who may like the house but not want to buy next door to a business. So those are my concerns, and I guess if this is all contingent upon the drop-off and pickup being at the rear, that should be found out first, because to my knowledge, there's been no agreement, and I don't know where that stands.
Thank you, Mr. Lockhart. Any questions for Mr. Lockhart? Seeing none, thank you very much, sir. And if you don't mind, could you please sign in while
Yes.
the next gentleman comes up? It's okay. You can come right over to the microphone. And you can manipulate the microphone any way you want so we can hear you nice and clear.
My name is Roger Parliament, and I live at 260 Governor's Road, 3 houses away. If the church gives written consent to use the parking lot, what is the guarantee that 40 cars will not be coming in and out on Governor's Road? They will still use Governor's Road regardless of the churching parking lot. I have already stated in my letter that every 15 seconds a vehicle goes by my front door from 7 a.m. till 9 or later at night. The traffic on Governor's Road is horrendous, and you will not be able to go there, get in and out with all that traffic. Also, with in excess of 50 people in the house that size is ridiculous. You're talking 41 children plus adults, 2 bathrooms, maybe 3. That is a ridiculous number in a house of that size.
Mr. Parliament, just to be clear, there's 26 that they're asking for. They've changed the application. I don't know if you were aware. Thank you. Can I have a motion, please, to receive all three delegations? Councillor Ferguson, Councillor Clark, all those in favour. Is there anyone else here from the public that is willing to come down and speak to this issue? 252 Governor's Road. Going once, we'll do this 3 times. Going twice, and 3 times. May I have a motion, please, to close the public meeting? Councillor Ferguson, Councillor Whitehead, all those in favour? Carried. Thank you. And we'll now hear from the applicant. Guess who it is?
Morning, Madam Chairman, members of the committee, staff.
Could you please introduce yourself?
Yeah, my name is Paul Mallard. I'm the planner for the applicant, Mr. Steve Dunham, and I'm here to represent him in terms of the public meeting today. With respect to the application, staff's indicated that there has been an amendment that was achieved this week through a consultative process with the ward councillor, Councillor Powers, and city staff, Mr. Robichaud, the Director of Planning. Given the councillor's concerns and the area residents' concerns with respect to capacity, the client agreed to and is amenable to the amendment to reduce the capacity from 41 children to 26. That also has an effect of reducing the staff from 10 to 5. So there's an associated reduction there as well in terms of the number of staff on the property. From my perspective, the proposal is consistent with the provincial policy statement. It's consistent with places to grow. It conforms to and implements the Urban Hamilton official plan. A day nursery is an identified permitted use under the official plan. It's suitably located and it fronts onto a major arterial road, Governor's Road, which has direct access to public transit. Tim indicated that currently the owner is operating a private home daycare for 5 children, of which 3 of those children are from the immediate area, and they're a walk to the facility. Adequate parking can be provided in accordance with the bylaw 05200. So with respect to the drop-off and pickup, this was an issue that was actually initiated by my client, and he recognized the aspect of traffic onto Governor's Road. So it was through his initiative that he approached the church in advance of submitting the application to secure drop-off and pickup for the parents that would be bringing the children to the facility. It's not required parking. So I think he's gone over and above in recognizing the existing situation and is trying to address that. He has been in discussions with the Board of Governors of the church in terms of establishing the terms of the agreement. That agreement is to be to the satisfaction of the Director of Planning, so the city will have the opportunity to review that. The zoning does require it, so without the agreement, he's unable to establish the facility for 26 children. From my perspective, the proposal is compatible with existing and planned development in the immediate area. Tim alluded to the retirement home across the street. There's town housing across the street. The church is to the east, and there's a commercial plaza to the east, and then there's a number of single-family dwellings. It would maintain the character and scale of development in the area in that it's being only operated within the existing single-family dwelling. There's no additions, no expansions, no changes to the front yard. There's a double-wide driveway there. So it maintains the residential character and appearance of that side of Governor's Road. The one issue that hasn't been addressed is the need for childcare. With respect to Dundas, childcare services, there are 10 licensed facilities which provide a total of 664 childcare spaces. None of those spaces are for infants. The owner here today is proposing a facility to cater to infants and toddlers. Infants is 0 to 18 months, toddlers 18 months to 30 months. Of those 664 spaces, only 5.5% are for toddlers. So there's a clearly demonstrated need for this type of facility in the town of Dundas. Interestingly, there was an article in the Dundas Star yesterday with respect to the rezoning. I don't know if anyone has seen it. I can pass it around to the committee. But in the end of it, Mr. Campbell identifies that in 2008, a Dundas study funded by the Ontario Trillium Foundation recommended creating 10 new licensed staircase providers in Dundas. Only one licensed provider was added by August 2013. So clearly there's a demand for this type of service in the community. Council's policies and Council's policies and objectives, goals and objectives under its policy documents are to create complete communities. From my perspective, the provision of this type of service in the community goes toward implementing those goals and objectives. There's a need, it's suitably located. I believe the amendment that was reached in discussion, as I said, with Councillor Powers and city staff, addresses not only the councillors' concerns, but the area residents' concerns. The capacity would be reduced from 41 to 26, and as part of the zoning, he will be required to enter into the agreement with the church to the satisfaction of the Director of Planning prior to the use being established on the property. Those are my comments, Madam Chairman.
We have some questions. Councillor Whitehead and then myself.
Thank you. We heard one of the presenters, and we all know this, people make the biggest investment in their homes, and they hope that they can secure through retirement the value of their home. And there was concern about whether something like this would impact the market value and the sellability of their and return for the home next door.
Yeah.
Has there been any studies on that or assessments on that?
Through you, Madam Chairman, to the councillor, I'm not aware of any empirical data or studies that have been conducted in that regard. As you are aware, that's a common concern from area residents whenever change is proposed. I can tell you that under the former Hamilton zoning bylaw 6593, daycare centers for a maximum of 25 children are permitted as of right in all residential zones. So the 26 is comparable to that, and had this been brought forward in the city of Hamilton, the former city of Hamilton, the use is permitted automatically for up to 25. So that gives you some guidance as to how the 26 was reached in our discussions with Councillor Powers. So I'm not aware of any studies or any data that would indicate that there's an effect. I mean, daycare centers, as you're aware of, are all over the city. They front onto major roads. They're adjacent to residential properties, and I'm not aware of any
I just wanted to have
any negative impact.
The other one is agreement. So one of the delegates came here and said, as far as they know, there is no formal agreement to date. You're indicating through your presentation that your client is in discussions with the governors of the church.
Right.
There's agreement in principle and will be written up in a way that the director of planning will have it in his hands. Is that correct?
Yeah, through you, Madam Chairman, to the council. That's correct.
The last one is, even with the drop-off being at the church, would Governor's Road still not be the primary form of transportation to get there?
Well, through you, Madam Chairman, to the councillor, I would anticipate that it would be the primary route for going there. Most of the traffic will be bypass traffic as it is from the residential neighborhood further out on Governor's Road. But in terms of accessing and drop-off, they would utilize the church parking lot.
And I guess my last question is the 26, I mean, we started at 41.
Yes.
Brought it down to 26. Because I've seen where they've come back years later and look for expansion, make requests for expansion. Is there an ability for us to build into this process that this is it? It's not going to get expanded?
Yeah, through you, Madam Chairman, to the councillor. No, it's not. It would be you could take some comfort in the fact that any increase proposed down the road would be subject to another public process, either by the Committee of Adjustment or through a further rezoning.
And just to let you know that legal does want to make a comment, but I'll wait until we're finished with Mr. Mallard's presentation. Councillor Clark.
Good morning, Mr. Mallard. With regards to the earlier comments, and I'll probably end up going back to legal, the agreement, we can't make agreements conditional when we're dealing with zoning, but I believe I heard you indicate that the parking is required for the zoning to occur in this subject property.
Yeah.
So the GM for planning would have to understand very clearly that there's an agreement in place for the parking. Now the challenge becomes, as the question was to legal, if something happens and that agreement falls apart and parking is no longer available, then the subject property would no longer be in compliance with the zoning, which would mean closure.
Correct.
Client understands that?
Yes, he does.
Thank you.
Thank you. And Councillor Pasuta, if you can take the chair. I've got the last here. One of the things that I was thinking about when I was reading the letters from the residents, having a business next door to them. Businesses usually mean a nice sign out front, big parking lot. Will this have a sign? Will the sign change? What's going to indicate that there's a daycare on site, if there is one?
Through you, Acting Chair, to the councillor, there's currently a very small lawn sign on the property that identifies the daycare for the private home daycare. There's no provision made for a large sign to be placed there. He's cognizant of the fact that of maintaining the character, the residential streetscape character of the area. So we didn't request any modifications in zoning to throw up a big sign.
Thank you. And my last question is really hinging on Councillor Clark and Councillor Whitehead, and it's about the agreement, because I think you and I both agree that this would not be coming forward if ample parking was not provided. So I can just see this 10 years down the road, whatever happens to the church, they decide to grow, they're going to another property, this now becomes null and void, the parking. So again, we need to give the residents some comfort that there is a provision put into place that if this parking was ever to be null and void, that the business would adapt accordingly. How would that work in your planning expert mind? How would that work when you've got someone going to the press saying they're throwing our babies out? So how do we make this work so that there is a clear understanding and a comfort level for the neighbors that this parking will stay in place, and if in fact it ever becomes null and void, this is what we're prepared to do?
Yeah. Through your, Acting Chair, to the councillor, I do want to refer back to the fact that in terms of the parking requirements under the zoning bylaw for the proposed size of this daycare, day nursery, he meets the parking requirements on site. He can provide what's required by bylaw. It's his operational needs and his identification that Governor's Road is busy, and for the convenience of his clients, he wanted to provide the off-site parking. So he initiated this. It wasn't a condition that was brought up by staff. Staff was aware of his proposal and has made it a requisite of the bylaw by tying the use to the provision of that and maintaining it. So he is fully agreeable with that. It's his intent to carry that out and maintain it, and he understands that without it, he doesn't have the use.
Thank you. And can you please, through you, Chair, can you please refresh my memory? How many parking sites on site? How many parking lot spots are on site right now?
Through the acting chair to the councillor, the building is set back substantially from Governor's Road, so you can park two in the drive. It's a double-wide driveway. You could park two with full maneuvering behind it, and upwards of 4 to 6 stack spaces on site.
So that meets the parking requirement with 5 staff.
Through you, acting chair to the councillor, it meets the parking standard under the new zoning bylaw for day nurseries, and with the reduction in the capacity from 41 to 26, it would meet the old standard under Dundas zoning bylaw as well.
Okay.
My apologies. I thought I had turned it off.
That annoys me.
I should know better.
Yes. Okay, those are my questions for now. Thank you very much. I have some questions for staff. Thank you. Can I have a motion, please? No other questions to receive Mr. Mallard's receive. Thank you. Councillor Farr, Councillor Whitehead, all those in favor?
I would just like to take the opportunity, Madam Chair, to thank Councillor Powers, staff, specifically Steve, Anita, Edward, John, and Tim, and reaching an agreeable solution to the councillors' concerns and what I believe is a solution to the area residents' concerns as well.
Thank you. So now we've got the motion in front of us. Does anyone have any questions besides myself to staff? Councillor Clark.
I want to go back to legal for a second because we had comments on the onset with regards to conditions, with regards to an agreement between 2 third parties, making that conditional on zoning. We can't do under the Planning Act. So what we've now heard is that it's actually zoning requires that in order for them to proceed. They need to maintain that parking structure or that parking agreement if it falls through. My understanding was that they would no longer be in compliance with that zoning bylaw, which would mean that it would be enforced, which means potential closure, if not a significant reduction in the spaces. Can you just comment on that?
Mike?
Through you, Madam Chair, after listening to the submissions and hearing the concerns expressed by council, there's a couple of things I would add to my previous comments. The one thing that that committee could recommend is an inclusion of the city be a party to the agreement. Therefore, the city would have some control in terms of it being rescinded or attempting to get out of it and that. And as a party to the agreement, we could require other terms. One, Madam Chair, you expressed the concern that in the future the daycare could expand. Well, one of the provisions of the agreement could be a requirement that contractually the agreement provides that they cannot expand. And we used this tool recently in another file that you may be familiar with, the Pickles 341 Mountsburg file, where we put in certain restrictions on the use of the property, et cetera, in the settlement agreement that was reached on that matter. Another matter is we could have the agreement registered on title perhaps to both properties, and I would put a caveat on that if possible. The registrar these days in some instances is difficult to get agreements registered, but there is a precedent for that. In the downtown, we allow parking off-site to be provided for developments on the contingent that there be a parking agreement entered into and registered on title, I believe. So there is that precedent that's available for these types of parking arrangements. And you could have further restrictions in the agreement between the parties to contractually bind the daycare that they do not allow a drop-off on Governor's Road, if that's a concern also. So there is an ability to add things to the agreement if the city is a party to it. We then have some control over it. If we're not a party to the agreement, legally that agreement can be changed by the parties without our consent. They could enter into an agreement satisfactory for the zoning on one day, and then the next day they enter an amending agreement that takes away all those terms, and we would have no knowledge of that. By being a party to the agreement and it being to the satisfaction of the legal department that it's consistent with the recommendations, committee can exert some control over that.
Councillor Clark.
So to Mr. Thorne or to Mr. Robichaud, you've heard legal's comments, and you've heard Mr. Mallard's comments with regards to non-compliance, potential non-compliance in the future if the agreement falls apart. How would we handle it if the agreement between the two third parties, without the city being a party to it, because that, in my opinion, does complicate things a little bit for the city. How would we enforce compliance on zoning if the parking is no longer there?
Madam Chairman, to the Ward Councillor, it would be treated as any other zoning regulation. If so, you're required to provide certain performance standards associated with that use. If you're not meeting those performance standards, then you are out of conformity with zoning. So the applicant would have, or the property owner would have two choices, or three choices. One would be to bring the property back into conformity with the zoning bylaw, or alternatively, they could come forward for either a routine rezoning to further amend that regulation here at Planning Committee, or they could apply to the Committee of Adjustment to amend that regulation through a minor variance. And then staff would have to assess the merits of either that minor variance application or that routine rezoning application and make a recommendation. If we felt that we couldn't support those and they were approved, say, through a Committee of Adjustment situation, there would always be the right to appeal it to the Ontario Municipal Board. But it is a zoning regulation, much as the same. You have to provide landscaping, visual barriers, or required parking or loading spot on site. And if you're no longer providing those, meeting those bylaw requirements, you are in contravention of the zoning bylaw. And then the city has the right to take the necessary steps to bring that property back into conformity by working with the property owner.
So then, Madam Chair, just to be clear, it would be no different than some of the landscaping companies that we've been dealing with who were operating in the rural areas without any registration or zoning, and they're either have to come into compliance with the zoning on the land or move their business, or we shut them down.
Through you, Madam Chairman, that would be a similar analogy, yes, that they now have to look to either bring the property into conformity with the zoning bylaw by ceasing the use or amending the planning instruments to permit the use.
Would you care to comment on the suggested options with regards to the city entering into a third-party agreement? Is that necessary?
Through you, Madam Chairman, we have done that in some situations where the agreement has been, the city has been named party to the agreement. As Mr. Kovacevic has indicated, it just, if there's ever an amendment to that agreement, it's just that way the city participates in being notified. It sort of becomes a braces and suspenders kind of thing. It's just an extra level of protection if it's felt that committee or council wanted that protection in terms of going forward and dealing with those issues. The agreement is to be to the director or the general manager's satisfaction, so we will still be negotiating what the terms and conditions of that would be, and what sort of processes we put in place in terms of any notifications for alterations or termination of that agreement. So that will something that still has to be negotiated and signed off before the zoning would take effect to allow for the off-site parking or loading and unloading on the adjacent property.
Councillor Clark.
Regardless, the city still has authority under the zoning regulation to enforce the bylaw.
Through you, Madam Chairman, that is correct. We do have the zoning bylaw and all the remedies available under the zoning bylaw to enforce that and ensure compliance and conformity.
Thank you, Madam Chair.
Thank you. Councillor Pasuta, could you take the chair? I just have a quick question that Mr. Hughes had raised. Because the church is a part of this application, right or wrong, it's an accessory to this application, was 120 meters recognized from the actual property or from both properties? This is the notification question.
Through the chair to the councillor, the notice was given 120 meters from the subject property, so 252 Governors Road. With respect to the church to the rear, under 05-200 in the zoning bylaw, it is zoned I1, which would permit a day nursery as of right.
Okay, so my question through you, Chair, is the 120 meters was recognized from the actual site property. It was not recognized from the church, more, I would assume it's south, right?
Yes, that's correct.
Okay, and that's strictly under the Planning Act?
Correct.
Thank you. Okay, so that was my question. Thank you. I'll take back the chair. You have before you 6.1 as amended. It's on the yellow sheets. So I need a motion right now for 6.1. Councillor Pearson, Councillor Clark, and this is as amended, right? Is that right, Clerk? Thank you. As amended.
So you don't need a motion to approve the amendment?
That's what I'm asking.
So that's a strict delete and replace recommendations. So these will be the new recommendations. So it's simply approved.
6.1 as amended.
Yes.
Thank you. Everyone? All those in favor? Any opposed? Seeing none. Now we're on to 6.2, please. And we've got the proposed bylaw, zoning bylaw amendment affecting lands located at 30 Eleanor Avenue in Ward 7. Members of the public, in accordance with the provisions of the Planning Act, please be advised that if a person or public body does not make oral submissions at a public meeting or make written submissions to the Council of the City of Hamilton before Council approves the zoning bylaw amendments, the person or public body is not entitled to appeal the decision of the Council of the City of Hamilton to the Ontario Municipal Board, and the person or public body may not be added as a party to the hearing of an appeal before the OMB unless, in the opinion of the Board, there are reasonable grounds to do so. Is there anyone here for 30 Eleanor Avenue, Ward 7, going once? Is anyone here for 30 Eleanor Avenue, going twice? And third and final call, is anyone here for 30 Eleanor Avenue, going 3 times? Seeing none from the audience, may I have a motion, please, to close the public meeting? Thank you. Councillors Pearson, Councillors Farr, what is the recommendation of this committee? Do you want to see Mr. Lee again, or do you want to waive the staff presentation? Councillor Whitehead to waive the presentation. Councillor Pearson, all those in favour? Thank you. You have 6.2 in front of you right now. What is the wish of this committee? Move it. Councillor Whitehead, Councillor Pearson, all those in favour? Thank you. So now we're on to 6.3. This is the zoning amendment bylaw for 6593 lands, number 6593 for lands located at 252 and 254 Locke Street in Hamilton, Ward 1. Members, I have to repeat myself, folks, so bear with me. Members of the public, in accordance with the provisions of the Planning Act, please be advised that if a person or public body does not make oral submissions at a public meeting or make written submissions to the Council of the City of Hamilton before Council approves the zoning bylaw amendments, the person or public body is not entitled to appeal the decision of the Council of the City of Hamilton to the Ontario Municipal Board, and the person or public body may not be added as a party to the hearing of an appeal before the OMB unless, in the opinion of the Board, there are reasonable grounds to do so. Is there anyone here to speak, other than the applicant, on 252 or 254 Locke Street? Going once. Is there anyone here to speak to 252, 254 Locke Street? Going twice. And the third and final time, Ward 1, 252 to 254 Locke Street in Ward 7. Yes, sir. So beside the applicant, right. So that's the third and final call now for the public to speak on this issue. Seeing none, may I have a motion, please, to close the public meeting? Councillor Clark, Councillor Ferguson, all those in favour. Thank you. What is the wish of this committee regarding 6.3? Do you want to see the staff presentation? We have the applicant here. Can we ask, I just want to quickly ask the applicant, are you in favour of the staff recommendation? Waiving fees. Come on forward. So is it the staff to hear the applicant first, and then we'll decide whether we need to hear the staff presentation? Waive the presentation. All those in favor? Thank you. So we're, sorry? Presentation. You heard the words presentation, correct? Okay. Sir, can you introduce yourself, please?
Yes, my name is Steve Bernstein. I'm here for the applicant. Good morning, Madam Chair, committee, staff, members of the public. Just very briefly, it was suggested when we were here a number of years ago that perhaps at this stage, if after 3 years everything was good, some consideration to fees being waived for this application. I practice criminal law primarily for a living, so I'm familiar with the concept of probation. So this 3 years we've been on probation, and as far as I'm aware, there hasn't been one single peep or complaint about noise or anything of that nature. I can tell you that Councillor McHattie is also supportive of fees being waived. And this matter has a rather lengthy history because it went originally to the Committee of Adjustments, where it was approved. It was appealed to the OMB. The OMB said it should have been an application to amend the bylaw. We brought the application to amend the bylaw, and then we were given the 3 years, and now here we are today. So it has a bit of a history. The suggestion back then was perhaps they could be waived. Councillor McHattie is supportive of the fees being waived, and I'm making the request today.
And thank you, Mr. Bernstein. I have Councillor Ferguson to ask a question of the presenter.
Yes. What are the fees you're asking to be waived?
The fees, I think it was $10,000 and change, about $10,400 to bring this.
Sorry, through the chair.
Sorry.
The planning fees?
No, it's the fees that were paid to the city as it relates to this application.
Which are the application fees for the planning rezoning?
Yes.
Yeah.
Yes, that's right.
I think you're familiar with the term breach of probation. How the heck can we do it for you and not for everybody else? And
as I say, this was a somewhat, as I understood it 3 years ago, it was something of an unusual finding, and the suggestion back then was something that it should be considered today. And because of the history of this and the fact that the councillor of that ward is recommending it, that's why I'm asking for it.
Thank you, Councillor Ferguson.
That's all my question. I would like to ask staff a question on this.
Thank you. Any other questions for the presenter? Seeing none, thank you, Mr. Bernstein.
Thank you very much.
Motion, please, to receive the presentation. Councillor Ferguson, Councillor Pearson, all those in favour. Thank you. Questions for staff? Mr. Clark. Councillor Clark, and then Councillor Ferguson.
Thank you. So we've heard the request to Mr. Thorne and Mr. Robichaud with regards to what the fees are for. Are they relative to this application, or were they relative to the last application? Can you give us a little bit of history?
Thank you, Mr. Robichaud.
Through you, Madam Chairman, to the committee. The previous application was originally submitted as a routine rezoning to permit an outdoor patio in the rear yard. As a result, staff recommended approval of that application, but in response to concerns from the immediate neighborhood in terms of potential impacts from the patio and if there was ever a change in ownership or how the patio would operate, it was negotiated with the ward councillor and the proponent that the application at that time would be approved as a temporary use bylaw for a period of up to 3 years. And that's why this matter is now back before committee today, because the temporary use bylaw expires in November of this year. So they have submitted an application at this time as a routine rezoning to allow for the outdoor patio as a permanent use on the property. Because of, I think, the change in the processing that happened 3 years ago, one of the suggestions that was raised, or one of the things that was floated out through the discussions between the ward councillor, the neighborhood, and the applicant, was that there could be an opportunity to reduce the fees when they came forward to make the patio permanent. But under the city's fee bylaw, staff do not have the authority to waive or exempt or reduce any of the fees required for an application. As you are aware, the city did a fee review 2 or 3 years ago, and our fees basically reflect the cost to do service based on 75% of the cost for staff to process a development application, do the circulation, and give the notice, and the other 25% represents the public benefit, protecting the public benefit through that evaluation process. So the fee really is 75% of the full staff cost to review, process, and bring forward a development application. And we do not have the authority under the fee bylaw to waive or reduce any of those fees.
Councillor Clark.
And so to be very clear, there were costs to the city with the application 3 years ago, and there's costs to the city this time.
That is correct. The city incurred costs 3 years ago to do the review the application and bring it forward, and there were costs to the city in terms of processing this application and bringing it forward today. And in both times, it was to reflect 75% of the staff costs to deal with those applications, and the other 25% is funded through the general levy.
Thank you.
Thank you, Councillor Ferguson.
Yeah, through you to Steve. Steve, does this mean they paid that planning fees twice, once 3 years ago and once again now?
Through you, Madam Chairman, that is correct, because the original application, they filed it for a routine rezoning, so they paid for those fees, and then it was approved as a temporary use bylaw for 3 years. They've now come forward to make an application to allow to recognize the use permanently, so they paid again a routine rezoning application.
So they would have paid $10,000 3 years ago and another $10,000 now, or 3 years ago the fees were probably $6,000, weren't they?
They would have been in that $5,000 to $6,000. Through you, Madam Chairman, to the Board Council, they would have been in that $5,000 to $6,000 range 3 years ago, and then we did the fee review about 2 or 3 years after the original application was submitted, and we did do the increase in fees. I think what the applicant also indicated, they did initially start this as a minor variance process, so they paid $1,000 for a minor variance. That got appealed to the Ontario Municipal Board. They were approved by the committee, denied at the Ontario Municipal Board. Then they came back in and did a routine rezoning, so they paid $5,000 or $6,000 3 years ago. That got approved as a temporary use bylaw, and then today they came forward and they had to pay another $10,000 in order to allow for the patio on a permanent basis. So they're at what, 10, 5, they're about $16,000, $17,000 in total planning fees they paid to date. Plus at that time, they had planning consultants as well to assist them with the original applications.
Okay, my 8 years
Ferguson?
in this committee, I don't remember giving a temporary use and then having to come back and get a permanent use. Is this an anomaly that we haven't seen before?
Through you, Madam
Steve?
Chairman, we don't normally do temporary use bylaws. They're sort of an exception to the rule in terms of why someone's coming forward with a temporary use. It's either for a surface parking lot traditionally. In this case, it was done as a negotiated settlement because the residents were very concerned about the patio being especially in the rear yard and the potential, there was concerns if the ownership changed, what would happen if it became, a less than desirable type operation. So in order to allow it to sort of as a test period, that's why it was agreed to do it as a temporary use basis for 3 years. But it's pretty much the exception to the rule that we come forward with temporary use bylaw provisions.
As the Director of Planning, what would your recommendation be to the committee on the fee issue?
In terms of the fee, well, I understand where the applicant is coming for. We do have to, it is a fee for service. We do have costs. It does, if we start doing this, then where do we draw the line? In terms of the fee rebate, it would come out of sort of the fees that the department collects, and those fees are designed to offset this cost to deliver all of the planning services. So we do not normally encourage or support waiving or reducing fees for development applications.
And
Councillor?
And just get through you, Madam Chairman. So because I've never seen this before, and it sounds like you haven't seen it, so you're suggesting we still stay with the full fees even though they had to apply twice for the same thing?
Through you, Madam Chairman, that is correct. The other option is applicants, there is a lower fee if they want to do an extension of a temporary use bylaw, because they keep coming forward every 3 years to extend it.
I don't think that would be of interest.
Cumulatively, you'd be right up to a routine rezoning. And that is one of the reasons why we do have the routine rezoning, because it is, a complex rezoning, that fee is closer to $20,000, where the routine rezoning is for these more straightforward, simpler type applications. And that's why we charge the $10,000, but like I said, it does reflect the cost to the city to deliver that planning service. So if the fee is rebated here, then that $10,000 would then come out of a levy contribution to offset those costs.
Yeah, I understand that. Through you, Madam Chairman, two more quick questions. Has the ward councillor spoken to you about this? He hasn't spoken to me about it. I don't know about other members of the committee, but has the ward councillor made a suggestion to you that we should waive the fees?
Through you, Madam Chairman, the ward councillor asked the question, and I responded that under the city's fee bylaw, planning staff do not have the authority to waive the fee, and if the fee was to be either waived or refunded, then it would take a motion of council to direct staff to issue a fee refund to the applicant.
Okay, would it make sense to you, or it doesn't sound like it does, but would it make sense to you that we reduce the fee to what they would have paid in the original application, which is in the order of $6,000?
If the committee feels that that's a fair compromise, then that would, it seems, they did pay once already, and staff had supported the initial application, so, that wouldn't be opposed if the committee wanted to give them a partial fee rebate based on the 2007 or 2008 fee schedule that was in effect at the time of the original application.
Okay, Madam Chairman, $10,000 is, you have to sell a lot of beer to do that, but I'll see what the rest of my colleagues have to say about this.
And you're the last speaker. Anyone else would like to speak on this issue, please? Councillor Farr.
Yeah, I followed this one closely, even visited the restaurant.
On-site visit.
On-site as we debated this one and spoke with the owner and also spoke with some of the neighbors and one appellant I've spoke with since. It has been a while with this temporary use bylaw. It is fairly rare, and I would suggest it's a success. I recall, and I think committee will recall, it was a while ago, but the debate was we were worried about a rowdy pub causing disturbances with the neighbors. And the argument from the owner was, no, it's good, fine wine as you dine and a casual atmosphere. And certainly in the last 3 years through this temporary use bylaw has proven to have followed through on exactly what he suggested, or close enough anyway, to our committee 3 years ago. And so we're past that point of the temporary use bylaw. So I like where Councillor Ferguson is going. I was going to ask the same questions of staff, so I don't have any questions, but I would be happy to second a compromise on the fees, not a full reduction. Given this anomaly, really, that's before us, we don't want to find ourselves in a position, or the councillors that are on planning committee in the next term, where we're dickering costs associated to planning fees more than we're debating good developments and so on and so forth that move the city forward. But I think in this case we can make a strong argument to offer some form of reduction, or look at the price point 3 years ago, maybe get some support and help out in that fashion. I'd be happy to second that motion if Councillor Ferguson moves it.
Councillor Pearson.
Madam Chairman, yes, thank you. And, you know, I'm going to listen to the conversation around the table. I'm sort of leaning that way. I just would have preferred that the ward councillor was here, possibly maybe bring a motion to council that we can address as understanding the scope of where he's at on this as well. But my next concern, and never mind where this goes, but I really believe that staff, we have to look at this going forward, because I'm afraid that this now will set precedent on people coming forward for temporary use permits and then come back again 3 years later, and now we're in the same situation. We did temporary use, I think just one in Stony Creek. I don't recall that a full fee had to be paid again. It was a golf course, a driving range, if I remember correctly, in Stony Creek days, where we gave a 3-year temporary, and then we gave another extension, and I don't believe the fees were that high in those days. So I really think that staff need to put this on their outstanding business list as far as coming back in the new term for the new committee and council to address how we deal with these going forward. There has to be a proper protocol on fees, because the door is now open, and people will come back. So I need to be sure that staff are aware of this and come back with policy. Thank you.
Councillor Clark, second time.
Thank you very much. Given that we don't really have the actual history in terms of what the fee was, we're kind of punting in terms of where it was. We could approve the application that's here and then have an amendment at council with the exact fee. And then actually Councillor McCaddy could move that motion, being the ward councillor. He could speak to it at that time, so we would get everything at council. So I think that would be my recommendation. Let's approve what we have, and let's get the history, and then have the ward council move that, and Councillor Farr or Councillor Ferguson could second it at council, and then we actually have the real numbers before us as opposed to guesses, and not comfortable with guesses.
Thank you. And I'm going to go back to the mover of the proposed motion. Do you want to hold back then and wait for council and let the ward councillor come forward with A or nay?
I think I heard, Madam Chairman, that the ward councillor would like to see them reduce 100%. I'm not on for that, so I'm going to just test an amendment that the fees be reduced to $6,000 for this application, and I think Councillor Farr wants to second that. But I think through you, Madam Chairman, to staff, just Steve, $6,000 is as close as Dan is to swearing to what the fees would have been 3 years ago.
Madam Chairman, we can have the fee numbers probably within the next hour, between the difference what was paid in 2011 and the current fee application. So if we just want to have a placeholder for that number, we can provide that to committee today.
We can approve this now and wait an hour for the fees to come in, and then we can come back and amend 6.3 if we need be.
Or I could simply say the same fee they paid in 3 years ago.
Okay, so is that going to be your motion then? Whatever they were to pay 3 years ago would be what they're paying today. Okay, and you're willing to second that? Okay.
That the fees be reduced to the application fees that were paid on the initial application 3 years ago.
Thank you. And that is the motion put forward, please. All those in favor? Any opposed? Thank you. Now I need to look at 6.3 as amended, please. Thank you, Councillor Clark. Councillor Pearson, all those in favour? Thank you. So now we're on to 6.4. This is an application for amendment to the Town of Flamborough zoning bylaw 90-145-Z for the lands located at 1605 Kirkwall Road. Members of the public, in accordance with the provisions of the Planning Act, please be advised that if a person or public body does not make oral submissions at a public meeting or make written submissions to the Council of the City of Hamilton before Council approves the zoning bylaw amendments, the person or public body is not entitled to appeal the decision of the Council of the City of Hamilton to the Ontario Municipal Board, and the person or public body may not be added as a party to the hearing of an appeal before the OMB unless, in the opinion of the Board, there are reasonable grounds to do so. Just straw vote, please. Anyone here to speak to 1605 Kirkwall Road in Flamborough? Going once? Anyone here to speak for lands located at 1605 Kirkwall Road, going twice? And third? I'm sorry? Yes, I'm sorry, I should say that. Anyone here other than the applicant here to speak for 1605 Kirkwall Road, going 3 times in Flamborough? All those in favour for closing off the, motion to close it off. Councillor Whitehead, Councillor Ferguson, all those in favour? Thank you. So what is the wish of this committee for? Waive the presentation for the staff report, please. And Councillor Pasuta, are you all right with this? This is your ward. Councillor Pasuta, Councillor Whitehead, all those in favour? Applicant, you're in agreement with the, she's nodding her head yes for the public records, that she's in agreement with the staff recommendation. So you have before you 6.4. What is the wish of this committee, please? Councillor Pasuta is moving it. Councillor Ferguson is seconding it. All those in favour? Thank you. We're moving on to 6.5. This is the proposed zoning bylaw amendment affecting lands located at 1292 Old Highway number 8. Again, Councillor Pasuta's ward in 14. Members of the public, accordance with the provisions of the Planning Act, please be advised that if a person or public body does not make an oral submission to a public meeting or make written submissions to the Council of the City of Hamilton before Council approves the zoning bylaw amendments, the person or public body is not entitled to appeal the decision of the Council of the City of Hamilton to the Ontario Municipal Board, and the person or public body may not be added as a party to the hearing of the appeal before the OMB unless, in the opinion of the Board, there are reasonable grounds to do so. So I'm going to do this again. 1292 Old Highway 8 in Flamborough. Is there anyone here from the public other than the applicant here to speak on that issue? Going once. 1292 Old Highway 8 in Flamborough. Anyone here to speak to this issue? Going twice. And third and final call. Anyone here to speak to 1292 Old Highway number 8 in Flamborough, Ward 14? Gone. I need a motion, please, to close the public meeting. Councillor Pasuta, Councillor Pearson, all those in favour? Thank you. What is the wish of the committee for the staff presentation? Move it from Councillor Pearson. Councillor Ferguson, all those in favour? Is the applicant here for 129? Mr. Webb, are you okay with everything that's in front of us today? Full agreement with the recommendation by staff for 6.5. Thank you very much. So what is the wish of this committee? Councillor Pasuta, I'll go to you. Are you willing to move this? Moving. Councillor Pasuta, seconded by Councillor Ferguson. All those in favour? Thank you. Sorry, oh, I apologize. We have 3 pieces of correspondence. I need a motion, please, to receive all 3. Councillor Pasuta, Councillor Pearson, all those in favour. Thank you. So now we're on to 6.6. This is 2791 King Street East in Ward 5. Members of the public, in accordance with the provisions of the Planning Act, please be advised that if a person or public body does not make oral submissions at a public meeting or make written submissions to the Council of the City of Hamilton before Council approves the zoning bylaw amendments, the person or public body is not entitled to appeal the decision of the Council of the City of Hamilton to the Ontario Municipal Board, and the person and public body or public body may not be added as a party to the hearing of an appeal before the Ontario Municipal Board unless, in the opinion of the Board, there are grounds to do so. As I said earlier today, that Councillor Collins has got an appointment this morning as urgent, so he will be here at noon. What is the wish of the committee? Do you want to refer this, or do you want to deal with this now? Councillor Ferguson.
I think it'd be appropriate just to table this until Chad arrives. It is his ward. I understand there's some issues around it.
I just want to get a straw vote. Is there anyone here to speak on that issue?
Yeah.
Are you the applicant, sir? Yes. You're the applicant. Anyone else here? we're just going to hold off for your counselor to come. So if you're okay with that, please relax. Let us know if you need money for the meter. So we're going to go right to 8.1.
Now, where are you going to get that money from?
Well, Councillor Ferguson, I heard him jingling coming in, so he's got tons of cash on him. So we're going to skip over 6.6, please. We're going to go to 8.1, right? 8.1, Hamilton Gateway Marquee Partnership, Ward 4 with citywide implications. I will ask Brian McDonald and Brian Voodoo. Am I saying that right? He's not here, but Brian McDonald is? Okay, super. To speak to this item on behalf of Coralie Secor, this item is related to item 8.2. And just for interest, we also have Glenn Gibson and Jeremy Kramer who wish to speak at this time as well. I don't think they expected us to be in the 8 section so quickly. Councillor Clark?
So we're going to deal with 8.1 and 8.2?
I'm not seeing that on my roadmap. I'm seeing that we deal with 8.2 afterwards. Yes, Vanessa?
Yeah, we'll just do them in order. They're just related to the same topic, so it's beneficial to hear 8.1 before making a decision on 8.2.
So 8.1 is detriment to 8.2 then?
Okay, I thought we dealt with that at GIC, though.
I'm sorry?
I thought we dealt with this matter at GIC.
So it should be quick here.
Mr. Robichaud, can you please, where'd he go? This is Danielle Stevens. She's now Danielle Beck. So I have to get that in my head. So, good morning.
Through the chair to the councillor, at GIC you dealt with the use agreement between the City of Hamilton and the Ticats sign. Today what's before you is the sign variance for that sign again. So similar issues, but different approval of processes.
Yeah. So the council has the authority to waive the variance, so we can clearly approve the variance. The outstanding issue is with the Ministry of Transportation, which is their permission, and the council has the authority to write to, or through the mayor's office, deal with the minister, and the minister has the authority and the discretion to exempt it from provincial law. So we can expedite it relatively quickly if we just add that clause that we write to the minister and request the minister's assistance and support on the application. It's at his discretion.
Are you speaking to the staff or are you speaking to your colleagues? Both. Microphone, please. Sorry.
Sorry. I'm just speaking to both. If we can expedite it instead of going through presentations, really the outstanding issue is the variance. The GIC has already made their decision. I understand staff's position on it. The outstanding issue really is the ministry's position, and the ministry's permission is required for it to go forward, and the minister has that discretion to deal with issues like this. So it's really a question of us writing to them.
So is that it in a nutshell, Danielle? We're waiting for the ministry to say yes? Is that what we need to do right now, is ask for the minister's permission?
Through you, Madam Chair, to the councillor, yes, they still are required to go through and get approval from the MTO for the permit. If it is the committee's decision, that can be worked into their decision that a written notice is given to them recommending their support as well too. But staff's position is clearly stated in our report that we do not support it.
And I'm just to be clear, trying to expedite it because I know timing is of an issue with regards to the sign. The ministry staff are not going to change their position. Let's be clear, the ministry staff, this is a regulation. They will always stick to that regulation. So we have to go through the process of supporting the application to the ministry staff and still write to the minister to get that support from the minister. So you can shortcut that process quickly if you deal with it up front. That's all I'm saying.
Thank you. Councillor Ferguson?
I was going to ask the very same question. I know we dealt with this at GIC and it got approved unanimously, so we should be able to move 8.1 and 8.2 through pretty quickly. But so I've heard the staff presentation. Now I know the President Tiger Cats would like to speak to us also. I suspect it's about this, so I think we need to listen to him now and just confirm we're on the same page.
Did you want to say?
Yeah. Sir, I've received a number of emails, so I'm certainly very supportive of what we've done to date on the leasing and on the and even the variance. I guess my bit of concern is that we make the best decisions based on what impacts the community. When it comes to road and safety in regards to the highways, that's MTO's responsibility. Right. I just don't, I'm a little bit leery about us now getting involved on the safety and health issues of the highway. So I want to make sure those are two separate issues. MTO, they have to make their decisions based on whatever they make their decisions and providing the permit. We make our decisions based on what's in the best interest of the community, which we are. I just don't know if we want to get into dealing with a regulatory body that's responsible for the safety and health of the thousands of people on the
Okay, so I think right now we're deciding whether or not to listen to the presentation. So I'm hearing from one yes, one we don't need to. Councillor Clark, back to you.
I'm fine with hearing the presentation for the Tiger Cats. I can tell you that Niagara Region made the same application for the Niagara Gateway, which was a giant sign right on the QEW. I was the minister at the time. We made the changes, and it was done through the discretion of the minister's office. So this is completely permissible.
Okay, so what's the wish of this committee? Do we want to hear the staff presentation? From the Ticats. We don't need to have the staff presentation. Okay, so the staff's off the hook. So we need a waive. Do I need to waive the staff presentation? This is not a public meeting, so we're good, right? Okay, thank you. So Mr. and Mrs. Ticat are coming down.
Thank you very much,
The public record, sir, and I know everybody around the table knows you, but we'd really appreciate if you could introduce yourselves, please.
Thank you. It's Glenn Gibson. I'm the president of the Hamilton Tiger Cats, and with me is Jeremy Kramer, the principal of KDI Designs.
Glenn, can you move the microphone just a little closer to you?
On? There we go. Is that better?
Thank you.
Thank you for the opportunity to speak today. I'm not going to be long-winded, and I won't go over things that have already been covered at GIC. I think this is a very unique situation. So, through Councillor Clark's expertise with the provincial government, he probably more than anyone knows what has to go into the next step after we get hopefully through today. So it's very unique in the sense that we're a partner of the City of Hamilton. And I think what's lost a little bit, and it didn't really come out in the GIC, but I'm going to make the point because, the economic impact of what we're doing with the Tiger Cats as a business, it's 500 or 600 jobs that are created down at the precinct. And those are jobs that are largely for a segment of our population that are young and disadvantaged a bit, and they need employment. And I think hasn't been highlighted enough probably in what's gone on up to now. I also think when I look at the expenses of the team and I look at where we're spending money and the vendors in the city and some of the local people that are participating in the rebirth of the stadium, I think that's a little bit lost in the economic side of things. So I just want to make those points. And with that, I'm just going to sort of lead into the real purpose today, which was to introduce Jeremy. Much like Ken Austin when he's looking to have a good team in place, I use the saying a lot, it's first who, then what. And you have to have the right people that are involved to make things happen right. And so 3 years ago, the Tiger Cats and through Matt Afnick, his leadership, we engaged Jeremy. And Jeremy is, I don't know if it's up there yet on the screen, but Jeremy is a world-class sign expert, and he's got over 25 years experience on an international stage. And some of the things that Jeremy has been involved in include the Celebration Square in Mississauga, the Toronto Eaton Centre Media Tower, the Sony Centre for Performing Arts, recent projects in Qatar and Saudi Arabia. So he's the man. He's got a lot of experience, and so on the technical side, we are going to bring him forward, and I think he'll be fairly brief, but perhaps open up the door for any specific questions about the actual sign itself and the design. Thank you very much, Jeremy.
Thank you for that introduction. As Glenn mentioned, I've been involved in the identification of major public facilities for now 25 years. And in fact, one of the initial projects I worked on at the start of my career was doing all of the identification and signage with my firm for Copps Coliseum. So we have some history, of course, with the city of Hamilton. And I think one of the things that's extremely important that I'd like to mention with a project like this is that it's not just about identification of Tim Hortons Field, it's about creating a presence for the facility, for the city, for events happening in and around Hamilton, so that the energy and excitement that we all have today is not forgotten. There's a very old adage, which is out of sight is out of mind. This facility does not have a physical presence to a major arterial. So part of the importance of this particular sign is actually to let people constantly be reminded that we have a terrific facility in Hamilton, that there's a variety of events going on, both sports and other, and that it is also a vehicle for the city to promote citywide major initiatives. So the reason we envision this as a gateway is we see it as much more than simply identification of Tim Hortons Field. The gateway structure has really been designed to make a strong public presentation. We've done similar projects like BMO Field in Toronto, where it's about creating a landmark that people recognize and identify, and it becomes a visual cue as well. The use of technology, it's consistent with best practice North America-wide. I don't think anyone is planning a world-class facility today that does not include using technology as a way to communicate its message and its content. And the proposed gateway structure uses tools that will allow you to do that in the most professional way. Some examples of projects that we've been involved in and a few other examples. City of Mississauga, Celebration Square, which has a gateway feature. City of Toronto, CN Tower, which we completed last year. And it's interesting. Tallest tower in the country. But from many points in the city, you actually can't see the tower. And after 35 years, they recognized that they needed to do a major gateway sign so that people could recognize where it was when you were in the downtown. City of Niagara Falls, the Falls View Resort, we were involved in all of the planning as well as this major digital piece. BMO Field, and now we're doing a similar project for the city of Brampton. And of course, we're also showing here LA Live in Los Angeles. And I think the point I make by showing these precedent examples is simply to say that I think in one way or another, the constant with all facilities of this scale and caliber is the need to communicate a message in a way that's clear, that people can understand what's on, what's coming, and keep providing a reason for the success and vitality of the facility. So key objectives, we see this as a gateway for the city, as well as for Tim Hortons Field and the Ticats, raise the profile of Tim Hortons Field and the city so that people are fully aware of events, what's on. Communicate a sense of excitement, really have this be a strong marketing piece so that, again, this has a lot to do with the vitality, attendance, and ongoing success of a facility. And then the integration of programmable static technology. And I want to emphasize static because one of the things, there are two types of LED technology. One is what's called full motion. What we're proposing here is static. So there has been numerous studies throughout North America related to this, and it has been proven that static technology proves no risk to traffic safety. The colors and finishes of the structure have been designed to both reinforce the branding of the city as well as the Ticats, and special effort has been put into the form of the structure to make it something truly unique, truly iconic. And the quality of the technology has been designed so that the way in which images are presented is with the best possible quality. This is just simply showing the location, and the setback conforms with all restrictions, with the exception of we understand that we will need to seek additional MTO approvals. This is the look of the sign itself. So it will have the ability to promote content at the Tim Hortons field, as well as information about current events and upcoming, as well as branding for the city and the team. And an example of how it would have the ability on occasions to promote wider citywide initiatives. And a view of it from the road in both directions. I think that's...
Thank you, Jeremy. I have some questions for you, if you don't mind,
yes,
and
absolutely.
also for Glenn. So we have Councillor Farr, Councillor Ferguson, Councillor Pearson.
I'm glad we hit on, through you, Chair, the technology. And I remember a debate not long ago, about a year ago, I guess, here in this committee, and we were talking to, I think it was Pattison who came before us, and they had a proposal which was unique. We hadn't seen it before, talking about removing, I think it was 3 to 5 static billboards on our city streets above restaurants and buildings and so forth. We'll take 5 if you let us replace it with this new type of technology. And it was a good debate, and I've since looked into it further, and this truly is, through you, you can confirm today a non-invasive. You mentioned studies that prove this is no risk to traffic, yes, and it's a non-invasive sort of technology. In fact, could you speak to, through you, Chair, the fact that even these static billboards with light shining on them could be considered even more of a challenge for some, or more of a distraction than what you're proposing here today, through you?
Absolutely. In fact, I recently participated with the City of Toronto Transportation, Urban Planning and Public Space to review future guidelines and existing guidelines for LED technology. And one of the differences that technology today has the ability to have its light source controlled and even timed, so that you have the ability to dim it past a certain point at night without compromising the quality of the image. The fact is, traditional historical signs were floodlit with incandescent light that has no dimmable quality to it, and it has enormous light leak to it. So I think what has emerged is now the ability to control what they call the nits, or the brightness of the LED, to create something that is more compatible with an urban environment.
I'm hoping our friends at Global Spectrum, who now manage the first Ontario Centre in honor of Victor K. Copps, so Copps is still in the name, as you probably know. One of your first gigs was here in Hamilton, as you mentioned. Meet with you soon and bring in the new technology, because I think the world doesn't sell those little red light bulbs anymore, and it's still standing today. Thank you. For Glenn, a quick question to our president of the Tiger Cats. I thought about this when we discussed this, and thank you for spending the day at GIC. You didn't have an opportunity to speak then. You do obviously today, as was recommended, this come to planning. What happens, knowing that the Tiger Cats, your organization, is covering all of the costs, the installation, we're basically giving you this little spot of land. The rest is up to you as per the MOU. What happens if we decide in the 20-year agreement that to change our branding on the, I know we can always work with you to change our message for the percentage of time that we get to promote our city, but if that permanent logo, City of Hamilton, somewhere down the line we decide to go in a different direction, it's part of a debate, I'm not suggesting that it is or being planned for debate, but if we decide to go in a different way in branding our city, and there needs to be some fix to that logo, would that be something that you have already considered in terms of working with us and changing that permanent fixture or brand right under your Tiger Cap brand through you?
One thing I could probably say is our brand's not going to change.
I know that.
But I take your point. I mean, it's everyone likes to refresh things over time. I think our intention is to, leave the situation cost neutral for the city. But you're our partner in what's going on here. So somewhere down the road, I would think if there's a change in brand, then we'd be open for discussion on that. I couldn't commit today that if you change your brand 3 times in the next 20 years that we're going to pay the cost of going up. And I don't even know, frankly, what the cost might be. It might not be very high to change the actual brand on the sign. So I really can't give you a definitive answer today.
Okay.
Councillor?
I think that's all I have for now, and I thank both delegates for coming.
I got Councillor Ferguson, Pearson, and Whitehead. Councillor Ferguson.
A few questions, and I don't know which one of you would like to answer these, but probably the sign expert. You mentioned in your presentation that the noise is going to be the sound of intensifying shoulder pads hitting. Are you going to have noise penetrating from the sign? I didn't understand that bullet point.
It was really a reference to the form of the sign. If I
go back to that slide, because you talk about noise.
If I kind of refer you to the sort of front leading edge or nose of the sign, the inspiration of that form was based on the safety defensive uniform of team equipment. So that it was not really referencing sound so much as to say that was the inspiration of the physical appearance of the sign.
Can you go back to that bullet point then? The distinctive noise. Oh, no.
It's the nose. It's the nose.
Oh.
Nose.
That's like
okay, next.
Okay.
We got you back.
The other question I have, you're an expert in signs. You build big signs all over the place.
We do.
The migrating birds, how do you avoid them from flying into your signs?
There are a number of possibilities, but I will tell you that the birds generally do not like to be by the LED technology. They tend to choose locations that are, that do not have the illumination and the kind of and the warmth that the sign itself generates. So there are sound devices that you can put on the tops of these types of signs to keep birds away, but we have not found that to be an issue in any of our installations.
Okay, so you feel comfortable through you, Madam Chairman, that you'll be able to satisfy the Conservation Authority on migrating birds and the issues around this?
Yes.
Okay. And I'm not much of a sign guy, but what's the difference between a static sign, and there was another one you referenced. It sounds like it's more of an animated sign, the other one?
Yeah. Yes.
So it'll just hold a picture there, and you'll be able to change the pictures, but it won't be dancing across the sign.
A simple comparison would be when you're watching your TV, you have full motion. When you're watching a static digital sign, it is the equivalent of a PowerPoint presentation. It's a static image, and it changes to another static image.
Councillor?
Okay, and I'd have some comments on this at the right time.
About the noise? Fine.
No, on the sign issue. When you're ready, put me on the list on the about the noise.
He's never going to live this one down. Councillor Pearson?
She ate her Wheaties today.
Oh, yeah.
Thank you, gentlemen. Thank you for the presentation. I guess my question, if you go back to, I just want to get an absolute bearing of where this sign is going to be. I notice it's 2 sides. It's going to be visible from the east and the west?
Yes.
Correct?
That's correct.
So this is on...
Let me just...
I'll let you get a picture.
So it's designed as a kind of narrow V-shaped structure so that it would provide both east and west views.
Just around the bend as you come off the, going onto the Red Hill Creek entrance to Red
Yes.
Hill Creek, correct? And at the QEW. So it's not that far away. Is it that far away from the globe, from our globe? Water, it's near there. So in comparison size-wise, it's not going to detract from that at all. So you'll have independent visibility?
Absolutely.
Okay. And what else was I going to say? So and from the bridge, from the Red Hill Bridge, you're obviously quite a ways away.
That's correct.
Okay. Thank you, Madam Chair.
Thank you. And last speaker, Councillor Whitehead.
Madam Chair, in fact, Williams Jury, this committee was gracious enough to support me in a push for the new technology on Upper James, although they haven't put it up yet. And then I know that Councillor Farr and I, again, being consistent with supporting of these type of signs, when Patterson came in, pushed to actually have our sign bylaw amended to enable this. So I'm being very consistent on this path. And I remember there's people around this table that argued against it. And in fact, I actually took it upon myself, as opposed to putting our overworked staff. My staff, we're looking at other jurisdictions to see how they're addressing this new technology. And what we found is a bit patchwork. It's still new, and people are, some municipalities are moving forward on it, other municipalities are still in a wait mode. But certainly I hope that we adopt the fact that this is not bad technology and is safe. So my question to you is, you've done the science, you understand the impacts. Some of the pushback I've received from the community is, aren't we concerned about the health and safety of those on the Queen Elizabeth Way? We understand the MTO staff are concerned about it. Is it just that they haven't caught up with the latest empirical data, or can you help me understand what the issue is?
I think, no, it's a very good question. I think many of the applications that existed in the past related to this technology were requesting full motion. In more recent years, I think many municipalities who have done their homework have discovered that the appropriate solution for our main arterials is to have static technology with some controls on light levels. And I think beyond that, understanding that the quality of the resolution has some impact on safety as well. So we are certainly taking all of those learnings related to best practice in the recommendation that's been put forward.
So is it just a matter of the MTO not having the empirical data at this point, or I'm just trying to understand how they would see this as a concern when there's overwhelming information to suggest that this shouldn't be an issue?
I think the issue for MTO is that they want to address these on a case-by-case basis to be able to make informed decisions. They certainly have approved static digital signs in other locations adjacent to MTO highways, and I think the variance process for them is a way to have control and be able to make informed decisions on a case-by-case.
Question for Glenn. The position I put forward is I'm obviously fully supportive. I've been consistently supportive for these digital still approach for signage and utilizing the latest in technology. And we're doing all we can with the variances and that to support the Tiger Cats and the city, quite frankly, in this approach. I guess the piece I'm having a challenge with is, should we be, I don't mind expediting a decision through a letter to the minister. I just don't know if I'm comfortable trying to influence an outcome of their own processes relative to making the decision on this particular permit. So I'm just looking for any comment that you can provide on that.
Well, I think it's this is a three-step process for us. So subject to receiving approval today, we would go to the MTO. We would, you're our partners, we would seek advice from people at council on how best to approach this, because we all mutually benefit in a favorable outcome of Queen's Park. So I think that's kind of where my mind's at, is sort of one step at a time. The other thing I would just sort of add in is that when you talked about technology, and I just wanted to kind of get it in, is that when you look at what's evolving in the city here with the Innovation Park, you look at the technology hubs that are happening, you look at the presentation the other day by Mike Marini with the young professionals and what we're seeing at the stadium with the SME sector and what's emerging. You know, it's important for us to have leading edge technology outbound so that people going by realize we're a current happening forward thinking city.
Speaking to the converted on the technology. Thank you.
Thank you.
Thank you, Councillor Clark.
So the ministry's concern is really location, that distance from the highway. Is that not correct?
One of the variances that they would have to make a site-specific exception to is that the standard within their conditions is that a variance is required for any sign within 400 meters of an MTO highway, whether it's a traditional sign or a technology-based sign. That same variance would be required.
Add me to the comment list, please.
Thank you. And Councillor Pearson for the second time. Okay, we're going to comments. Thank you very much. Can I have a motion, please, to receive the presentation from both Mr. Gibson and Mr. Kramer? So move, Councillor Collins and Councillor Pearson. All those in favour? Thank you. So we're going back now to the list for comments. And we've got Councillor Pearson, then Councillor Clark, please.
Thank you, Madam Chairman, and certainly thank you to the presenters and the clarification to my questions. I appreciate that. Going forward, I do recall that I had a sign issue in Ward 10 probably within the last year. Actually, in February it was approved, and it was a similar issue where it was a large sign similar to this that was being requested by a business owner for an industrial complex on the south side of the QEW on the South Service Road, probably closer than this sign is going to be. Approval was finally reached. As a matter of fact, ministry approval was given before we gave approval. So I'm really surprised that the ministry's taken this position, but I understand that they need to do site-specific reviews on every application. But I have no problem following or moving forward with this and allowing approval of it. I think, our sign bylaw is a good bylaw. We may need to tweak it more. The new term of council may want to look at that. I hate to say it because I think I was chair of committee twice now in dealing with the sign bylaw. But, we have to recognize the need to be able to have businesses have their visibility in the community. This is technology. We have to move forward and not backward. So, Madam Chair, I will support this going forward. Thank you.
Thank you, Councillor Clark.
Thank you very much. Ministry of Transportation has numerous studies, as was indicated here, that talks about the motion side of these signs and the distraction from those motion signs. I've spoken before at this council with regards to having those, they're pretty much large TV stations along the highway, and there is a significant risk of additional accidents from that type of sign. They also have studies that show, as Councillor Whitehead indicated, a static sign has the contrary effect. It really doesn't draw the eye away, much like billboards. I know a lot of people spend a lot of money on billboards, but when you're driving down the road, the driver doesn't tend to see the billboard, the passengers tend to see the billboard. So in this particular case, I can tell you from history that the minister specifically does have the discretion to make these decisions when there's a challenge. I can tell you from history that municipalities frequently support applications for third-party signs along major highways. Niagara region is the most recent one in my memory in this area specifically, and that was that large Niagara Gateway. You see it on the south side of the QEW heading towards Niagara Falls in and around the Grimsby area. And there was in the end, there was a negotiation that occurred between the minister's office and the chair of the region of Niagara, and they were able to come up with something that both parties could live with. So I think it's appropriate that the city indicate that they support the application to the ministry staff. It's no different than other cities have done. Whether we do it today or later, we can clearly indicate that if The ministry still maintains their position that the city would support the appeal to the minister. It is important for the public to understand that it's not just the city of Hamilton that invested in the Tiger Cat Stadium, but it's the province also. They put up a lot of money to that stadium, and they consider themselves, as I recall, when they made that significant announcement, Minister Angelidis was the minister at the time, that they were full partners in this going forward. That means a great deal when you're dealing with the minister and with the cabinet on these types of exemptions. So I support what's going forward. I know that there is the way to do it. It's just a question of following the process and making the applications, the city supporting it, and then proceeding if there is a decision that goes against it. Thank you.
Thank you. And I've got Councillor Farr, Councillor Collins, and then Councillor Whitehead, please. And just to keep track, everyone, 8.1 is to be received, 8.2 is to be approved, and that's for the variance on 8.2, or not approved. Thank you. Councillor Farr.
Yes, Madam Chair, what we're doing here today is simply cooperating as per the MOU that we signed with the Hamilton Tiger Cats some months ago, as it relates to our Tim Hortons field, formerly Aberwin Stadium, and to the greater extent, of course, the Pan Am precinct, where we're making a tremendous investment on behalf of the taxpayers of Hamilton in creating something very special and unique in many ways in a community that deserves it, no doubt about it. Just very briefly on the technology, and I think we talked about this in Planning Committee the last time we were debating, LED and digital. And I certainly mentioned, having done my research, that it has changed significantly and that you could have more of a visual distraction from a static billboard that we see all over the city now than what we are capable of doing with the technology, with dimming lights at certain times of day or night, significantly to have that and at your fingertips in some computer in some office many kilometers away. It's a lot different now than it was, and the changes continue to occur, and they are significant, and they've been significant since we signed off on it. Well, the former term of council signed off, but not too long ago on our comprehensive sign bylaw. So our first speaker commented on maybe looking at this again. I remember when I had taken Marty Hazel aside and suggested same. He rolled his eyes because that was a great deal of work. I wasn't here, but I have heard about those lengthy meetings, and it was a comprehensive bylaw, but certainly something that was needed at the time. But even since that time, 5 or 6 years, technology has evolved where we don't have to concern ourselves as it relates to that distraction. And in this case, you're not looking at moving pictures. You're essentially looking at a billboard, just one that ever changes. And I think the key point for me as well, it's important for, of course, the Tiger Cats and Tim Hortons to promote themselves, Madam Chair, but it's also important for the city of Hamilton to promote ourselves. And we have a wonderful opportunity to do so in front of an average of 150,000 people each and every day coming in both directions along this section of our megalopolis. Thank you for the time, and I support what's here.
Councillor Collins.
Yep. Thanks, Madam Chairman, and my apologies for being late. I had to attend my all candidates debate on Cable 14, so it's certainly something I couldn't miss. So I apologize for missing the presentation and the comments that were made earlier. But Councillor Marula and I have had the opportunity to meet several times with the Tiger Cats and parties associated with the application that's in front of us, and we've had a lot of questions, and all of those questions have been answered. And I think when the concept was first proposed, we had some red flags go up because just coincidentally, you notice under the consent item, I had a number of requests from the Hamilton Port Authority to place a number of these similar signs along Eastport at strategic points, and I had the opportunity to speak to my beach community council, who were not in favor of the Eastport signs because of the visual pollution. The signs were well above the noise walls that protect the neighborhood from the QEW noise and other issues that come with the operation of the highway. So when this was first proposed, I did have some concerns, but in terms of the location that's been planned, certainly the consultation that Councillor Marula has undertaken, because this does fall within his area, it is quite a distance away from my residence in Ward 5, and it's almost as if the applicants, through their planning, have found really the perfect location. If we were to allow one, this seems to be the best site for it. And so others have mentioned the benefits that come with the partnership. The relationship between us and the organization seems to be getting stronger as we've moved on from other issues that we've dealt with. And certainly the investment that's being proposed into the neighborhood or neighborhoods that surround the sign is a key component of what we have in front of us. So for those reasons, I'm going to support what's in 8.2, and at the appropriate time I would move both 8.1 and 2 when you see fit.
Thank you, Councillor Whitehead. Then Councillor Ferguson.
Thank you, Madam Chair. As I indicated earlier, I've always been supportive of the latest and newest technology, as long as it's utilized in a safe manner and doesn't impact on surrounding residents. And Councillor Collins indicated that this location is ideal relative to any impacts on homeowners. So the other thing I want to do is, and I think the word I heard just in the previous speaker was move on. I mean, what concerns me is there's still an element in the social media that, for whatever reason, want to take a shot every time that the Tiger Cats do something. Well, I want to make it clear that the Tiger Cats are part of this history, part of the fabric of this community. We've entered into the partnership with the stadium. We've entered into a partnership on this particular request. And the relationships with the Tiger Cats couldn't be better, quite frankly. And I know that there was a misunderstanding with the water fountains, and the Tiger Cats' response was, as we expected, very, very positive. Certainly, so to misplace that issue on the Tiger Cats, again, was wrong and wrong-headed. So I'm fully supportive of what's here before us. I support a letter of support for this particular piece. I support a letter for expediting the process to get the permit. And I also support the appeal, because at the end of the day, the ministry will make the decision balanced on all the issues, and it'll be an informed decision. So I'm wholeheartedly supporting this application. Thank you very much.
Thank you. And final speaker, Councillor Ferguson.
Madam Chairman, I was first contacted by Glenn Gibson about this issue quite a while ago, and I want to thank him publicly for the very professional way that he's tried to shepherd this through the city approval process. As chairman of the Stadium Precinct Subcommittee, which also now includes the Pan Am Games Subcommittee, our lease agreement, I went out to try to find out with Tiger Cats, actually has a requirement there that we will do what we can to support them having visibility to get people down to our new stadium. I don't think I need to remind everybody that the stadium debate was a little controversial, and there was a lot of discussion, why not Confed Park? And well, and believe me, I'm past the discussion about location. I'm over that, but this may neutralize part of the problem by having this visible sign in that same area to direct the motoring public on the QEW to our new stadium and to the Tiger Cats, and promote city special events like the Pan Am Games that are going to be going on next year. So I'm very supportive of the sign. Now, just through you to Steve. Steve, I think you're the author of the report, or Danielle, or Jason. One of you can answer the question. 8.2 is recommending denial. And I think the intent of the committee here today, I'm sensing, is to support it. And also to send a supporting letter with the Tiger Cats application to the MTO for approval to put it on the Queen Elizabeth Way. So I'm going to need your help with some wording about how we support it. I read option 2, which is to support it, but there's not a lot of other conditions around that.
If I can, 8.1 we're just receiving, we're going to do that at 8.2, just to be clear.
I'm trying to zero in on both. 8.1 is simply to receive, I suspect, because it's an information item. 8.2, though.
A lot of this discussion is related to item 8.2. We can just receive item 8.1.
Yeah,
and then we can move to
okay, so Councillor Collins, Councillor Ferguson, all those in favor of receiving 8.1, thank you very much. Now, Councillor Ferguson,
so
sorry for the interruption, but let's keep it on.
I suspect the chairman won't let me move this now because I've spoken to it. But if we want to have a motion to approve the sign, can you help us with the wording of that resolution, in which would include sending a letter of support to the MTO.
Dr. Ferguson?
Through you, Madam Chairman. Yes, we can do that. It would just be a very simple recommendation that the sign variance application be approved, and that the Minister of Transportation be advised of Council's decision. There's no need to attach any conditions to the approval because the sign will need a building permit, and as a precursor of that building permit, they will be required to submit a land use permit with their building permit application, and during that building permit review, they will identify any variances from the zoning bylaw that are applicable. As identified in the staff report, the current sign location does not comply with the zoning bylaw provisions, so the proponent, if they want to build the sign in this location, they will also need a variance to the City of Hamilton zoning bylaw and have to go through the Committee of Adjustment process for that as well. But those are, you don't need to make the variance or the MTO land use permit a condition of Council's approval of the sign variance application, since they have to happen anyway.
Okay, so the building department, as part of their approval, will also check the engineering concepts of it. There's adequate foundations and it's structurally sound. You mentioned it has to go to Committee of Adjustment for minor variance. Is there a chance this could be killed at Committee of Adjustment then?
Through you, Madam Chairman, the Committee of Adjustment is an independent decision-making body, so they may decide to deny the application when the variance comes forward, or alternatively, there could be a third-party appeal to the Committee of Adjustment's decision. Any person can appeal a decision of the Committee of Adjustment, whether or not they're immediately adjacent to that property, or alternatively, I believe under the zoning bylaw regulations, the sign has to be set back approximately 14 meters from the limits of the MTO highway. The proponent could seek to relocate the sign to be outside of that 14-meter setback. I think it's right now it's about 4.4 meters.
Is that the only thing they need the minor variance for, is a setback?
Through you, Madam Chairman, that is correct. It's too close to the MTO highway limits, so they could just shift the sign by about 10 meters away from the MTO highway limits.
And as our professional director of planning, your staff would comment to the Committee of Adjustment if the Committee and Council next Wednesday decide to support this. Would your comments to Committee of Adjustment be supportive, or where would you go with your recommendations?
Through you, Madam Chairman, the comments would have nothing to do with the sign variance itself. It would be the impact of allowing a sign to be located 4 meters away from the limits, from the highway limits, whereas the bylaw requires 14 meters. And generally, we've supported unrequired features within that setback, but it's more coming from MTO's concerns if they ever had to widen the highway. That's why they always seek to have structures located more than 14 meters away. So we would be looking also to the comments from MTO if they had any concerns with a structure being closer than 14 meters to the highway limits. But we have supported other features, unrequired parking, landscape features, et cetera, on the service roads within that 14-meter buffer before in other situations.
Councillor Ferguson, your microphone, please. Thank you.
So the motion, through you to Steve, would simply read that we approve the sign application and advise the MTO of our support. Would be that simple?
Through Madam Chairman, yes, that I believe it would be that the mayor be directed to write the minister indicating their support for the sign variance, or for the sign in its location as proposed.
Councillor Ferguson?
I assume you won't let me put that motion now. Unless you have other speakers?
I have no other speakers, and I think everyone is on the same wavelength as you, so I'll go back to you to just...
Okay, I'll move that the application be approved then, and that we read a letter of support to the MTO.
And Councillor Collins asked for that. Did he be seconded on that? So all those in favor, please. Oh, sorry. I think that's what was part of the amendment. It's all in the motion. Right. Okay, so thank you. All those in favor? Any opposed? Okay, folks, follow the roadmap. We're going back to 6.6. Thank you for your patience for this. This is the application for the amendment of the City of Hamilton zoning bylaw number 6593 for the lands located at 2791 King Street East. This is in Ward 5. Members of the public, in accordance with the provisions of the Planning Act, please be advised that if a person or public body does not make oral submissions at the public meeting or make written submissions to the Council of the City of Hamilton before Council approves the zoning bylaw amendments, the person or public body is not entitled to appeal the decision of the Council of the City of Hamilton to the Ontario Municipal Board unless, and the person or public body may not be added as a party to the hearing of the appeal before the OMB unless, in the opinion of the board, there are reasonable grounds to do so. I see that we have some people up in the audience that are here to speak to this. You're here to speak to this. Thank you. So we'll at this time ask Joe Muto to come down and present the staff report.
Still morning. Good morning, Madam Chair, members of committee, staff, and members of the public. The subject lands are located at 2791 King Street East in the city of Hamilton at the northwest corner of Owen Place and King Street East. The applicant has applied for a change in zoning to the property at 2791 King Street East from the AA Agricultural District to the site-specific AA Agricultural District in Hamilton zoning bylaw number 6593. However, after reviewing the proposal, staff are recommending changes to the proposal and have included a holding provision with a site-specific request in order to permit parking on the lands municipally known as at 2791 King Street East to be used in conjunction with the proposed redevelopment of the lands located across the street from Owen Place at 2803 King Street East. With the submission of the rezoning application, the applicant provided two options. These options came out of reviewing the newly acquired lands subject to the zoning application. The owner currently owns the lands known at 2803. Mr. Lambda is the owner. The use of the property currently is across the street is used for an auto sales dealership. This is an aerial view of the subject lands. This is a photo of the subject lands located at the corner of Owen Place and King Street East. This is the Punjab Auto Sales at 2803 King Street East. This is looking kitty corner from across the street on the subject lands. This is the abutting residential to the west, and a letter of concern was submitted by the property owner here, and I believe they are here today. This is abutting residential to the north of the subject lands. This is existing commercial uses on the south side of King Street East. And this is the City of Hamilton Police Station located on the other side of the Punjab Auto Sales. And this would be the access coming from the Hamilton Police Station from Owen Place onto Owen Place. In accordance with the provisions of the Planning Act and the Council-approved public participation policy, notice of complete application and preliminary circulation was sent to 94 property owners within 120 meters of the subject lands on March 14th, 2014. A public notice sign was posted on the property on March 21st, 2014, and one letter, as stated, of concern was submitted by a neighboring resident at 2787 King Street East. The letter is discussed in the analysis rationale for recommendation section of the staff report. Most of their concerns have been addressed through the staff recommendations and implementing zoning bylaw. The notice of public meeting was circulated in accordance with the provisions of the Planning Act. The public notice sign on the lands were subsequently updated on August 29th, 2014 to provide notice of today's public meeting. Madam Chair, in closing, the planning application, as amended, has merit and can be supported by staff as the proposal is consistent with the provincial policy statement, conforms to the growth plan for the Greater Golden Horseshoe, it conforms to the policies of the Urban Hamilton Official Plan, and the proposed parking lot addresses parking demand for the proposed medical office redevelopment located at 2803 King Street East. Madam Chair, that concludes my presentation.
Thank you. Are there any questions for Joe at this time? Councillor Collins.
Madam Chairman, and thanks to Joe. I know Joe's worked for some time with the applicant in terms of getting us to where we are today, so I appreciate staff's assistance. My concern through the whole process, Madam Chairman, through you to Joe, as you know, Joe, parking is a massive issue in this area because we have the St. Joe's Medical Facility right next door, and they charge their, not just their staff, I think, but their patients to park on site. And so the problem that I've had to deal with over the years, and it's almost a decade now since that parking fee was implemented, is the proliferation of on-street parking in the adjacent neighborhood. And my concern when I noticed not just Mr. Lamba's original application, I believe that a portion of the building will be used for medical purposes, which, as we know from a planning perspective, attracts a lot of traffic. My concern from the start was the number of parking spaces that we could facilitate on the vacant lot that you've outlined in your presentation. And I know the applicant has suggested actually that we go with 2 rows of parking rather than 1. I'm curious to know how we would facilitate that if the committee saw fit to amend the application in the approval process. How would we go about adding the additional parking, knowing that for those people who live in this area full time, it's been an ongoing concern? Through you, Madam Chairman.
Through the chair to the councillor, with respect to the proposed medical office use that Mr. Lamba would at some time in the future come forward with, has not been vetted from a planning perspective in terms of, you know, the gross floor area, the types of uses forthcoming. They've identified that it would be medical office. They've come to city staff or the development review team to do a formal consultation based on these 2 options that they've provided here today and that were submitted with the rezoning application. So in terms of the ultimate parking, this proposal that they've recently acquired through the city acquisition of the city parcel that's subject to this rezoning has not, like I said, has not been vetted. We've just tried to accommodate as best we can by meeting the principles and the provisions of the existing zoning bylaw and adding some additional provisions through this implementing bylaw. Through the chair to the councillor, if I guess in respect to that, what staff attempted to do in this regard was try to accommodate some of the existing provisions as well as some of the residents' concerns relating to the landscaping, fencing, and having an appropriate access as well as maneuverability for the future parking lot.
And so on the question in terms of what we'd need to do to amend it, as I understand it, and Joe, you've listened to many of the debates around this table, traditionally we're begging the developer to add more parking, and in this instance they've proposed more parking and we're actually suggesting they go with less. So I was quite pleased to see 2 rows at this location rather than just 1. I understand we haven't received an application yet for across the road, but if the proposal at this point, and I would tend to believe the applicant that their intent is to build a medical facility or a portion of it would be deemed for medical use, I would much prefer to go with more than less parking. So what would we need to do here, and maybe it's a question for Marty's staff for the parking, but I thought I read in the report that they were supportive of additional parking, understanding we don't have an application yet for the medical facility. How does the committee make that work in the context of what we have in front of us, is my question.
Through the chair to the councillor, I mean, based on good planning principles and design, this is, in staff's opinion, the best outcome. I mean, whatever the committee decides to do above and beyond would likely be up to, I guess, Ms. Marty's group. As indicated in my staff report, there is some discussion with respect to the encroachment. I think historically the encroachment agreement, the city and commercial uses are done to recognize kind of existing situations, and in this respect, since it is new and there's nothing that's currently developed there, we are concerned with it moving forward and kind of setting a precedent.
Yeah, I think we're being relatively conservative here, and I'd rather prepare for the worst, especially as it relates to parking. This is essentially a parking lot, so we're not, other than what we might lose on a landscaping buffer, and we'll certainly hear from people who may have that as a concern. My concern is what happens to the parking in the neighborhood after any commercial development is constructed across the street. And so I've changed through Marty's group every parking regulation for 4 city blocks in southerly, and certainly we've changed all the parking regulations on Owen Place almost down to the end of the street to accommodate the existing traffic that's generated by St. Joseph's, as I referenced earlier. I am not interested in the least in contributing to that parking problem, so my preference is to go with 2 rows of parking, and I think the applicant has agreed with my request. So all I'm asking is, what do I need to do to amend 6.6 to make that happen? And I'm not certain I've received that answer. Maybe through you to Marty or
you, Madam Chairman, to the Board Councillor. Steve. There would be 3 things that would be required. One would be to direct staff to prepare a revised zoning bylaw to reflect the proposal as submitted by the applicant. And then secondly, there would be a direction to both Public Works and MLE staff to work with the applicant to enter into the necessary commercial boulevard parking agreements and encroachment agreements to allow parking within the municipal right-of-way. So that would be the direction to staff, and that would allow for the implementation of the proposal as submitted by the applicant to allow for the 2 rows of parking partially located within the road allowance. We would need to revise the zoning bylaw because there would have to be some notwithstanding clauses built into it to eliminate some of the required landscaping along the lot line, but that would be achieved by requiring landscaping within the boulevard, and that may also be just sort of a direction to staff to work with the applicant because they have to go through a site planning process to ensure that there's enhanced landscaping and other features provided within the right-of-way in order to mitigate and buffer any of the negative impacts associated with the parking lot partially located within the road allowance.
Okay, I think that's very clear. So 6.6 would move ahead pending the decision of the committee. Certainly we have public comments to deal with. It would need to be amended, and we would incorporate at a later date whatever development comes forward on the other side of the street. Is that correct?
Through you, Madam Chairman, that is correct. We do not have any current development proposals for across the street. So at such time as they came forward with their site plan application, we would deal with that application on its own merits. And if they needed any variances or agreements to allow for parking, because for the medical clinic, their concept plan also shows parking within the municipal right-of-way, parking and maneuvering areas. So they would also need to enter into separate agreements for that property since it's a separate parcel of land. And then we would register those agreements on title as well.
Okay. Thank you for those answers, and thanks again to Joe for his presentation.
Any other questions? Councillor Pearson, please.
Thank you, Mr. Chairman. I just wanted to ask through you, there will be site plan requirements. So I'm asking that will include landscaping around the abutting properties. So I notice if you go back to the picture, you showed the property to the west and the property to the north. There is nothing currently abutting that, and I see in here we're looking at fencing. So fencing will be required, but will there also be landscaping buffering required?
Thank you.
Property to north has a wood fence now. It belongs to that property owner.
Through the Vice Chair to the Councillor, the implementing zoning bylaw prepared for the staff recommendation does identify, I believe, a 2-meter landscape strip as well as the fencing or visual barrier along the periphery of those residential dwellings.
At that time, it'll be under site plan control, so there'll be involvement with the ward councillor or the neighborhood potentially to make sure what goes in there.
Through the Vice Chair to the Councillor, the site plan process would be circulated to the ward councillor. It's not a public process, but if this committee so wishes to have the public involved.
No, I just wanted to ask the question. I may have interest I could speak to the ward councillor about with regards to a property owner abutting that. The other question I just want to ask is on page 20 of 21. It does speak to the visual barrier, the fencing. Could you just clarify, through you, Mr. Deputy Chair, it mentions fabricated metal. Is this different than what we proposed or put in our fence bylaw that no metal fencing is allowed? I just want to be sure we're not contravening our new fence bylaw.
Mr. Muto.
Through the Vice Chair to the Councillor, the fence bylaw would be a separate bylaw. This is coming out of zoning bylaw 6593, which identifies what types of materials can be used with respect to a visual barrier. As indicated, it would be going through the site plan control process, and at that time, staff would likely not recommend something of that nature.
I want to be sure it's noted because in our fence bylaw, we do not allow the metal fencing any longer. Thank you. Thank you for the answer.
Thank you. Any other questions? Seeing none, a motion to receive the staff report. Moved by Councillor Pearson, seconded by Councillor Collins. All those in favor? Carried. Thank you, sir. Now to the members of the public. If you'd like to come forward, please. And is there any other members of the public that will be speaking to this? Thank you. Good afternoon.
Hi, good afternoon. My name is Karen Dick, and this is Sean Jones. We are the residents at 2787 King Street East that are on the west side of this proposed parking lot. We submitted the letter, and we would just like to thank Joe and all the council members that went through our letter and have made adjustments, and we really are appreciative of that and taking into our concerns. I would just like to further put forth that a solid barrier wall along our fence line and against our property, we really would like that, just as a protection measure against vehicles potentially colliding into the side of our house, seen as part of the house is not covered by our wooden fence as it is right now. And with looking at the drawings of the properties, next to our house, the cars would be within 1 meter of our house. So we were very concerned about that. So I just want to put it onto record that we really are looking for something that is solid and that would sustain potential collision of a car. And then we were concerned about the last clause just before the maps, where it says that there's a clause in there that it says that there's a potential to change this proposal to from what they're proposing, which is the 2 lines of parking. We are really in favor of what the city has put forward in terms of 1 lane of parking and it to be used for staff. It makes more sense just being a resident right next door in terms of car lights into our house, in terms of noise of car doors opening, that kind of thing, in terms of people crossing the roads. We're living in a situation where we have the hospital on the one side, and then we're going to have this medical center, and a lot of public traffic on foot has already impacted our property, and we're concerned the further ramifications of that. I think that is all.
Anything for Sean to add then?
Sorry?
You have anything to add, sir?
Well, just also the impact of the value of the property as well. If somebody were to want to buy this as a residential home, they probably would refrain from purchasing because they have a parking lot right beside them. I think that's about it, really.
Okay. Thank you very much, both Karen and Sean. Any questions for the? No, thank you. If you could just fill in, Councillor Pearson, you're moving. If you could just fill in the form there with your name and address. Motion from Pearson, seconded by Collins to receive the presentation. All those in favor? Thank you. Come on down, sir. You're wishing to speak to this item also? Are you a resident, sir?
No, sir. Nick Philippus, an agent for the owners of the property.
Okay. Can I just ask if there are other members of the public before we have you speak,
sorry,
sir?
go right
So
ahead.
is there anyone else from the public, the general public, that wishes to speak to this item? Anyone else from the general public that wishes to speak to this item? And the third time, anyone else from the general public that wishes to speak to this item? Seeing none, I need a motion to close the public hearing. Moved by Councillor Pasuta, seconded by Councillor Collins. All those in favor? Carried. Yes, sir. on behalf of the applicant, please.
Thank you, Mr. Chairman, fellow committee members. Not to beleaguer the points that have already been made. I mean, as we said, this is the first step of a larger project. Obviously, the project's going to go on the property to the east, and that's what will be the majority of the development in here. And it is a coincidental development, and obviously both properties need to be addressed together, and we have every intention of doing that. And like I said, this is the first step in being able to ensure that we could use this proposed property for parking. And obviously, as Councillor Collins indicated, the amount of parking is also very critical as to keeping the development viable next door to, and also reducing any spillage onto to Owen or other the adjacent streets, because there already is that other issue from the hospital. And like I said, we have no issue with the staff report. We have no issue with the H provision, because I think it protects the municipality and making sure that the total development is well coordinated. Our only issue, I guess, is some of the site-specific comments made directly by staff. One being the landscape setback to the west, and the other being able to have the flexibility to provide the 2 rows of parking, one partially encroaching onto the road allowance. We don't see an issue with trying to provide the westerly neighbors with solid screening that will give them the privacy that they're asking for and mitigate any of the adverse effects of a parking area. We just don't think it needs to be done through setback, and that's where our issue is. The bigger that setback, the worse the encroachment is, and so on and so forth. And I think that building the lot without the 2 rows becomes very critical to the whole project. We're a very challenged development here. Both this property and the one to the east, we're being requested to donate very large road widenings. On the property to the east, they're taking almost 30% of the entire frontage on a road that's just been recently completely built new. So it's sort of suspect as to when the ever future widening again of King Street would happen in that area, and given how it's just been clearly widened to this date. So losing that much property makes it very challenging to be able to make a viable project, and so that's why we're saying it's very important to have these parking leeways given to us. Site plan will certainly provide the municipality all the avenues it needs to protect, like I said, protect the municipality and the neighborhood, with all the engineering concerns being addressed through lighting, landscaping, privacy, so on and so forth. So we don't feel that need. So our amendment requested is like I said, the bylaw that being proposed is fine, other than the required setback to the westerly property as far as landscape strip width, and I guess to allow us that flexibility to enter into the encroachment agreement. So we'll see fit if parking authority can deal with it, that we can allow and apply for that encroachment agreement to park adequately. I think that's it. I appreciate any comments, and we hope that we can receive your support.
Thank you. Anyone here for questions for thank you. Councillor Collins, please.
Thanks, Madam Chairman, and through you to Mr. DeFilippis. I thought I heard you say, Nick, that you were committing to a solid barrier between the new proposed use and the residents next door. I just want to make sure that was from certainly one end to the other, understanding that there need to be some accommodation made closer to King so as not to block any visibility. But I thought I heard along the lot line there's an opportunity to construct a solid barrier, which is traditionally through site plan, but I just wanted it on public record again that you did commit to looking and investigating to making that kind of an investment with the applicant.
Through you, Madam Chair. Obviously, the issue about the height of that fence as it gets closer to King is very important for sight lines along King, and obviously we're going to meet the bylaw requirement on both fences or both types of fence. As for a solid barrier, I mean, we haven't finalized the actual design of the fence, but the solid barriers can be built many ways and insulated many ways so that we can still achieve the screening and the setback that and we hope we can mitigate the setback so that we can still achieve the purpose of that fence.
And my other question would be, I'm very familiar with the site and having lived in the area for quite some time. So I do know that since the home was, the property in question had a residential home on it until a couple of years ago. It was torn down as part of the city's King Street construction project. The city actually purchased that and has put it on the market. Mr. Lamba has purchased it from us. But since that time, there have been a lot of shortcut pedestrian traffic. Those people, I think, as was outlined by both Sean and Karen, there's a lot of pedestrian traffic through that area using now what is a vacant lot. And I'm hoping that through the design process, we'll be able to design it in a way that we improve pedestrian traffic so to push them to Owen Place and along King rather than shortcutting through, which will be it sounds like a busy area with vehicles operating for at least business hours during the day. In terms of what we can do to address that, I'm certain that can be placed on the site plan to-do list. Is that something we can look at through you?
Nick?
Yeah, through you, Madam Chairman. I don't think there's an issue doing that. And like I said, we have every intention of doing whatever it takes to help mitigate all these types of problems, like you just said, the jaywalking or crisscrossing across the road. And I think one of the suggestions we had made through the process is that we try to encourage the building owners of the property to the east to let staff mainly park on this property. So it also reduces the amount of in and out. I mean, hopefully we can reduce a good portion of those proposed spaces to very few trips a day in and out in the morning, out at night. And that's pretty well it.
Right. And lastly, through you, Madam Chairman, I think you were present, Nick, when I asked the question to planning staff in terms of what revisions would need to be made to the report to allow that second row of parking. Understanding we'd need some site plan issues dealt with for the adjacent neighbors. Were you supportive of Mr. Robichaud's suggestion in terms of the revised zoning bylaw going ahead, and then the second part to that, I believe, was the encroachment agreement and the setback issues that need to be revised?
Through you, Madam Chairman, Board Councillor, if I assist, yes. As a matter of course, they'd be required to enter into a commercial boulevard parking agreement with the city, with Mr. Hazel's group, and there'd be an encroachment agreement with Public Works. And then what we would just suggest was that through site plan, we would be looking to provide enhanced landscaping within the municipal right-of-way because they'd be providing parking within the right-of-way, and there wouldn't be normally a buffer otherwise between the parking and the sidewalk or the curb.
So you again, Madam Chair, I have no issue with that. I guess the only thing I'm asking for is as the bylaw is written today, it says 2 meters on the west. If we leave it that way, it sort of restricts our abilities to design and provide, what leeway we'll need to make sure that the site works. Like I said, that's the one item without having to come back to Committee of Adjustment to a variance application unnecessarily for this property. We're trying to clarify that up front. It doesn't preclude the requirement to do to satisfy the municipality as far as the privacy issue. So at least, though, we're not obligated or mandated by the setback right off the bat, and we have no issue. We have no leeway to manipulate the site. And I know that will create a further issue in forcing the whole parking area easterly unnecessarily.
Understood. Okay, so I can raise that issue then when Mr. DeFilippis is back in his seat.
Thank you. Any other questions? Seeing none, can I have a motion, please, to receive Mr. DeFilippis' presentation? Councillor Collins, Councillor Pearson, thank you. So now before you, we have 6.6. I'm coming back to Councillor Collins for...
Just on the revision there and the 2 meter issue that Mr. DeFilippis has just identified, then again, I want to be clear, just so as this isn't back to committee and there are delays, we need to get to the site plan, obviously, for Sean and Karen, and we certainly need to try to accommodate as best we can the next phase of development for Mr. Lamba, who's making a substantial investment. I'm anxious to see a building on the other site instead of a trailer that's been there for quite some time that Mr. Lamba has appropriately dealt with his partner. They've had a very successful business, but for anyone who's visited this stretch of King Street, there's a lot of transition going on. Certainly Councillor Clark has a very large development just down the street, and we've seen the rejuvenation and the regeneration of many of these properties into something different than they traditionally have been used for over the last 50 or 60 years. And so Mr. Lamba's development is certainly a good fit in that regard, including some of the improvements we've already seen across the street at the gas station and the Tim Hortons and their new design. So I want to be clear on the 2 meters in terms of what revisions need to be put in the recommendation. So if I can, through you, Madam Chairman, I know Steve has referenced it, and Mr. DeFilippis reiterated that he does not want to return in this forum through another process, whether it be committee of adjustment or otherwise. I just need to be clear in terms of what we're doing with that 2 meters as part of the recommendation that's in front of us.
Madam Chairman, what I would suggest would be the easiest way would be to modify the recommendation so that in the 4th line, after the phrase parking lot in conjunction, to add the phrase as shown on appendices C and D. So that would be a very clear direction that the implementing bylaw would be prepared to implement the concept plan prepared by the applicant and submitted with the rezoning application. And then between now and council next week, staff would make the necessary modifications to the zoning bylaw to ensure that the concept plan as shown on appendices C and D is implemented. And then the other matter that would be add a new recommendation D that planning and economic development staff and public works staff be directed to work with the applicant to enter into the necessary commercial boulevard parking agreement and encroachment agreements to implement the concept plan as shown on appendices C and D, and that and then also E, that as part of the site plan review process, staff work to provide for enhanced landscaping within the municipal right-of-way. And our follow-up with Vanessa on both of those.
And I would just suggest that I know it was referenced by Councillor Pearson. Thank you for those amendments. I would suggest that we include the residents who appeared today as part of that last discussion there on the landscaping and the fencing issue. I know it's, again, traditionally it's something that's dealt with internally here, but if there's an interest of the adjacent neighbors to participate in that discussion, I certainly welcome it, and I would like that included in the recommendation if possible. So I would move those amendments at the appropriate time and then move the main motion as amended.
And seeing no other speakers, we're going to go back to Councillor Collins, seconded by Councillor Pearson, of those amendments that will be clarified through with Vanessa and Steve at a later date. But I think we caught up the essence of this. And I see that the residents are nodding their head yes, they would like to be included. So thank you, Councillor Pearson, on this motion, on this amendment.
Madam Chairman, on the amendment, I'm fine with it. I just want to also be included in the site plan with regards to a property owner to the north. So I don't know if it needs to be part of this as the residents to the west are, but I know I can work with the ward councillor and staff, so that's
okay. That's great. So on the amendment, moved by Councillor Collins, seconded by Councillor Pearson. All those in favour? Carried. On 6.6 as amended, moved by Councillor Collins, seconded by Councillor Pearson. All those in favour? Anyone opposed? Thank you, and thank you very much for your patience, folks. Let Councillor Ferguson know if you need more money for your meter. So now we're on to 8.3. This is the review medical marijuana growing and harvesting facility, greenhouse and aquaponics facility as permitted uses in the rural areas, Ward 9, 11, 12, 14, and 15. The wards that are affected are, and I think I just said that, this is prepared by Joanne Hickey-Evans. I believe we have some people here to speak on this, so I would ask Joanne Hickey-Evans to please come down. I'm sorry.
Through you, Madam Chair. I don't have a formal presentation, but I will summarize what is in the report because this is not a public meeting. The public meeting was closed. As many of you may recall, on June 17th, Planning Committee tabled a portion of the PED 14037B dealing with medical marijuana, aquaponics, and greenhouses, and in particular, it focused on the rural area. It was tabled for 2 reasons, and it's summarized in your report. One was to ensure that a site plan control process be established for aquaponics and medical marijuana facilities because they're currently not under site plan control. And the second part was to deal with the letters of intent. And the city had received several letters of intent. And for those people in the audience, a letter of intent is an application by a prospective owner to seek a license from Health Canada for a medical marijuana growing facility. So staff identified that there were 7 letters of intent in the rural area where they would be permitted use. That excludes the Niagara Escarpment Commission lands, as it also excludes rural settlement areas. So in Appendix E of your report, you will see a summary of the information that we received on each of these 7 proposed facilities. So with this information, and then going back and revisiting, one issue stood out for committee, and there was quite a bit of discussion, was surrounding the restriction of 500 square meters for a medical marijuana facility. So in looking at the information that we received, as well as looking at the rural landscape, we also identified that there were a number of existing buildings in the rural area, particularly in the former industrial business parks, that because of the Greenbelt Plan restrictions, don't have a lot of future. So we thought that was a perfect adaptive reuse in these areas. So in terms of the recommendations before you, in PED 14037C, there are three changes actually. The first is to allow a medical marijuana facility in buildings existing at the date of the passing of the bylaw. The second would be that any new building, and there's not a restriction on the number on the site, would not exceed 2,000 square meters. And the third recommendation is that the height be restricted to 11.5 meters. So subsequent to the preparation of the report, there are two additional changes that we're seeking, and they're really clarification. And the first surrounds what I just talked about, the 2,000 square meters. The way the bylaw is written, there was some interpretation issues. So we would like to say, to clarify it, to say that any individual building or structure would not exceed 2,000 square meters. That's to be absolutely sure that there's no misunderstanding as to what that is. And the second thing, we also recently learned that there are companies who are interested in allowing testing independent of the growing and harvesting. And the way the definition is written, we want to ensure that testing is only done in conjunction with the growing and harvesting of the medical marijuana. So we're suggesting that the sentence be added to the definition to ensure that testing is accessory and incidental to the growing and harvesting. Again, both those points are clarification. So going back to the 500 square meters and our thought about the existing buildings in the 2,000 square meters, in your report there's a series of different options that we considered. As you may recall, there were people who presented to you the last time, and they are looking to expand. They bought some buildings and they want to adapt or reuse. And of the 7 letters of intent of the existing buildings, only 1 exceeds 2,000 square meters. So we derived that 2,000 square meters is an appropriate size restriction. Secondly, we looked at mushroom operations because there was a lot of indication that mushroom operations were similar to medical marijuana. We looked at the building regulations surrounding them, and one of the things that we identified is a very recent mushroom operation. The height of the building was 11.5 meters. That's fairly significant, but we wanted to make sure that we didn't have multiple story buildings within the rural areas. So what we have done is suggested a restriction of 11.5 meters in height. So in terms of how we came to these recommendations, I mean, we know that the medical marijuana, it is a new and emerging use. There's no magic bullet. There's no municipality that has gone out and looked at various, there's no experience we can draw on. So based on the rural vision, where we want to have buildings that are focusing on agricultural use, agricultural production, and looking at the size of the types of buildings that actually locate in the rural area, we came upon we identified that 2,000 meters is acceptable. As you note in Appendix E, there were a couple of facilities that would like to exceed that size, and one building they were looking at a future expansion. It doesn't say if it's one building or multiple buildings at 3,500 square meters. There's another facility that would like to have a future expansion of 35,000 square meters, and a third one that wanted to have an expansion of about 22,000 square meters. And so those uses are, building sizes are quite large for a rural area, and that's why we propose a restriction on the size. So in conclusion, we are recommending 5 changes from our original report back in June. And to summarize, it was 2,000 square meters for all new buildings with no restriction on the number of buildings per site. You can use any building existing at the date of the passing of the bylaw. Height restriction on the new buildings to 11.5 square meters. And the 2 amendments I just spoke about, one is to clarify the bylaw language surrounding all individual buildings are not greater than 2,000 square meters, and amending the definition slightly to ensure that the testing is accessory and incidental to the growing and harvesting of the medical marijuana. So that concludes our the recommendations that are made in this report on the basis of. Oh, and just one more thing to add is that the very last recommendation identifies that both medical marijuana facilities and aquaponics will be placed under site plan control bylaw immediately to address committee's concerns from June.
Thank you, Joanne. I've got Councillor Collins and myself, please.
Thanks, Madam Chairman. And I certainly understand the sensitivities in terms of what kind of development would come with, you know, in many cases, we've referenced them as small factories or business operations. And in some cases, they, as was referenced, they can become quite large, especially if you're in that 20 to 30,000 square meters category. So I'm certainly supportive of what's in front of us in terms of the recommendations. And I wanted to be clear, I thought I heard Joanne say that it doesn't limit, though, someone who may have a large rural property from erecting more than one building on site, to be correct. Is that right?
Joanne? Madam Chairman, that is correct.
Okay. And I just wanted to understand, because I'm not familiar, I haven't had anyone certainly approach me in my area, but I do know that several prospective investors have made the rounds to different areas of the city. And I'm wondering what the average facility looks like, and whether there is a difference between those that are looking to operate in the rural area versus those that may be considering urban area operations. So are there limits in terms of what we've established in the urban area? And with applications that have come through in an informal way, are staff aware of what the norm is in terms of how large these properties might be once they receive all of their approvals and, of course, the appropriate federal regulations?
Madam Chairman, in the urban area, there's no restriction on size, but we have subsequently learned, and through an informal, it's not in a regulation, that the federal government is looking at restrictions on setbacks, which are greater than what the municipality has at 20 meters from residential uses. We've seen various sizes. We've seen in the industrial area, I know of one in particular, and it was within an industrial complex, so it wasn't a standalone building. There were some other people who had standalone buildings, particularly in the north end. I'm not sure what their size is, but the urban area, we were not concerned about the size because, as you know, in an industrial area, there's a number of different building types and forms, and so it would fit beautifully in there. But the rural area was a little bit different. There is, you know, what we know is in Tweed, for example, they adapted in another factory. There's nothing we can point to say, okay, this is what the size is going to be. It depends on how much production that they're going to get licensed for, because you can have small operations and you can have large operations, from my understanding.
Okay. Thanks, Madam Chairman. Those are my only questions. Thank you.
Thank you. And Councillor Collins, can you take the chair? Just, oh, sorry. Councillor, sorry, I've been doing this all morning.
I know, and I apologize for that.
No, that's fine. I already
here.
announced at the beginning of the meeting who was going to be coming and going.
Thank you.
Through you, Chair, to Joanne. Letters of intent, 7 of them have been submitted. One of them, or a few, some of them have been within the Niagara Escarpment plan. Is that correct?
Joanne?
Through you, Madam Chairman, I believe there was 1, maybe 2 within the Niagara Escarpment plan area.
Oh, thank you. And through you, Chair, to Joanne. The Niagara Escarpment Commission, from what I understand, does not recognize this as an agricultural use, correct?
Joanne? That's through you, Madam Chairman, that's correct.
So when push comes to shove, does the Niagara Escarpment Commission have the jurisdiction to say, we don't want this here?
Madam Chairman, if they seek a development permit, yes, they can say no.
I'm sorry?
When they seek a development permit, they would say no.
Okay, thank you. And the Niagara Escarpment Commission being very restrictive with their development and being very restrictive for the list of what can go and what cannot go, how does this fit within the Greenbelt? From what I understand, they were supposed to almost mirror each other. So how is it that we are looking at putting buildings into the Greenbelt when the Niagara Escarpment Commission doesn't recognize this as an agricultural use?
Joanne?
Through you, Madam Chairman, the Niagara Escarpment Plan and the Greenbelt are different. Our understanding from OMAFRA, which is responsible or through Ministry of Municipal Affairs and Housing for the Greenbelt, identified this as an agricultural use. The Niagara Escarpment Plan has chosen to take a different view.
Okay, thank you. And I'm only getting these questions out because I know they're going to be coming towards me. So through you, Chair, to Joanne, these 7 that were submitted, are these brand new applications, or are these applications that reflect ongoing operations as they are today, and they're just actually updating their status?
Joanne?
Through you, Madam Chairman, the letters of intent are for a facility under MMPR. That is the regulation that amended the original medical marijuana. So they are applying under the new regulations, which they are required to do.
Right.
We have heard rumor that maybe one of them already had a license under MMAR, but for the most part, these are new facilities.
Okay, so through you, Chair, to either Joanne or legal. We know we do have some of these facilities that have been operating already under the old guard, if you will. My understanding is that there will be an end date where the old facilities will have to either apply for the new regulations or they need to cease and desist, correct?
Joanne or Mike?
Through you, Madam Chairman, in the regulation, it was identified that the ones that were established under the previous regime of MMAR were ceased to exist. I don't know the date specifically, but they are to cease.
Councillor?
Thank you, but there's no end date at this point in time for us to say, as of March 31st, 2027, you have to stop. We don't have an end date, correct?
Through you, Madam Chairman, my understanding, and this is not for sure, is that the original date was April 1st of this year, but there was a stay given in another province, so I am not sure how that works in terms of the MMAR.
Okay, so this is where my dilemma is, Madam Chair, is that I do have one facility in particular. The greenhouses are almost abutting the neighborhood home, where the residents could literally stretch outside their second-story building and pick whatever plant they would like. So, and the smells are unbelievable. So where do we stand as a city with the current operations and the new ones coming in and this end date? Are we in a gray area here? Are we floating in midair? What are we doing?
Councillor, are you asking from a legal perspective?
Yeah, I really would like to go back to the residents to give them some sort of comfort level that this facility, although it was legal at the time, now the new regs are coming in, and this facility isn't going to be legal for a variety of reasons, security being one. So if this is something that's coming forward, we don't have any, we're in limbo with these existing versus the new, correct?
Yeah, so Mike, would you take over the question?
Through you, Madam Chair, my understanding is that there is a stay in effect for that regulation on their termination date, for lack of a better term. So you are correct. At the present time, we're in limbo in respect of that, and we can't provide. I can't provide any further assurances other than that.
Okay, thank you. And through you, Chair, back to Joanne, you said immediately they will be put on a site plan. You're just referring to the new applications, correct? You're not referring to the existing ones.
Joanne?
Through you, Madam Chair, it would be the new ones coming forward.
Thank you. And part of that site plan, would it be looking at security, water capacity, utility, the capacity for power? Because my understanding is these things do require a lot off the grid, or to pull off the grid, so I'm just asking.
Through you, Madam Chairman, we would not be looking at security. The security is the responsibility of Health Canada.
Right.
Utility, we would not, that would be their responsibility. We don't regulate powers through site plan control. We would be looking at water use, location of buildings, access, anything dealing with stormwater management. The typical things that we would look at, lighting, if lighting was required, fencing, et cetera, that we would traditionally look under a site plan control bylaw.
Okay, thank you for that. And I'm sort of just looking up this map, for instance, on A, and I'm at page 2 of 3, section 2, A, notwithstanding paragraphs, a medical marijuana growing and harvesting facility shall be set back 20 meters from every site, from every lot line, every property line. So if you were to look right now at the St. Joseph's facility, they would literally have to put it almost dead center to appease that. They couldn't put it close to the neighborhood. They couldn't have their building butting up against the property line. That's going to be a very enforceable, and we're going to stick to that 20 meters.
Joanne?
Through you, Madam Chairman, that is a regulation in the zoning bylaw which we will enforce. People can come through committee of adjustment and seek a variance.
Right.
But we've established this regulation both in the urban area and in the rural area.
Thank you, and those are my questions. Thank you, Councillor Partridge, and I'll take the chair back.
Do you have Councillor Pasuda on your list?
Councillor Pasuda. Thank you.
Thank you, Madam Chair. Oh boy, I think we got caught our pants down on this one when it started, so we're trying to catch up here. Through you, Madam Chair, to Joanne. The Appendix E that's before us here right now, when was the last letter of intent? When did it come in? And is it on here? The last letter?
Through you, Madam Chair, this is as of June 17th.
So, Madam Chair, to Joanne and I got a few questions. There hasn't been any other letters come in since June the 17th.
Any
Through
other
the Chair,
letters since June?
We've received none in the agricultural zone since that date.
In the agricultural zone, none received since. Thank
Very
you.
good. Thank you for that. As of right now, greenhouses have to go through site plan, and that's what we're looking at here with the medical marijuana operations. Joanne?
Through you, Madam Chairman, that's correct.
Okay. Is there a medical marijuana operation operating in Hamilton right now as this date?
Through you, Madam Chairman, we are not aware of any licensed facility in the city at this point.
Okay, thank you. My question here is, and I've got actually there's 4 here in my ward. A couple of the questions, you talked about the buildings that are already there. So if there's buildings already on the property, do they have to be in shape right now to grow, or can they be renovated?
Through you, Madam Chairman, they would have to be renovated. From our understanding is that they have to be renovated regardless because of the requirements for ventilation, security, et cetera, that likely wouldn't be in place at the present time.
So where I'm going with this, Madam Chair, is if I had, let's say, 35,000 square meters of livestock barns and implement sheds, that would qualify as far as under the existing buildings.
Through you, Madam Chairman, that's correct.
Okay. And through Madam Chair, then, and then on top of that, they would be, or I would be allowed to add another 2,000 square meters of new buildings?
Through you, Madam Chairman, that's correct.
Sounds like a court of law here. Sorry, Joanne. We're looking at restricting the size of a medical marijuana building. Can we, the city, restrict the size of a greenhouse, a feedlot, an aquaponics building as of this date? Can we restrict the size?
Through you, Madam Chairman, we can. There's no regulation that says we can't, but we don't have any regulations in place for those facilities now.
So, Madam Chair, may I ask then, why are we doing this to the medical marijuana if we're classifying it as an agricultural crop?
Through you, Madam Chairman, it is a crop. It is not a traditional crop that is saleable to the average person. It is a new and emerging use. It is, firstly, there are no licenses. It's somewhat speculative at this point, since there are no licenses. The adaptive reuse of those buildings is a concern because they are hermetically sealed. And at the time that they go, firstly, from a size perspective and a use perspective, there are some concerns. For the most part, in the rural area, we have traditionally seen livestock barns, you have silos that are greater than height, but we don't see multiple story buildings. We don't see large 35,000 square foot buildings in the rural area. We are trying to maintain the rural vision, despite the fact it is an agricultural crop. And we've identified it as such. OMAFRA's identified it. It's not a typical agricultural crop.
Thank you, Madam Chair. So, Joanne, do we know of any other jurisdictions within Canada, other provinces that have a limit set on the size of the building?
Through you, Madam Chairman, in many municipalities are now going and saying in the industrial areas only. So they're actually even saying we don't want them in the rural areas. Particularly looked out in BC where Kelowna and a few others where they've said no, it's industrial only. Ottawa only allows it in their rural industrial parks. And Sudbury as well.
So there is bylaws in place then, is what you're saying?
There are new bylaws in place for those areas. Whether they're under appeal, I don't know, but that was Sudbury's is, but Ottawa, I understand the appeal has been withdrawn.
So, and this is in the rural area, through you, Madam Chair?
Through you, Madam Chairman, these ones, no, they're for the urban area, except for Ottawa, it's the rural. It's not allowed in the agricultural area, in the rural area. It's allowed in their industrial parks, which they have a number of them.
And I've been focusing on the rural area, so maybe I hope I haven't misled somebody, but we're talking specifically the rural area. So, okay. I'll leave at the moment. We got, I believe, 2 delegations coming forward, 3 coming forward. Okay, I'll leave some questions from my colleagues, and I'll look forward to the delegations. Thank you.
Thank you very much. Seeing no other speakers at this time, I will like to move to receive Joanne's presentation, please. Councillor Ferguson, Councillor Partridge, all those in favour. Thank you. We have correspondence from Ed Fothergill on behalf of 381 Highway number 8 in Dundas. Can I have a motion to receive it, please? Councillor Pasuta, Councillor Ferguson, all those in favour. Thank you. So now we have a number of delegates coming forward. Just to remind everyone, this is not a public meeting. You will be limited to a 5-minute presentation. So is Paul Bernier, and also David Varghese. Come on down, please. Hello, Paul. Is David with you?
No, it's not Paul. You know that. I know that. It's Scott Snyder. I'm here. I'm counsel on behalf of those individuals. As you know, I'm with Turkster Maz, and the company name is Farm Meds Limited. That is the company that I represent. They were established in 2013, and they're one of the individuals that you've heard that has submitted an application to Health Canada to become a licensed producer. They own a property in Waterdown. It's an existing building. Now, my comments here, and the punchline, what I have to tell you is that my clients can live with the recommendation that you just heard. They can live with it. They don't like it, but they can live with it. But I have instructions to tell you a little bit about why they don't like it, and I want to just do that very briefly. I got 5 minutes. I won't take more. I'll be less. We need to remember where we start from, and the starting point is this: that marijuana is a plant. In that sense, it's like any other thing that we grow for consumption, whether it's wheat or mushrooms, eggs or pork. These are all agricultural products. The NEC's position on this, I haven't seen it in writing. I don't get it. Unless they're relying on some definition in the NEC plan that somehow distinguishes one plant that we grow for consumption from another, I don't understand why they're saying that growing marijuana isn't an agricultural use. It clearly is, and your staff came to that very conclusion, and they were right. Now, it's a controlled substance, so it's regulated by the federal government, but that doesn't change its essential character, its agricultural character. We have quota for chicken. That doesn't change growing chicken from being something that's not agricultural. Some agricultural products are grown largely indoors: mushrooms, greenhouse vegetables, chicken, turkey, dairy, and there's others. And now we have marijuana. So from a planning perspective, marijuana is simply part of a class of agricultural products that requires generally structures to be grown. Now, I know staff have said it's different. And what they said at page 8 is that it's different because it requires a secure storage area, there's a lab involved, and that all the product is shipped elsewhere. That was their comments. And I respectfully disagree that those are distinctions that mean a difference. You talk to farmers, and most of their stuff is shipped elsewhere, sometimes all over the world. There's requirements for pork barns that don't apply for other things, like in terms of manure storage. That doesn't change its essential character to something other than agriculture. So those parameters don't change that, in my respectful view. So the fact that all of that is true is why this initiative isn't needed for my clients or anyone else who wants to grow it in the agricultural area. You have to understand that today there is no restriction on them doing no caps. The initiatives is required for the urban area, and we have no objection to that. And we understand that staff see that as an opportunity. Great. This isn't an effort to control competition. What we're saying is you're actually proposing a downzoning in the agricultural area for people that want to grow marijuana. It's from a time where no caps to now you want to put on caps. And I have to say, the vision for the rural area is predominantly a place where people work in agriculture. And sometimes that involves buildings, sometimes that doesn't. But it's a place of business. And yes, you've got to meet the environmental standards and performance standards. Those are all important. But because you might have a big building in some locations is not a reason to say that we need to cap it or that it's a problem. It's part of agriculture. So we say that it's a mistake. It's a downzoning. It's one you should not follow. And I say that respectfully because staff have worked hard on this, and I know that. And they're well-meaning, and I get that. But I just don't think it's the correct path. Because if you're going to do it for marijuana, you really should be doing it, looking at it for turkeys and greenhouses and mushrooms and everything else that might include a building. So I think it's discriminatory. I think it's a mistake. But can we live with it? Yes, because we have an existing building. And 2,000 square meters is a lot better than 500, which is what was originally proposed. We could not live with 500. Okay? But we can live with this, and I'm trying to be honest with you about that. But and I will say one other thing. Page 13, what staff suggests is let's monitor it. And I think that's the best advice you can get. You don't need a cap, you need to monitor it. Thank you.
And thank you for staying under the 5 minutes. Councillor Whitehead and then Councillor Partridge, please.
Thank you. It is amazing how a lawyer can take something that is an illicit drug that is being regulated heavily and classified as and make the comparison to turkeys and other cash crops when clearly this is unique in the concern and the public realm. So I'm trying to understand how you equate something that really needs very little refining in regards to people accessing it and utilizing it versus any of the other products that are grown in farms.
Through you, Madam Chair, this is from a land use planning perspective an agricultural use. There are moral and concerns, health concerns, that are regulated not by a municipality through a zoning bylaw, but by Health Canada through the regulations. And they have very strict security controls to ensure that my clients will be obligated. It's a major investment to be able to get this up and running, but it's not a controlled substance in the sense of like chicken where there's supply managed. So it's a competitive market too. So you have to understand that a farmer coming to this is still a farmer, even though there are these other dimensions they have to get approvals for.
Councillor?
Okay. The other thing is I think it's the type of buildings that are going to be required on the new regulations in regards to that safety and security.
Yes.
I think they're trying to contemplate those demands. And I think the question, and I think it's raised in this report, is what is the character and the landscape of our agriculture community, and do we want it to take that change? Because these type of structures and buildings and facilities are somewhat out of the norm for the agriculture community.
So the question?
I'm asking if that's the argument.
I understand that, and I would submit to you that there may be the odd large building that's using this, but there are In other parts, grain elevators, not here in Ontario, but in other parts of the country, that's agriculture. Silos are agriculture. There are large pork barns. There are large other facilities. That's just part of agriculture doing work in the rural area. And I speak for farmers often, and they react strongly to the notion that landscape is there for us to sort of drive through and enjoy as an open space. There's a dimension of that will always be there. But when farmers need buildings to do their business, we should facilitate it, not frustrate it, in my respectful submission.
Thank you.
Thank you. Councillor Partridge.
Yes, thank you, Madam Chair. Nice to see you again, Scott.
Thanks.
So my question is around the Waterdown location. You mentioned you're in Waterdown. Are you in is your client in the urban or the rural area of Waterdown?
In the agricultural area, yeah.
In the agricultural area?
Yes.
Okay, so not in the industrial zone, not anything to do with that. And the existing building, what size is it?
It's about 2,000 square meters, as it turns out.
Wow, isn't that handy?
It is handy, yes. And of course, it would permit the existing use anyway, so if it was larger, it would still be okay under the new proposal from staff, which is why I said, and I'm trying to be frank, we can live with it, but we don't like it.
Yeah, well, I also wondered why you're just a very calm and good presentation today, and not.
Thanks.
So my last question through you, Madam Chair, is the size of the property. Because the changes that we've got here says it would allow for additional buildings in the agriculture area.
I'm looking at my clients. I don't know how big the property is.
So it's about 10 acres then?
Yes.
All zoned agriculture as far as you know?
As far as I know, yes.
Okay, thank you very much. I appreciate that.
Thank you.
Thank you, Mr. Snyder. And can I have a motion, please, to receive Mr. Snyder's presentation? Councillor Pearson, Councillor Partridge, all those in favour. Thank you. And I have Bill here from First Access Medical. Believe? I'm sorry, Bill. I would like you to pronounce your last name for us, please. It's an awesome last name. I'm just not going to butcher it.
Hello, Council. My name...
And you have 5 minutes, please.
Yes, my name is Bill Paniatakopoulos. I represent First Access Medical. I'm the CEO and partner there. We started our endeavor into this marketplace this time last year, at which point we came in and met with the City of Hamilton, both the building and the economic development offices. Since then, we've had literally dozens of meetings of how to evolve our business and how to become competitive and be able to grow to meet the not only demand but the marketplace rigor that's going to be imposed on us. There is a direct correlation of economies of scale in this, just like in any other agricultural business. If we're limited in our size, you can't compete. Now, what we originally had planned out to do is build a building that did not exceed actually the 11.5 meter height, but it was larger and it was multiple levels in that the square footage, the floor plate was large to accommodate the building on our particular site. So we've had many meetings with regards to that, to be able to do that. And everything up and until the June 17th meeting was very positive. Everybody was very supportive. Economic development, building, everything was good. And then, of course, we got hit with a 500-meter rule, which literally shut us down completely. And then in that council, they said that the existing people who have been working on this since before the meeting and like we've been doing it for almost a year now, we're going to be grandfathered in and excluded from any further, bylaws that would be imposed. And to that point, we were contacted 3 days later on June the 20th and requested our criteria of what we're looking to do. And we responded in kind and gave our vision and our plan. Again, not exceeding the height, and in our particular location, visibility is, you wouldn't even be able to really see it because of our tree coverage and our setbacks. And after that, we met with economic development and building again to move forward because we have a considerable investment in this. We have passed the $5 million mark. So we went back to our investors, to lawyers, to everybody and announced, listen, this is fine, the 500-meter rule, we're not going to be held to that. We can develop our business so that we can be a competing entity in this enterprise. Again, in our opinion, being small is not going to work for the future of this industry. And again, multiple meetings, everything went fine. And then last week we heard of the 2,000-meter rule, which complicates our site because we don't have 100 acres where we can do multiple 20,000 square foot buildings, and also the nature of the building and the crop that you're producing and the security protocols that you're going to be dealing with in that lend itself to having one facility as opposed to having multiple small ones. So we now wanted to, as a group and as a company and our investors, and want to understand why we were excluded. I guess our interests were excluded from this report, where we don't necessarily want to go higher than the 11.5 meters, but we did want a larger floor plate of more than 2,000 square meters, and we also wanted to do multiple levels. That's the best, most efficient, most economical use of the building. Oh, sorry. I thought it was
1 minute.
Oh, 1 minute. Okay. So I guess the question now is that we've been working really hard. We've been completely transparent with the City of Hamilton, multiple meetings. We've put out our plans and our proposals. How come, and we were asked to grandfather in by sending our application. How come we haven't been grandfathered in with respect to our requests? They're not that far outside what they've come back with. And how do we move forward to be able to move our business plan as been outlined to the city over the last year?
Thank you, Bill. Councillor Whitehead. Questions to the presenter?
What's the location?
It's on Highway 6 in the 10th concession in Flamborough.
What is the acreage of your property?
It's 17.78 acres.
How much?
17.78.
This is not a farm currently then?
It's not a farm, no.
What is your square footage that you're looking at?
We were looking at up to 180,000 square feet, multiple level.
You have a license?
No.
But you have a significant investment, but you have no license?
Yes.
Those are my questions.
Thank you. Councillor Pasuda.
Thank you, Madam Chair, and welcome, Bill.
Thank you.
When did you first put in your letter of intent through you, Madam Chair?
It was last year with the Hamilton Economic Development Office.
Last year, 2013?
Yes.
Okay. Where the building is, or the potential where it's going to be, and there is buildings there now.
There is, yes.
Visibility from the road?
Minimal. You would have to enter into the driveway and drive about 100 meters before you can really have a visual of what's back there.
Councillor?
Okay, thank you, Madam Chair. What's it zoned for right now, the property?
It's agricultural.
Agricultural zoning on, okay. Through you, Madam Chair, you yourself, Bill, sounds like a court of law again, sorry, but you yourself, Bill, you're a farmer, a farm background, your partners in the business?
No. Primarily, some of the investors and our partners are from the medical community, doctors, PhD.
Councillor?
Okay. Bill, can you translate 180,000 square feet into square meters?
60,000? No. I think it's 18,000 square meters.
Factor of 10.
Yeah, factor of 10.
18.
So 18,000 square meters. And that's our up to point. It might be different depending on the style of building and exactly what's going to evolve.
Madam Chair, through you to Bill, then on the Appendix E that's here, it shows here existing building of 1,133 square meters and a future expansion of 21,168, total of 22,304. But you're okay with the 18,000 you're saying here today?
Yes.
Right. Okay. How much money do you, through you, Madam Chair? How much money do you have invested at this point in time in this project?
All parties, we've passed the 5 million mark.
5 million. Thank you. Councillor?
What's the value of this project in total dollars to have it all up and operating?
Up and operating, how much?
After operation, we have a go public, plan for this. As soon as we are licensed, we'll have a book value of $60+ million.
Plus million. Councillor?
Thank you, Madam Chair. So through you to Bill. Bill, how many employees would this operation?
It would be in excess of 125 employees. And that number will become more clear after the construction and as the duties and responsibilities and we factor in some automation.
Thank you for that. Madam Chair, through you once again to Bill. Are you connected to any research and development organization within your...
Yes, actually, our partner, Roger Ferreira, PhD in neuroimmunology, we're working with the Western Research Institute. We've also started conversations with the Health Sciences Department in Hamilton. We will be dealing directly with McMaster University and Hamilton General.
Councillor?
Running out of questions. Sorry, Madam Chair. Bill, you had through you, Madam Chair. Bill, you had mentioned that you had met with the Economic Development Department. And I'm going to ask the question of them later. I do see some people here from that department. Do they think it's a good plan when you talked with them?
They've been very supportive. They've worked with me along the way. They're pro the business. And they understand that the jobs that we're talking about are not general labor jobs. We're talking everything from research to, I have the list here actually. There's a high degree of technical ability that is required for almost every position. So it's not going to be a general labor. They'll be very high, well-paying jobs.
Councillor?
Okay, and one more question, and I might be prodding here, but this is a lot of coin you're putting into this project, a lot of money. No guarantee you're going to get a license. Nobody has a guarantee, as far as I know, if any of these projects.
I agree. Constitutionally, in Canada, anybody can get a license. There's no, it doesn't state anywhere you can't. So provided you abide by the rules and regulations of Health Canada and the Office of Controlled Substances, you can get a license. Now the barrier to doing that is a financial one, because to abide by all their criteria, and it's more stringent than a pharmaceutical company, you have to spend a lot of money, a lot of time, a lot of energy, and a lot of people believe that this is going to be a business that's going to thrive and do extremely well in Canada. Canada right now is the global leader with its licensing program and its ability to supply this product globally.
Councillor?
Okay, and probably got two more questions, Madam Chair, if I may here. So, Bill, with your letter of intent back last June or last year, whatever, was it included for the 22,300 square meters at that point in time?
At that point in time, we were developing our size and our strategy. Since then, we looked at some facilities down in the urban area in Hamilton. In fact, we had a deposit down on 391 Victoria, plus engineering costs, and well, the deposit alone that we forfeited was over 50,000 plus a lot of engineering costs that went into it to get to that state, until we were informed by Health Canada that there's a 150-meter rule setback from residential. So they will not allow you to do this within 150 meter, and that precludes most of the commercial in Hamilton, and especially since we've been looking and there's less than 2% vacancy, it doesn't allow for you to be in Hamilton's, I guess, urban area.
Councillor?
Okay, and one final question, Madam Chair. So, Bill, indication towards you that if you had a letter of an intent put in place that 5,000 or the 2,000 square meters was going to be an issue? Have a feeling of comfort that what you had put forward you were going to be grandfathered into?
Like I said, yes, we were actually led, and again, we've had a lot of support from everybody, especially the Economic Development Board, and at no point was there ever anything that said that you will be limited to the square footage. They viewed it as agricultural. They like the business. They like the parameters that the federal government have put around it, in that the security requirements, the background checks, the protocol, that it's a good business to bring in. It complements the health sciences and their their building of both the educational and the health departments in Hamilton. They saw the synergies there. They were pro the business, come, and build. And at no point did anybody say, hey, you know what, you're going to grow something, we might want to limit it, because we just don't know enough about it.
Thank you, Councillor.
And sorry, Madam Chair, just finish up here. So, Bill, this report here, this 8.3, did staff consult with you during this, putting this report together?
No, I was presented that report just as a matter of fact. This is what we're going to do. And when I had obvious concerns and questions about it, it was met with, this is it.
Thank you, Councillor.
Thank you, Bill. Thank you, Madam Chair.
Thank you. So I've got Councillor Partridge, myself, and then Councillor Whitehead for a second time.
All right, thank you, Madam Chair. Bill, welcome. Thank you for your presentation. My ward colleague here did ask some good questions, but just one clarification. I heard you say that you met with economic development folks. Have you ever met with the planning department?
I've met with the building department.
Met with the building department, but not the planning department, who's actually the author of the report?
No.
Okay, all right. That's an important clarification because I want to make sure when we're asking staff these questions, you didn't hear back. Did you have any follow-up meetings?
Only the request to grandfather in our request of the size, the location, the structure, just the broad thing. And quite frankly, I was surprised with that, and so was everybody else. We assumed it was a non-issue because if planning or somebody was to impose any rules and regulations on this, who best to go to than the people who have been involved in it for over a year now, developing the business, to ask, hey, what's a good idea here? This is what we're looking to do. What are you guys looking at doing? Because for the most part, aside from the security protocol, which the federal government has and the Office of Controlled Substances has laid out, most people have no idea what these structures look like, how they perform, how they act. The fact that they're hermetically sealed, there's no air that passes in and out, how big your processing area is, which is less than 5%. There's a lot of there's a lot of moving parts to this, and I was not consulted on any of that.
Okay. And if you hadn't met with the planning department, that might explain why. You received letters, you said, from staff at various times?
I received an email requesting the size, location, and what our plan is because of after that was on June 20th, because June 17th they wanted to somebody made a motion to grandfather in the people who have already been going through the process, have already made the investment, have already been led down the belief that that Hamilton was good with his business and pro it. I was asked in that email to identify the square footage and what we're planning on doing. And I did. I responded in kind, and I'm on the amendment.
Councillor?
So you have, thank you, Madam Chair, and through you. So you have this in writing then in an email that you would be grandfathered?
I don't know the exact verbiage of it. I don't think somebody said we're gonna let you do this, but the sentiment of it was we're not opposing this. Go ahead, evolve your business, and that's why again we have a lot of accountability, a lot of oversight from our investors, their lawyers, our partnership. Like I said, there's a lot of very well-rounded people backing this endeavor. At no point did I ever feel it necessary to go back to them and say, we will be limited. I did that after June 17th. I said they proposed limiting it to 500 meters, but they withdrew that and they want to grandfather in the people who are currently working on the project, us included. June 20th, I received the email and then I responded in kind with what we're planning on doing. Since that point, nobody at any point gave me any indications that I was going to have any difficulties to evolve the business to where we had always talked about and move it to.
All right, and thank you for that through you, Madam Chair, but I'm going to bring you back to the grandfathering part of it because that's what's of interest to me is if you heard it verbally in conversation.
I believe
or you have it in writing?
In the council meeting, it was mentioned, I believe, at 4-hour and 21-minute mark.
Okay.
The councillor said we should grandfather in the people in it, and I believe somebody else mentioned it. that was my indication that, okay, so the people who obviously spent the time, energy to work at this are going to be recognized and be able to move in the agricultural capacity without any limitations, and more importantly, without any biased impositions.
Right, but just to clarify, Madam Chair, just to clarify then what you're talking about when you heard about the grandfathering, it was a discussion around this table?
No, I'm going to clarify. I didn't hear about it. I was told in the council when I spoke last time that there was going to be a grandfathering. 2 councillors spoke about it. Then I was sent an email asking exactly what I wanted to put in as my project, and I responded.
Okay, thank you very much. Those are my questions.
Thank you.
Thank you, Councillor. I know that Jason would like to add some comments after we're finished with the presenter, so could you please take the chair? I just have a quick question for Bill.
I will. Go ahead, please.
Bill, one of the concerns that Councillor Ferguson and I mentioned about being out in the rural area is that these facilities require security, demand on water, as well as utilities. So where you're located right now, or where you're proposed to be located, are you serviced by water?
I have wells. Yes.
You have wells. Okay, so one of the comments that you made was that that you wouldn't be very competitive if you were given these restrictions out in the rural area. Is being out in the rural area beneficial to you as far as you don't have any water bills? So that in itself is giving you an upper edge, does it not?
Yes.
For your competition? Okay. So I just wanted to clarify that with the utilities. And I'll take the chair back, and I've got Councillor Whitehead for the second time, please.
Thank you. It was 180,000 square feet you were talking about?
Yes.
Opposed to 2,000 square feet.
2,000 square meters is what's been proposed, which is, yeah.
I'm just trying to think, when you're looking at investors making that kind of significant investment, have you built anything yet?
We've retrofitted the existing facility.
Okay, and you've already done the studies in regards to the aquifer and the ability to service 180,000 square, is it feet?
Yeah.
Facility with water?
Yes, the water study, the water is not an issue with the aquifer being available. I have, under agricultural rules, I have 44,000 liters a day allocation without needing to go to the Ministry of the Environment and ask for more. Highway 6 is the corridor for the 27.6 kVA lines. Those are the trunk lines, the power lines that run right up into Guelph. And there is, as the hydro-tech told me, unlimited power.
Would it be through the chair, would it be unexpected or reasonable that perhaps there might be a limitation on the size of a building in the agriculture community? So, for example, do you think it was unlimited? Do you always believe it was unlimited? So we could have had, 100, 200,000 square meter facility on an agricultural lot growing marijuana?
I understood there always to be a height restriction. After that, I've never heard of any barn or any chicken coop or any kind of limitation on actual floor plate square footage. And I've seen some absolutely enormous barns like that. The height, I understand, it's a visual thing, and we were never proposing, or we don't need to go past the 11.5 meters. But as far as the square footage, that's an arbitrary restriction done without enough. There's nothing to back somebody saying that don't go bigger than this. I mean, the security protocol and the amount of oversight by the federal government, both by Health Canada, Office of Controlled Substances, and RCMP, preclude any major breach in security. The facilities are built properly. They're monitored both by Ottawa and at least 2 different licensed security companies. So when you pass those types of hurdles and when you pass that type of rigor, you don't expect to be limited on the size of your building because of an arbitrary agricultural doctrine that really has no application to your business.
Yeah, I think planning might disagree with that. The other question I have is, this facility, would you be paying the reduced agricultural tax rate, or will you be paying a higher tax because you're manufacturing something?
We've taken into account to pay higher taxes, but that has never been proposed to us, or we haven't talked about that in any detail with the city.
Councillor, thank you. Can I have a motion, please, to receive Bill's presentation? Thank you, Bill, for coming out today.
Thank you.
Councillor Pearson, Councillor Pasuta, all those in favor? Thank you. You have 8.3 in front of you today. I've got a list of speakers who want to ask questions to staff, and I'm starting off with Councillor Pasuta. You had questions for staff?
Thank you, Madam Chair. Yes, I do. Through Madam Chair, with the potential of this project going forward, and we're looking at a requirement of a site plan, hydro-G study would be needed. Would that be right?
Madam Chairman, yes, a hydro-G study would be required.
Councillor?
And what about the disposal? What happens to disposal of remnants from when they grow the flower? Is that under our jurisdiction as far as what we can tell them they can and can't do?
Joanne?
They only use the flower, so.
Joanne?
Through you, Madam Chairman, Health Canada regulates disposal. And so they can't dispose of anything that has remnants. What they do is that they take my understanding is the leaves, and they bathe it in a chemical bath to kill any molds or THC that may be remaining. But that is tightly regulated by Health Canada.
Thank you. Councillor?
Okay. Madam Chair, do we know, maybe we don't through staff, what's the largest greenhouse operation we have within the city of Hamilton in square meters? Do we have any idea?
Does anybody know?
We have some massive ones, I know that.
40,000, I heard. Yeah.
Through you, Madam Chair, we don't know exactly, but what I can say is that the greenhouses are a series of multiple buildings. There's not one building that is excessively large. They generally have a series of structures.
I understand that from that background. Okay, but they also could have a series of buildings for medical marijuana too on a property. Same thing, correct?
Through you, Madam Chairman, yes.
Okay, thank you for that. I guess this is maybe a question for economic development planning. Madam Chair, I guess Norm's going to come forward.
Good afternoon, Norm. I know you've been dying to jump in here, so Councillor Pasuta, your question to Norm.
I'll be easy on you, Norm, real easy. What's the economic benefit to the City of Hamilton in having an operation, all of them, okay? I don't care which one it is, all of them, whether it's the one that Bill was just here with us or the smaller one, or where Scott Schneider had the one here. What's the benefit to Hamilton out of this? Not only as far as, and you can go with jobs and whatever too, but the tax benefit in one way. Can you just kind of go on with that, please?
Through the chair to the councillor, I mean, there are the obvious economic benefits from a tax standpoint, from the assessment that will be generated from that. I guess more so with these operations is the type of employment and the high-end type jobs that we'll be creating. There are some high-end research jobs that will be affiliated with that, and that does help enhance both our life sciences sector here within the City of Hamilton, which is one of the key sectors that we're working on to diversify our economy, but as well as the ag side as well. So it does fit into actually two sides of our economic development strategy.
So through Madam Chair, so Norm, you do see medical marijuana operations working with the McMaster and different health associations within Hamilton?
Yes, I do. There's definitely a lot of potential for growth.
Okay. Property tax. I know we as farmers get a break on our property tax based on the agriculture and the $7,000 we produce. Is there any way, and these buildings will be producing a good income, is there any way it's this property, agriculture, but how can we benefit through the taxation department to get something out of this? Can portion of that building, that lands where the building are on, be commercial or commercial industrial? Is there anybody here who could answer that question?
Through the chair to the councillor, I can't answer that question. Mr. Zager could probably be the best individual or someone from his office to answer that. I don't know how it would be assessed, given that it is an agricultural building or an agricultural use. Ed, I'm not sure if you have any. I think we'd have to defer to finance to get the clarification.
And Just to throw this in here, I did ask that question, but on the reverse side, if the agricultural was in the urban area, would it be now deemed agricultural and taxes? And there was no clear answer for that either. So it's just the reverse question.
Yeah, it's true. Thank you, Madam Chair. So, you know, I really look at this, there's two sides to it, and you're kind of caught in the middle. It's a crop in one way, and another way it's what it's been known to be, but we're looking at a crop here. It produces a lot of good jobs. I know the residents are concerned about security. Have we had a conversation with police as far as security, increased police forces needed to monitor anything? We had those discussions, Madam Chair?
Madam Chair, the police are very much aware of this. But as I've said before, the security is tightly regulated by Health Canada. So they have quite significant measures to deal with security. The police will know where they are.
So, Madam Chair, so another point came up about the building itself and the way they're closed in, and we're not sure what could be, maybe I heard it wrong, what could be within these buildings at some point in time? Because of security within them? Is that an issue for staff?
Through the chair, the security requirements are set by Health Canada, and they will be inspecting those requirements. We will not be seeing those.
Okay, so through Madam Chair then, so we as a city do not have concerns once these buildings are built what goes on within the building. Is that true?
Madam Chair, I'm not understanding the focus of this question.
Well, I thought I heard we had some concerns, Madam Chair.
Oh.
Had some concerns about what could happen, what could be going on within these buildings, being that they're closed in, virtually closed right in.
Through you, Madam Chair, Ed can follow up on what I'm about to say. I was talking about them being hermetically sealed, and should they leave for the adaptive reuse in the future.
Okay. Good enough for now. Thank you.
Thank you. I just have a quick question. You've got your hand up. Sorry, I didn't see it. So, Councillor Whitehead.
Yeah, can I understand the limitations that we put on it? It was 2,000 square meters. So is that about 6,600 feet or thereabouts?
You, Madam Chairman,
Can you give me that in feet, please?
It's about a factor of 10, so it's 20,000 square feet.
20,000?
20,000 square feet.
And so the proposal that we heard here earlier was 180,000. When you look at the other jurisdictions, you indicated that no jurisdiction is looking at rural other than, I think it was Ottawa looking at industrial industrial zoning.
You, Madam Chairman, what I was saying, some allow it in the rural area with no restrictions, but there are several municipalities who are moving or have moved towards allowing it in the urban area only, with no restriction on building size.
Okay.
Councillor?
So on the ones that are allowing in the rural, is there any building size limitation?
Through you, Madam Chair, of the ones that I know locally, no, they deal with it through setbacks, and they do have in different forms. One municipality used lot coverage.
Councillor?
Okay, and you heard that, I think I heard 17 acres for the one that we just dealt with. So we're looking at 180,000 square feet on 17 acres. Is that proportional relative to any other best practices or what the other examples you were referring to?
In terms of lot coverage?
Correct.
Thank you. Lot coverage, Joanne?
Through Madam Chairman, the only lot coverage regulation that we deal with in the rural areas with greenhouses, which can range from 60 to 70%.
So I think the question was, we have 17 acres, you've got 180,000 square feet. Does that fall under that best practices for lot coverage, correct?
Yeah, would it be, in that context, would it be prohibited or would it be allowed?
You, Madam Chairman, lot coverage is based on a footprint.
Right.
So depending on what the footprint is of the individual building, it could easily meet that because it's not a GFA, it's a lot coverage.
So it could be multiple stories.
Yeah.
Right.
Well, there's a limitation, I heard,
Right.
11 meters or whatever. Or
11
was it?
and a half.
Yeah. Can I ask through to here, taxation?
No.
Can
And
anyone
that
answer that
question was
question? How this would be taxed? Would this be a facility like this, 180,000 square feet,
And
research? Would that be tax agricultural or differently?
And it was asked, and it was not sure. And it was asked previously to Mr. Sigarik how that would be if it was in the urban area, would it be taxed agriculture?
Yeah.
And nobody understood that either. So I don't think their answers are clear yet.
So they got to classify that.
Sorry? Mike, sorry?
Madam Chair, through you, I can assist a little bit in that.
right.
I don't believe MPAC has assessed any of these facilities yet. So MPAC doesn't necessarily assess based on zoning. MPAC looks at what
Right.
the use is and assesses based on the use. So there is the possibility that if there is a significant amount of research component in there, there could be a certain component of the use assessed as a non-agricultural component, because assessments can be mixed also. They don't necessarily have to be just one category for a property, but it is a use-based assessment as opposed to a zoning. So they look at what the actual use is.
So institutional. So go ahead.
Appreciate it. So the example we just saw, I mean, I guess I need to try and bring it down to the 2,000 square meters, which is 20,000 square feet. We heard this group wants 180,000, which is several times more than what is anticipated, which is huge. I need to understand how we arrived at that number.
Joanne, how did we arrive at 2,000 square feet or square meters?
Through you, Madam Chairman, on the basis of the letters of intent that you, Planning Committee asked us to find out what the sizes were of the proposed, the existing buildings, we looked at what the average was. And as I noticed in terms of the buildings that were existing, of the 7, 6 were under 2,000 square meters. Again, as I had said to you, there's no magic bullet in terms of size, but we looked at the letters of intent. There were 2 or 3 applicants who were looking at future expansions in excess of that, with no indication of how many buildings that would entail.
Thank you. Councillor?
Thank you. But you also, in this bylaw, enabling the size of the building be 2,000, but if they could build other buildings at the same size on the same property, correct?
Joanne?
Madam Chairman, there could be multiple buildings of 2,000.
Thank you.
Thank you.
Thank you. So I've put myself down, and Councillor Pasuda's number is on the second list. Councillor Partridge, if you could please take that. Yeah, thank you.
I got it.
On that segue, Joanne, and it's a very good question, with our greenhouses out in the agricultural.
Go ahead, please, Councillor.
Thank you. So my understanding is the Federation of Farmers came forward to help with the rural zoning, and part of their concern, and we addressed their concerns through the process, was lot coverage. And they felt the lot coverage could be a lot greater than what the staff was producing. Hinging on the question that if you've got 180,000 square feet and the lot is 17 acres, and if it falls under that lot coverage that's going forward for the rural zoning, why would we not allow that if it's considered the same as a greenhouse would be in that respect?
Joanne?
For you, Madam Chairman, we don't necessarily consider it the same as a greenhouse, but lot coverages could be very large. So I'm not great at math, so you're asking the wrong person. So if you had, let's say, 18 acres, 70% of 18 acres.
It would be a lot.
It would be a lot. Yeah. That's why we didn't go to a coverage thing. Generally, greenhouses also develop on smaller lots, and in many cases, we see that they actually take up the whole area. There are certainly greenhouses on larger acreages, but a lot of them are on smaller acreages, and they take up 70%, which is what exists today.
Okay, so through you, Chair, we've got a 2,000 limit in front of us, and your answer was, we have 7 letters of intent, and we looked at the majority of the ask, and the ask was under 2,000. But we now know that there are others in those stack of letters that are well above the 2,000. How do we reconcile that when we've got people coming forward saying, we've got a viable solution, here's what we need to have done? So are we asking the applicants now to go through a series of process and committee of adjustments and variances to accommodate something that could be rectified right now?
Joanne or Steve?
You, Madam Chairman, the committee has options on the table. They can, based on the letters of intent, allow these individual properties to have a certain square footage based on those what's contained in Appendix E. That's what they could, and then they could leave it for all other letters of intent that come forward. They would abide by the 2,000 square meters.
Okay. One of the alternatives I read was that we don't make any changes to the bylaws, that we just treat this as it's agriculture. The existing agricultural building provisions would apply. If that were the case, would this 180,000 square foot application go through with little or no fuss?
Through you, Madam Chairman, yes.
It would go through with no fuss.
Madam Chairman, if the idea is that that there be no regulations on medical marijuana, then it would be subject to your typical regulations for any other agricultural building.
Okay, those are my questions. Thank you.
All right,
I'll take them
the chair
back, and I only have Councillor Pasuta down. Second time.
Thank you, Madam Chair. Through you to Mike, to legal. Hope I can phrase this properly. If we were to, I'm just fishing here, okay? So if we were to just, the ones that are before us here right now, letters of intent with the sizes they have up to here, what they want to potentially build, if we were to say we're okay with this, and then regulate the rest down to 2,000 square meters, is that an issue legally? Grandfathered? If we grandfathered in what's here, allow this to be grandfathered and go forward, and then we put within the bylaw 2,000 square meters. Is there potential for a legal challenge there?
Through you, Madam Chair. Councillor Pasuta, I haven't had time to consider that issue, but it does raise some thoughts off the top of my head. One, the Planning Act already provides for grandfathering in it for legally established uses. That's usually how you get grandfathering with respect to zoning. I'm concerned that if you provide, I wouldn't call it grandfathering, I would call it more of an exemption from a zoning bylaw that you're passing, and what would the basis of the exemption be? Mr. Robichaud may have some comments in this regard to how we've conducted ourselves in the past with other matters, which I'm not familiar with. So my concern is if we're providing an exemption, what the basis of that exemption is, and why wouldn't it be given to someone else who comes in shortly after these letters of intent. So that's the concern I have, and in order to answer the question properly, I'd have to go back and re-examine this issue. But at first blush, it does cause some thoughts to go through and have some concerns which I think would need to be examined if you're going to provide an exemption. I wouldn't call it grandfathering because there's no established use. It's, in my mind, it's an exemption from a bylaw that you're passing.
Madam Chair. So, Mike, have you had any contact with Health Canada and their legal department on this issue with the medical marijuana? through your offices?
Through you, Madam Chair, I have not been involved with the matter, and I do not know if any other council in the office have been in contact with Health Canada on this.
So I guess I'm going to go with the planning staff then. So if we were just to treat this, and you've done a lot of work on this, believe me, it's been quite the file here. If we were just to treat as agriculture and just move forward, and then it's based on land coverage and Ed, right? I think Flamboro's at 20%. My part of my Ancaster ward is, I think we're only at 1%. We had that issue with one of the grain elevators. Does that help in controlling some of the size of these buildings? Because personally, I believe this is going to end. There's only so many that are going to be built, only so many are going to be licensed, and then they're done. And I'm going to be honest here, I think a few of the guys, a few of the businesses that are trying to set this up, if they build, they could go bankrupt because they're not going to get the license from Health Canada. I see that coming. So just a word of caution to even the people that have in mind about going forward and building these and trying to get them licensed. It is going to be an issue. So the point is here, I'm looking to staff here for comments, and anybody up there, please, okay? This is important stuff here we're dealing with. And what's the thoughts on just letting this go as an agricultural venture and not putting a control on the amount of land coverage other than what's in place now through the building department that Ed Vanderwint looks after? Comments, please.
I can, through you, Madam Chair. That certainly is an option that's on the table, and it's an option that was considered by staff as just treated as any other agricultural use. I think the challenge with this one is we're dealing a bit in the unknown. That you may be exactly right. We may never see any more letters of intent than this. There may only be 1, 2, 3 licenses issued in the city, but we don't know that. So the idea is, do we want to get out in front of this, establish some basic rules and regulations that this industry will have to abide by? The option would exist in the future if there are additional applicants that come forward. They can go through the planning process as any other applicant would to look at minor variances or zoning bylaw amendments to accommodate their use. But this is, as you say, you're wrestling with it. We as staff wrestled with it because we are looking at a new industry, and we don't exactly know what form it's going to take, how many of these applicants may be coming forward. But the option of just leaving it as agriculture was put forward as an option. And if it is only 2 or 3 applications, buildings that ever get built, then maybe it's not a big issue, but it may be many more than that. We just don't know.
Madam Chair. So, Jason, and I don't know where to go with this. We've talked about the tax implications. Can that building that's growing and has a lab in it, can it be taxed commercial industrial? Can we draw from that? Because, and then the whole building or just the part that's got the lab in it? Because there is an implication, there's some potential for some good taxes coming towards the city.
Through you, Madam Chair, I'll let Mike confirm, but we don't have any control over how MPAC ultimately decides to assess these buildings. It'd be probably an easier debate to have if that had already been determined, but we just don't know.
And I heard that. I was just trying to maybe somebody would slip the tongue here. So through the planning then, so Steve or Joanne, we've gone through things. Like I've got a couple businesses out there that got a little commercial part on their property, and then the rest is residential. That was all done through impact then, in their time? This has been before amalgamation, Madam Chair. So,
to you, Madam Chair, I don't know the answer to that unless someone else in staff would know how that was assessed at the time. In terms of Flamborough has an M3 industrial zone.
Okay, just one more. E.D. Smith, they were processing their and packing. Was that all agriculture, or did it have a commercial aspect to it? Industrial aspect to it?
Through you, Madam Chairman, E.D. Smith is actually in the Niagara Escarpment Commission lands. They do have processing. Their tax implications, I'm not aware of.
Okay. Madam Chair.
Actually, you wanted to ask some questions?
Yes, please.
I'll
So
take
if
the
you
chair.
can take the
Thank
chair,
you.
thank you very much.
Yep.
So we're taking a look at this. We're seeing some new things coming in. Mr. Thorne's very right. It's something that we wanted to get a handle on it before it continued on. So when I'm looking at a facility like this, I'm looking at it similar to the mushroom facility that we were talking about the other day at GIC. So we've got, or at planning. So we've got obnoxious uses. And this is, and trust me, if it's not done properly, you can smell it, and it's not that great. What's to stop us right now from carrying on as usual, with the exception that we put an MDS rule on this, as you do with a hog farm or a cattle farm? There must be an MDS involved because minimal distance separation. So it's no different than it has to be so many meters away from residential, because I see a 20-meter lot line here. That's great as long as the house that's next to it's not sitting right up against that property for whatever reason. We've got 150-meter setback in the urban area from residential, as the last speaker said, that they couldn't. So what I'm asking right now is, can we not just treat this as agriculture with the MDS in place to ensure that this is not going to have a negative impact on the neighbors surrounding, but we treat it as an agricultural use under the federal government's regulations, where security comes in and types of buildings and methods of operations.
Steve? Ed?
Through the chair, I can add a couple of thoughts. The setbacks are being set by the federal government.
Right.
That's not within our control in this particular case. And just to clarify the question that Councillor Pasuda had earlier, in the new proposed agricultural zoning, there will be no minimum lot coverage.
I'm sorry?
There will be no maximum lot coverage for agricultural buildings.
So just to be clear, through the chair, if I'm a farmer out in Glanbrook and I decide to put 100 buildings up on my farm, a real live operational farm, then there's no limit to how many buildings and how much lot coverage it takes up, correct?
In the proposed zoning bylaw, that's correct.
If they propose. But however, having said that, we still have MDS involved. You still have setbacks from the property land, correct?
So MDS refers to livestock only.
Yes.
It refers to nutrient management. It refers to the manure, distances from other buildings and properties. That's correct.
Thank you. And through you, that was my question. Could we apply MDS, but under this regulation, we'd call it maybe something different, but it'd be under the same heading, is that we have an MDS rule so that the people that live in the area are not going to be affected by this in a negative manner.
Through Madam Chairman, MDS is a mathematical calculation based on what the inputs that OMAFR has provided based on livestock units. We would not have an equivalency just to say that you would be able to say that one plant equals one cow.
100 plants.
You would have to have some sort of comparable to do that mathematical calculation. Alternatively, a committee could impose like a radial separation requirement to enshrine into the zoning bylaw the same provisions that the federal government is sort of softly using. It's not a federal regulation. I think it's what they're using as a screening tool in order to go through the number of applications so that they can just say these ones are dropping off the table because there's too many residential dwellings within a certain arbitrary limit, and that's what the federal government has sort of picked a number. So that would be one alternative. You could enshrine into the zoning bylaw. I think we said 20 meters in the industrial zoning, which we had for the urban area, and we're carrying that forward into the rural area. It could be another number. It could be 100 meters, 200 meters, whatever. 120 meters, we know during the circulation distance at 120, 400 feet, you don't pick up a lot of properties. So a number would just have to be picked. It would have to have some sort of science or rationale behind it. To defend as to why that sort of radial separation number was being picked in terms of a separation or a setback distance.
Okay, thank you for that. And through you, Chair, you've got two separate rules here, not separate, but they could be encompassing. You've got a 20-meter setback from the property, and then there's a 150-meter setback from residential. Both would apply?
More restrictive of the two regulations would always apply in any situation.
So the 150 would apply?
That is correct.
Okay, so those are my questions right now. Thank you, and I'll take the chair back.
Before you do that, can you please put Councillor Whitehead and Councillor Pasuda?
Thank you.
On your list, thank you.
So I've got Councillor Pasuda for the second time, and I had Councillor Whitehead for the second time. Okay, go ahead, Councillor Pasuda, please.
Once again, thank you, Madam Chair. We're dragging this on, I know, but it's important. Talked about obnoxious smells and that coming from an operation, and I'm just going to touch on the mushrooms was mentioned. I was in a mushroom plant recently in my ward that uses no manure, there's no smells from it, it uses a growing medium of wood within bags, and it's really neat, so there's that. But if we have, and Marty's going to catch Marty up there sitting there, through you, Madam Chair, to Marty, if there's complaints, even though this building is built and put in place and licensed under federal regulation, if we have complaints come forward, how do you deal with them? How would the City of Hamilton deal with it, even though it's administered and put in place and regulated by Health Canada, the feds? Do we know that? Neighbor complains about some smells or something coming from the building. How do we as a city?
Through Madam Chair, normally we don't investigate odors. We would do a cursory inspection and usually refer to the MOE.
Okay, maybe I'm going to reach out to Ed if I can, Madam Chair. So Mr. Vanderwint, please.
Through the chair, I can advise that the MOE deals with dust and vibration and nuisance odors. However, under the Right to Farm Act, farms may operate and produce smells.
Thank you, Ed. Kind of knew the answer. All right, Madam Chair, thank you.
Sorry, we're having a conversation about the odors, and when you have hundreds and hundreds and hundreds of plants involved, it does smell. And there's a place that I know in my ward that a 5-year-old could go in and grab them. So I'm still trying to not tell you the address, but I will one day. Anyway, so what is the wish of this committee right now? And Councillor Whitehead, sorry, one more speaker.
Questions. I want to get into the actual comments.
Okay, so we've got 8.3 on the floor right now. I'm coming to you for comments, and let's go. Thank you.
Madam Chair, I've been looking at this, and I think staff, I want to commend staff in doing a great job. This is very difficult because it's traveling down a road that we haven't traveled in a long time in regards to a new product. We know it's heavily regulated by the federal government. Councillor Collins has joined us on the police board, and I know that every time we walk in there, I was always wondering why there's such a strong odor in the stairwell of marijuana. And it was explained to me that the evidence locker is below, and then the marijuana permeates through the whole upstairs and building and the stairwell. So clearly, it's a very potent smell, and it carries very strong, and it penetrates, obviously, concrete. The concern I have is that it is unknown. And when I look at 180,000, which is 7 times larger or whatever it is than what's being proposed, that's pretty significant. I don't know who the market is. Are we trying to get into the international market and Hamilton becomes the capital of marijuana growth? I don't know if I want that branding, quite frankly. Certainly not something I'm chasing. I thought we were looking for small type outlets that manufacture marijuana to meet the local demands in geographic areas so you don't have to commute or travel to create more security concerns shipping this further and further away. I thought this was all about meeting the local needs, not the international needs. That's a whole different element. The 2,000 I thought was reasonable in the sense that you can put more than one building, and so you're not limited to just that size, and that size would be consistent to anything else that exists in regards to building and building mass and size in the agriculture community. Anything above this doesn't exist. An 180,000 square foot building does not exist anywhere in for agriculture purposes in the agriculture community, period. I want to be clear on that. So this would be breaking complete new ground. And certainly it's not something that I'm all that comfortable doing. We set standards. And I think here is a learning experience. We open the door wide open. It's too late to close it after the fact. This is a rolling in, trying to understand the industry. So with the standard they're proposing here today, I'm very comfortable with. Doesn't mean that variances can't come in and go through the appropriate channels for committee of adjustment to ask or require larger pieces. We still have those processes in place. We can review this bylaw after we get a better understanding of the industry and make the appropriate changes at that time if felt necessary. The other thing that concerns me in the agricultural and having such huge facilities is we talk about leapfrog development. We talk about, and there's no question that when you have these kind of facilities, regardless of the federal security concerns, that there's going to be additional policing and observance, which is an actual impact on services elsewhere. Because they'll be obviously spending a little more time traveling around those particular locations based on concern. No different than casinos where more police are surrounding casinos because it draws certain issues and concerns. So and we're not going to make any taxes on that. If this is not taxed properly, we don't even know if it's going to be taxed, and how it's going to be taxed, how it's going to generate revenue for the city of Hamilton. A lot of question marks. So as a start, not as a finish, but as a start, I think what staff is putting in front of us is prudent, is cautious, it's consistent with what we do in planning and most things in the urban area, and may not apply necessarily the rule. I hear you, but I think we need to take baby steps before we take the big giant leap in this with this industry. So I certainly support before us.
Okay, thank you. And I've got Councillor Collins.
Well, this is an issue that deals with certainly the rural community by and large. So I've listened with interest in terms of the comments that were made earlier, and it seems like a very subjective process, which is problematic. We know that we have safeguards in place for rural development for agricultural uses, and I think that was emphasized clearly by staff. So I want to say I'm in your hands. I'm not certain what direction I'd like to hear from the rural councillors in terms of where you believe your community's at with this, whether there's an opportunity, because this, as Councillor Whitehead said, is a first start. Is it something we put to your communities through the many committees that we have? We have rural and agricultural affairs. We have certainly your own community councils. This is the first time that any of us has seen this, and it is quite subjective. So I feel a little awkward in terms of adopting something that we really haven't had any public comment on, save and except for today's meeting. And so I'm in your hands, so to speak, but I'd be prepared to receive what we have in front of us and maybe put it out for public comment, come back. As staff has said, we have a couple of applications that are starting to come in. So and delaying this somewhat would allow us to garner some public feedback and not delay any prospective investments that are on the horizon. Although we've certainly heard, there's a domino effect that happens if we're going to delay this today. So you'd be without anything except for whatever the rural official plan currently has in place as sort of a protective safety net, if you want to call it that. So I've put myself on the speakers list just to let you know that I'm supportive of the direction that you'd like to take, because this issue is directly going to impact or not your rural community. So those are my comments right now, and I'd be prepared to assist in any shape or form that you see fit.
Thank you very much. And I've got Councillor Spasuta, Councillor Partridge. Do you want to defer to Councillor Partridge first, or do you want to? Okay. Ladies first. Yay.
No, I am first.
Okay. We're not talking about being a lady. Go ahead.
Anyway, thank you, Madam Chair. And I do appreciate Councillor Collins' his position and his words. Staff did do a lot of work on this, and I know it's a new area. But, what I'm hearing from my community is we already have rules in place with our rural zoning. We already have, we're hearing now, the federal government regulates the setbacks. It's not something we have any jurisdiction over. I think we're well protected in terms of the 150 meters or whichever is the greater setback in terms of residential housing. So that would be my position, is that we stick with what we've got for the time being, because I do think there's enough control there. And it also isn't going to handcuff anybody who's wanting to put significant investment into our city and create jobs. And we did hear from the one applicant who spoke that we're not talking about labor-related jobs. We are talking about high-paying jobs. And if indeed it does end up being 100 employees, that's quite a substantial operation. However, I do feel that as long as we have the current regulations and rural zoning site plan in effect, that we will be protected. Now, we can always come back to this. We could always, with our rural zoning that we are doing the public consultation coming forward, perhaps we could include this in that to get some feedback going forward. But I don't want to hamper or stop any of the applicants that are coming forward right now. So that would be my position, that we receive this report and that perhaps an amendment or a motion be put forward that the public consultation part be put in with the rural zoning changes that are being proposed, but that we stick with our current site plan and zoning regulations that we have. Thank you.
Just wait a minute until the phone's finished. Thank you. Councillor Pasuta.
Thank you, Madam Chair. Well, as I stated before, I don't think this medical marijuana business operation, farming, is going to be a runaway train. I think it's going to be controlled within itself. And I'm going to state again, there's going to be investors going to lose millions of dollars. It's going to happen. There's only so many Health Canada wants, and that's going to be where it's set at. We don't know where. It's all across Canada. You know, we're looking at this. It's an investment. It's employment. It has a stigma to it, though. Marijuana, medical marijuana, that. Don't know what the stuff is like. Never tried it. Don't want to. But I know the medical part of it and what it can do, and I've had lots of research and study and been with people who use it for medical reasons, and it's amazing stuff. It's an amazing product. I'm just afraid that we got investors now who have sent letters of intent, have moved forward on plans, and I have seen their letters of intent and seen their business plan. It's out there on the internet if you look them up. I'm just concerned if we put a noose on them and keep pulling them back, that other provinces, other municipalities are going to maybe get one or two of these operations. We're going to lose that opportunity for supposedly, hopefully, Impact put some kind of a tax on there that we get this tax increase. We get the jobs. We got the connection with MAC and the medical departments to do future investigations, research. I don't see this as a runaway train. Some of these operations are very large, and Health Canada is the one who monitors it as far as security, monitors as far as, and even the smells and everything. They have to abide by it. There will be inspections by Health Canada coming in and inspecting these very regularly. And I think anything that comes up, they will regulate them to the point if they don't abide by the rules of Health Canada, they'll be shut down. So, you know, I'm supportive, Councillor Partridge stated, and I'm on the same track here as moving forward.
Thank you. I had myself down just from being on because it was thrown over to the rural folks. Just to remind you that the agricultural industry is $1.6 billion. This is an industry. It is one of it's the largest industry that the City of Hamilton have. We have rules that are in place. The staff did an amazing amount of work on this. I like the fact that if we can send it with the rural zoning, because we're asking the public for their input on this. We've asked the Federation of Farmers to take a look at the rural zoning, and they went through it line by line after creating their focus groups. These are a committed group of people that are looking out for the city and the farmers' interests. So it would be, in my opinion, very interesting to leave the agricultural part of this alone. We've got the 150 meters in place. That gives me some comfort level for the obnoxious uses. It also, because it also takes care of the MDS I was talking about earlier. But at the same time, also putting in a little bit of a wedge in here that we do send it back to the Federation of Farmers. Let them take a look at it, because if they're going to look at it the same way we suspect they will, this is an industry. It's an agricultural industry. So having said that, I'm good to receive this and send it out to public consultation with the rural zoning, which is the understanding to find out if there's any more input from the public, and we can come back and revisit. So that's where I'm at right now, and I'm going to take the chair back, and Councillor Whitehead, and then we'll wrap up.
It's just a process issue. I believe that this is the first time that most of us have seen it. We've had a couple deputations. No, I mean this new dimensions.
Right.
We've heard that already in the delegations. Clearly, this council has been very strong on community engagement and being well informed before we make decisions. I'm not sure if it's gone to the agriculture community to have their feedback on these limitations or not.
No.
But I'm having I'm having mixed messages. I'm having two councillors say let's receive it, and yet let's send it out for consultation. Well, you can't do both. You receive it, that means it's done.
No.
If you forward it off for further consultation, that means it's still alive and it can be amended as a live document based on that consultation. Well, could I ask the clerk?
I will ask the clerk.
Okay.
Thank you.
If we receive this report, then this report is finished and done.
Exactly.
However, that doesn't mean that the recommendations in it can't come back in a future report.
At the new term of council.
Yes. However, the best course of action would probably just to refer the report back to staff, and they'll come back with a new report. Perhaps if you wanted to do a consultation with the public, then it would come back as a new report. So it'd be back as that next one.
So my point is that this report is a basis to start a discussion. I've heard it pretty clearly that there's some mixed messages and that it hasn't gone to the community. We heard delegations. I just heard it didn't go to the agriculture committee. But if you receive it, that means there's no action. If you table it and go out for consultation and then revisit it after, in the new term of council, the findings of that consultation and whatever amendments are made as a result of that consultation, then we have a working document that we can make a determination at that time.
Can I refer to our senior staff? They're trying to jump in here, Councillor, and I just don't know whether this might help us along the way.
Madam Chairman, what I may suggest is that you do not approve recommendations A, B, C, and D, which would be the actual changes to the current zoning bylaws.
Right.
That recommendation E would be amended to say that staff be directed to consult on the definition of medical marijuana, continue on more or less, including regulation, and as well as that radial separation requirement, so that we could actually look at maybe enshrining into our zoning bylaw what the current federal regulation is. And as Ms. Hickey-Evans indicated also, there's a laboratory component with some of these facilities where they're doing their own in-house testing, so we would want to incorporate that into any definition to see that we get that right.
Right.
Staff would like to recommend that recommendation F should go forward to place these facilities under site plan control, like we do with any intensive agricultural operation. And then item G would be just to remove it from the outstanding business list.
Okay, so the suggestion is, Councillor, that A, B, C, D does not get approved, but E and F and G does. G just makes it come off the list, but E and F does. Stays on. So stays on the list. Sorry.
Am I understanding that staff are suggesting no further consultation on, is it F?
I'm sorry, say that again?
So no further consultation?
That's, Steve, I don't think I heard that.
No, Madam Chairman, to the Board Councillor, we wouldn't, rather than going forward with zoning changes now, we will refer this to the consultation that we're doing on the new rural zoning bylaw, which is on a comprehensive basis, and we will have the consultation with the broader rural community in terms of this, as well as the other aspects of the rural zoning bylaw, and which is scheduled for late November, December of this year, and then when we report back to Planning Committee in the new year with the new draft zoning regulations, we will incorporate the results of the consultation on this and other elements, so that committee can make a decision.
You're singing my tune. Thank you.
So just to be clear, the rural zoning public open houses are coming in November. They've been slotted already, the times between Ancaster, Flamborough, and Glanbrook. This is all coming. This will be put under that umbrella to take a look at it at the same time.
That is correct. We will incorporate this into the consultation on the new draft rural zoning regulations scheduled for November, December this year, depending on how harvesting and all that goes.
So E and F is what is imperative that we approve today. G, it stays on the outstanding business list. A, B, C, D does not get approved today.
Through you, Madam Chairman, it can be removed from the outstanding business list because we would just be saying that this now becomes part of the rural zoning bylaw
It now becomes
project.
part of the rural zoning.
As opposed to an item on outstanding, and then we will report back. We would have some consultation. We'll report back on the results of that broader community consultation on this and the other elements. So it would really be just that recommendation E would need to be revised primarily.
Thank you very much. So I'm going to go to Councillor Pasuda, then I'm going to go to Councillor Pearson, and then Councillor Partridge, please. Councillor Pasuda.
Thank you, Madam Chair. So if we go on the path we're going right now, where we're heading, what happens to the businesses that are proceeding with their business plan that's before us?
They're fine.
As far as permits and moving forward. Can somebody answer that question for me, Madam Chair, please?
You, Madam Chairman, they would be currently permitted under the existing zoning, so it depends on the timing of the federal government. So if October 1st they all receive licenses and then they start construction, then they will have their licenses and they can then advance their business plans. That's the uncertainty that we're dealing with, is really the timing of the federal government to make the decisions. But between now and when we come back with the rural zoning, there'll be further opportunities for dialogue and consultation with them. And hopefully at that point in time, there'll be a bit more clarity as to how this process is going to play out at the federal level as to who is and who will not be getting permissions to become a producer.
So, Madam Chair, the process is right now you have to have it built under Health Canada's rules and passed inspection, right? So they have to have it built. So they need a permit to go ahead and build, even though they're not guaranteed a medical marijuana license.
That is correct. But I think getting back to your earlier point about the grandfathering, I think what Mr. Kovacevic was saying, it's a little bit difficult to grandfather something that doesn't exist, but we have done in other situations, fortunately, unfortunately, like the hazardous waste facilities, when we brought forward the new industrial zoning, we recognized any of those existing operations in the new industrial zoning, even though they didn't meet the regulations. So it's easier to recognize something that exists than to try to recognize something that may or may not exist going forward from a legal point of view. So when we do come forward with the new rural zoning, and if there's a certain degree of certainty around these operations, it becomes a little bit easier to make the argument as to why those uses should be recognized with site-specific provisions in the zoning bylaw, if that was the recommendation of staff and or decision of committee.
So through Madam Chair, and skipping all the planner talk, just right to the point down here, we agreed to hear what we got before us, and these people, whoever's working on this, can come in and get a building permit and continue on with the process.
Under our rural zoning as it is right now.
Right.
Through you, Madam Chairman, subject to complying with the building code and the zoning and any other applicable law, if the application complies with all of the above, then the building commissioner will issue the necessary building permits. But you may have additional comments.
Okay, thank you.
In the meantime, the rural zoning is under review, and it's going to fall under that under review, so it can change at that time when it comes back.
Okay.
Correct. So, Ed?
Just through the chair, you'll note that Steve recommended that we retain Clause E, which gives us a definition of what this use is.
Right.
Passing that puts that use into the agricultural zoning bylaws, which gives us permission to issue building permits.
Thank you, Ed.
Yeah, I'm sorry, I didn't hear that either.
So Clause E, which you're about to pass, will place the definition of these facilities into the agricultural zoning bylaws, then giving us permission to issue permits for these things specifically.
Right. Okay, so Councillor Pearson, are your questions answered now?
Madam Chair, I just want to confirm that my question is answered in lines with one of the presenters raising the question of the size of the building. So that's off the table until this was reviewed, correct? The 2,000 square feet?
So to be clear, right now, anyone coming in with a permit or an application that's agricultural related falls under the present agricultural rules as according to the former municipality it's situated in, correct?
To the chair, that's correct.
Right. So in the process, the rule of the zoning is out for review right now. That follows underneath that umbrella, and it will all come back in one big package at the end of the day.
Excellent. Thank you.
Okay. All right. Thank you. And I'm going back to Councillor Partridge, please.
Yes, thank you, Madam Chair, and I really think we need to move on with this now. I am supportive of it. We're going to remove A, B, C, and D, and I'm quite pleased to move that if I can get a seconder. Can I second that?
Councillor sorry,
Actually,
hang on a second. So we've got Vanessa's just going to go through process here.
Councillor Pasuta would like to second that, actually.
So
Yes,
with
I got
that, it's probably just better that we receive recommendation A, B, C, and D, because then it requires no
Right,
action.
so we're just
we'll
receiving
receive
it.
them. They're
Yeah.
done.
Okay.
No, nothing else.
So
done with
moved by
them.
Councillor Partridge, seconded
Yeah.
by Councillor Pasuta, that we receive A, B, C, D. All those in favor? Thank
Carried.
you. Councillor Partridge, back to you.
Thank you. And then we move the,
Opposed, fine.
And then-
Councillor Whitehead's opposed. Councillor Whitehead is opposed. Go
Councillor
ahead.
Whitehead is opposed.
Thank
Yes.
you. Councillor Partridge.
And then, and I am pleased to move then
E,
E,
F,
F, and G.
and seconded by
Second.
Councillor Pasuta. All
Councillor
those in
Pasuta.
favor?
Hang on.
Sorry,
hang on.
did
Carried
recommendation
and?
E need an amendment, though?
I'm sorry, E, F, and G, and there was an amendment hanging on to
Steve?
E.
So that is correct. I'll give it to Vanessa
Sorry.
after. I'm just writing out. That's for E, it'll be that staff be directed to consult on the definition of medical marijuana growing and harvesting facility and the associated regulations, including the distance separation provision for the proposed zoning bylaw, and the rest will stay the same. We will need to just tweak that a little bit further to talk about the associated accessory testing and quality control labs. But that'll be just something that'll get added, and I'll give that to Vanessa.
Okay.
Okay, so go ahead.
Okay, so that's what we've got right now, is E's been amended to have staff be consulted on the definition, et cetera. That will be tweaked and brought towards the council meeting, I'm sure, in case there's anything that's really significantly missing from that. Right?
We'll do the wording and I'll put it
You'll do the wording.
It'll be in the
Yes.
report.
All right,
when it
so
comes
moved
before
by
you.
Councillor Partridge, seconded by Councillor Pasuta. All those in favor? Carried. 8.3 as amended.
Hold on, do we want to do, why don't we do a separate recommendation to approve F as well, so that doesn't get.
Wait a
mixed up
minute,
in
a
E?
separate,
Why can't it be included?
Because we just amended E.
Right.
So E
Right,
is now
gotcha.
amended, so
Right.
E and F, so E.
so E and F and G has been approved as amended.
Yeah, E has
And
been approved as amended.
8.3 is now going to be approved as amended, correct?
Yes, that's how we were going to do it. Yeah.
Right?
Yes.
Okay,
yes.
so we just
And-
did.
Yeah.
8.3 as amended, moved by Councillor Partridge, seconded by Councillor Pasuta. All those in favor of 8.3 as
Carried.
amended?
Carried.
Anyone opposed? Thank you. Councillor Partridge, you wanted anything else?
Well, I just wanted to say that, for the general public that's watching, this will be included in the consultation, as we've heard, of the proposed rural zoning. That is supposed to take place in November, and it will be the new term of council that will be dealing with that.
Right.
And this will now be included in it.
Thank you for the clarification. We're good. So 8.3 is finished. We're on to 8.4, which is probably 90% of the people waiting so patiently. 8.4, I'd like to invite staff forward for the presentation. And then after, we will have delegations. And just to remind everybody, 5-minute rule for delegations. And I've got 4 people on here so far. Let's see if I got all 4. Perfect. Okay, thank you. So we got staff in front of us right now, folks. Can you just wait 2 minutes, please? We got a lot of rumblings going on here. We're just going to wait for everybody to clear out.
With these things, so I'll leave that. Oh, no.
Oh, we'll just get our friend Vanessa to come forward.
Anyone with technical skills?
Yeah, you don't have the, do you have the jump drive in? Do you have the little stick in?
Yeah. Well, I saved it to desktop, but I don't know.
This one here?
Yeah. Oh, maybe because I took it from the
I think I've got it on the flash drive. Okay. You do that. And now I know what to do. Yeah. Oh, now do I take that out? Thank you. Okay. Okay.
Good afternoon, Julia. I understand you're going to show us Barton-Tiffany urban design.
Yes, that's
Floor's
right.
yours.
Pardon me? Yeah. So I just wanted to say thank you, Madam Chair, and the Planning Committee, and all of the staff from the different departments that contributed to making the study. After my presentation on the background and purpose of the study, I'm going to have our consultants talk about the actual concept plan and some of the design principles. And then I'm going to follow up with illustrations of the recommendations in the staff report where we're seeking your approval. So the background and purpose of the urban design study can be summarized by just answering the basic questions of who, what, where, when, and why. Urban design staff in the Planning and Development Department managed the urban design study. A consulting team led by GSP Group prepared the background study, the technical study, and the urban design concepts and guidelines. Those are three very large documents that are noted as appendices E, F, and G in the staff report. The most important purposes of the study are to serve as the form and functional benchmark for future development in the area, to draw synergies and connections to the new GO station on James Street North, to ensure that the study communicates the vision of the West Harbour as is illustrated in the secondary plan, and also to respond to input provided by the public and the stakeholders. The secondary plan for West Harbour has a policy that requires that an urban design study be prepared prior to any development occurring. So that's the main reason why we initiated this study. The secondary plan also has many planning and design principles which must be entrenched within the study. These include promoting a healthy harbour, strengthening existing neighbourhoods, enhancing physical and visual connections to the waterfront and the downtown, promoting a balanced transportation network, celebrating the city's heritage, and last but not least, promoting excellence in the design of the built environment. The study area is located within the West Harbour and contains both wards 1 and 2 and 2 neighbourhoods of Strathcona and Central. It's located north of Cannon Street West and south of the CN rail lines, which abut the waterfront. It's east of Bay Street North and west of Crooks Street. And you'll also notice that we've included Central Park in the study area. Barton-Tiffany proper is above or north of Barton Street. We've included Central Park so that we could create some connections and just enhance the entire neighborhood by including the design of the Central Park. The urban design study could not be initiated until the secondary plan was approved by the OMB. This occurred in December of 2012. In 2013, the study commenced, and the study is now complete. It's anticipated that the urban design study will be approved in September and hopefully today. And I just want to draw attention that I've got an incorrect label here. The new James Street GO station, as you see, is actually north of Stewart Street. So in case you're looking closely at this image here. The study went through several rigorous processes. For example, the study was created by preparing a background study, which was an analysis of existing conditions, planning policies, engineering standards, and technical studies. We consulted with the public and stakeholders, which was a very large component of the project. Over 9 different events were held to gather the public's input. With each consultation, the study and the concept plan evolved based upon the public's feedback. A draft concept plan and urban design guidelines were prepared. These were then tested against technical studies such as functional servicing and transportation impact studies. Similar to the public consultation, input was also received from the city staff, design review panel, and the city's technical committee. Based upon input from the public, comments from city staff, and the findings of the technical studies, the preferred concept plan and urban design study was formed. I'd just like to give you a couple of notes about the context of the study area. It's near both the downtown and the waterfront. It's within walking distance of the new James Street North GO station, and you'll hear about that with the next presentation. It contains existing residential neighborhoods, businesses, and Central Park, and it also abuts a shunting yard and contains vacant lands and brownfield sites. So now I'd like to ask Kevin Muir of GSP Group and David Dow of Diamond & Schmidt Architects to present the actual urban design concept plan and go over the principles of the plan.
I'm going to have to crouch a bit, so I apologize. Kevin Muir from GSP Group, and GSP, as Juliet said, was the project lead for the Barton-Tiffany Urban Design Study. Also with us today is Glenn Shields and Brenda Kays, who were the project managers for the Barton-Tiffany study, and also David Dow from Diamond & Schmidt Architects, who formed the remainder of the project team, the design team itself. What we wanted to do was quickly run through you the story of the Barton-Tiffany Urban Design Study. It's obviously a lot of material in front of you and a long process. We wanted to hit the key highlights of the engagement that we ran through the process and also the key messages coming out of the Urban Design Study. As Julia said, we had a very engaging consultation program. We met actually 11 times with various groups, the Technical Advisory Committee for the city. We met with the focus group, we met with the public 3 times, and also the Urban Design Review Panel. And we were very impressed with how productive some of the sessions were, how positive some of the sessions were, and also the quantity and the quality of the feedback that we received. As Julia said, we ran through a series of 3 consultation sessions throughout the process, one that brainstormed some of the challenges and opportunities facing the area, and essentially established some design principles that set the framework for the study. We then came back with a series of 2 demonstration concepts that looked at 2 different scenarios for the development of the area and had the community evaluate those. And then finally came back with the preferred urban design concept and the set of urban design guidelines that supported that concept. As I said, GSP and Diamond & Schmidt formed the design portion of the team. We also had a series of technical consultants on board that looked at some of the specifics. We had 3 consultants. MTE looked at the functional servicing in terms of the servicing infrastructure that's required to support the urban design concept. Paradigm looked at a traffic impact study that tested the design concept and the plan development to make sure it works. And also HGC Engineering looked at the noise and the vibration impacts associated with the rail yards. The urban design study itself is composed of 2 main components. The first is a very comprehensive set of urban design guidelines, and these essentially provide the city's expectations as development moves forward, as reconstruction of streets and spaces move forward. And there's 6 topics within the design guidelines themselves. 2 apply to the city assets, so the streetscape design guidelines apply when the city's reconstructing some of the streets within the Barton-Tiffany area. Central Park, there's a master plan process that's recommended, so the design guidelines provide guidance to that process. There's a set of general development guidelines that apply throughout the area for all uses and all types and speak to common things such as parking and landscaping, sustainable design, and transportation management measures. And lastly, there's 3 specific areas within the Barton-Tiffany area. There's the Barton Street mid-rise, which is that strip on the north side of Barton Street, the Stewart Street commercial area on the south side of Stewart, and the residential infill guidelines, which apply to some of the areas for low-rise residential infill scattered throughout Barton-Tiffany. second part of the final design study is a preferred design concept, and what this is an illustration of the long-term potential development of the area should the design guidelines be applied. And so it gives you an idea of one look at how the area could develop over time, but it's not necessarily the only look. The design guidelines are flexible, so there is flexibility built into them. However, this provides the vision. And the vision itself was supported by a very detailed, comprehensive modeling exercise, and this was done for a number of reasons. One was to make sure the built form fits within the surrounding neighborhood in terms of the existing fabric. Second, there's topography issues in the area. Barton-Tiffany sits in what's really a bowl with high ends at the east and west and a gradual transition from south to north. So we wanted to make sure that fits within the grades in the area. And also the modeling exercise tried to demonstrate some of the character that was desired by the design guidelines in terms of architecture and articulation and character of the buildings. So as I said, there's a lot of material within the urban design study. I wanted to highlight sort of the 6 main themes that permeate throughout the document, and we'll cover them as quick as possible just to give you sort of the flavor of the design guidelines themselves. What we heard first was about the mobility streets within the Barton-Tiffany area. The secondary plan identifies 2 mobility streets, Barton Street West and Stewart Street. So these are the main people movers within the area. As you can see from the images on the left, these are both 4-lane roads with 2 lanes in each direction. So what we heard from the community is it accommodates vehicular travel very well, not so much for pedestrians and cyclists. So what we heard was an idea of trying to better balance these streets through reconstruction to accommodate all forms of travel. And so what this means in terms of the right-of-way design and the streetscape design for these 2 streets is a reduction of travel lanes from 4 down to 3, so 1 lane in each direction with a center shared turning lane that could be landscaped and medianed. It means sizing the travel lanes themselves to accommodate future public transit routes on both Barton and Stewart, potentially in the future to accommodate connections to the GO station. It also accommodates on-street and off-street bicycling infrastructure, either through dedicated lanes or shared lanes or multi-use trails, and as well as on pedestrian sidewalks along all sides of all streets that are sized according to the pedestrian mobility plan. And so this gives an idea of sort of the plan view of what the urban design study calls for in terms of vehicular circulation, with the red line being the 3-lane roads within the area. The yellow lines accommodate future public transit. And both of the streets have a combination of parking, on-street parking on one side of the street. It's recommended in the urban design study on the north side for Barton and on the south side for Stewart to support the redevelopment. There are smaller pockets of existing on-street parking that are accommodated and can be accommodated, so parking on both sides of the streets for Barton Street, certain sections in that area. For cyclists, as I said, there's an accommodation. The red lines here, there's 2 main multi-use trails running through the area. One that runs on the north side of Barton up to Stewart and up to the GO station in Bay Street, and one that runs north-south along Caroline Street. And also the lines along Barton show opportunities for on-street parking. So as one moves from west to east into Queen Street, it's a shared system, where east of Queen, it would be a dedicated en-route system. And lastly, the pedestrians. What's been identified is, again, those multi-use trails that accommodate pedestrians and cyclists, sidewalks on all sides of all streets, again, sized accordingly to the minimums in the pedestrian mobility plan, and as well connecting to potential future bridges at York and Caroline Street. The second main theme that we heard was this notion of a green Caroline Street corridor. And Caroline Street is not a mobility street within the secondary plan, but it is identified as a very important street through our discussions with the community. And the desire here was to try to take what we heard. The desire was try to take that theme of the Central Park, park-like setting and extending it along the entirety of the Caroline Street. So as you progress from Cannon Street through the park, north of Barton, through the development area and ultimately to the GO station and to a potential future bridge. So what this means is, in terms of what the urban design study recommends, is a Caroline Street that has trees on both sides of the street, on-street parking opportunities on both sides, this concept of a multi-use trail along the east side that connects all the way up Caroline, and a notion of a sort of a pedestrian alley along that street with a double row of trees. And then as you progress north of Barton, what we also heard is let's take that park-like setting, that open green setting, and extend it north of Barton Street. And so what we've shown in the urban design study is the concept of the extension of that multi-use trail. We've identified greater setbacks for some of these buildings. So on the west side, somewhere in the range of 4 to 6 meters, and on the east side in the range of 6 to 10 meters. And so these would accommodate residential amenity areas or commercial spill-out space or additional landscaping opportunity to support that green feel. And then at the top of the image, it transitions into an angled public plaza that wedges out and opens up towards Bayfront Park. And so this would be an example of an illustration of what that space could be. And it's intended to be a complement to Central Park in terms of that recreation function. It's a space that can accommodate landscaped areas, hardscaped areas for ground floor commercial uses, patios, cafes, and also placemaking elements in terms of public art and wayfinding features. The direction in the secondary plan also looked, in terms of the urban design study, looked at Central Park, and some of the directions it said was, one, to look into reestablishing the grid network, the existing grid network of streets in and around Central Park. It looked at, provided direction in terms of the Barton Street facility, which is at the top of the image, in terms of possible adaptive reuse of that facility, as well as an overall reconfiguration and redesign of Central Park to improve the function of the park space. So there's 3 areas in the urban design study in terms of a general recommendation for the master plan to follow up on. The first deals with the north section, which is in red there, and that's the existing Barton Street facility. It does make sense for the city to look into retaining either the entirety of that facility or a portion of it or the shell of it for some form of community use or commercial use, community use or recreation use. And so there's 2 images on this slide. In the top right is an example of the Evergreen facility, Brickworks facility within Toronto, which is used for just a number of functions from weddings, social events, farmers markets, things like that. And the bottom one is one in Greenwood Park, which is an adapted facility in terms of a covered recreation space, whether it be a skating rink in the winter and courts in the summer. We also, the urban design study also recommends the Bay Street frontage, sort of that southeast corner, in terms of more of an open space, an open lawn feature it's suited for flexibility. You can accommodate a broad range of different recreation types and uses, throwing a ball or kicking a ball, throwing a frisbee, social events, things like that. And lastly is the active recreation focus in the southwest corner, and this would be internal to the Caroline Street, closer to the existing neighborhood, and this would accommodate a broad range of recreation uses, courts and play structures, splash pads, together with supporting washroom facilities and central parking in the area. The 4th and 5th points are regarding Barton Street West, the mid-rise residential area on the north side of Barton Street, and also the Stewart Street commercial. And this accommodates the majority of the redevelopment potential within the Barton-Tiffany area. And so David will help me out. He'll assist me with speaking to some of the architecture components and the architecture spin on the things. I'll just give you the framework in terms of what the secondary plan says and what we heard from the community. The secondary plan for the Barton Street mid-rise residential area says a 4-story maximum. However, you are permitted up to 8 stories based on this urban design study. So one of the key tasks of our job was to look at where the additional height made sense. And so we had a lot of consultation with the community. We had a couple different scenarios that we played out in terms of how to distribute height. And what we heard most from the community is there's an established Central and Strathcona neighborhood, a low-rise neighborhood. We want to transition to that. So there's, within the urban design concept and the study itself, there are 2 transitions along Barton Street in terms of height and form of buildings. One starts from west to east, shown here. It's a gradual increase in height. And the second is from south to north, because on the south side of Barton there are some existing two-story dwellings, so we want to make sure the transition across the street also makes sense. The other component is the Stewart Street commercial area, and the secondary plan identifies that this is a maximum of 4 stories in height, and pretty much everything is permitted in terms of commercial uses, community uses, institutional uses. The only thing that's not permitted is residential and noise sensitive, obviously because of the rail lines. So what we heard from the community was trying to break up some of these bigger blocks, because what we heard is it's a lot of commercial land. And so what we've tried to do is try to break it up into smaller, more manageable bits, more of a campus-like setting. Rather than very large buildings with large parking areas, it's a finer grain in terms of smaller buildings, smaller parking areas, and connected on the block with amenity areas. So I'll pass it over to David just to speak to some of the architecture and the design aspects of those 2 points.
Thank you, Kevin. I think this is more appropriately height-sized for me. Thanks very much. In the image that's up in front of you now, there is a east-west street that was added along the top. No.
Yeah, can you pull that right over? Thank you.
Is that better? So in this image, there is we did add an east-west street through the block to basically break the blocks down into much more developable and manageable site sizes, and also to provide a buffer with the commercial to the north. The buildings are arranged in a protective, if you look, they come up the side along and down the edges, and they're basically providing a protective cordon around the housing to the south to help shield from noise from the yards. Do I just click on it? And then as you move to the east, the scale does increase. So we have all along Barton, we have 3-story townhouse walk-up units. So that's intended to try and make a good relationship to all the single-family housing, typically single-family housing that's to the south, and transition between that and then the apartment-type buildings that are arranged east-west, and then the commercial beyond. And at Caroline Street, we have introduced some intent of more densification in 2 taller buildings that straddle Caroline at the intersection of Caroline and Barton. And the intent here was that we felt the development could handle a bit more intensity in this area. It is a major intersection between the park and the route down to the north to the water, and also where the triangular plaza that Kevin mentioned earlier, it really helps reinforce and animate that area. Looking at the commercial area, again, as Kevin mentioned, we've been trying to break the blocks down. It's our intent that we reinforce the street face as much as humanly possible, so the buildings would be very street and pedestrian oriented. Parking would be either below grade surface or structured parking, but would always be behind the buildings. So you're not diminishing that relationship with the street. And block sizes in commercial can be a little trickier to determine ahead of time, depending on market forces. So we've really just shown some very generic buildings that would ring the sites and hold that edge. Again, to the character of these buildings, we would be looking to reinforce the historical industrial nature of that area, and so we'd be promoting the use of brick, punched windows, etc., items that really evoke the character of the industrial that used to permeate the land here. I think, does that go back to me? Do you want to keep going? So to that end, a lot of brick. The single-family dwellings to the south really want to try and get the rhythm of so these the rhythm of the single-family housing. So you can see in the top two left images, some kind of identity to every house. Picking up the rest. And I hand it back to Kevin. Oh, sorry.
So, thank you. Hopefully that summarizes the concept plan and some of the core principles that helped create the plan. I just want to draw your attention now to the recommendations in the staff report, since we're looking for approval of the study and the report today. This plan just illustrates the location within the study area where each of the recommendations is located. So I'm going to just talk about the area around Central Park first. These recommendations all relate to Central Park, and they support the vision of the secondary plan. Recommendation C requires that a master plan be created in order to redesign and reconstruct Central Park. Recommendation D relates to the preparation of a strategy to relocate the Public Works building and yard and the various functions on that site. Recommendation E involves the relocation of the Fire Station Number 13 Mechanical Division, which is located along Bay. And recommendation F pertains to the implementation of the street network, streetscape designs, and sections that are proposed in the urban design study. The next recommendation is a little more tricky. It also relates to Central Park, but it involves the issue of residential intensification within Central Park. The secondary plan proposes to extend Caroline Street North, Mulberry Street, Harriet Street, Mill Street, and Railway Street into the park. Basically, they want to reestablish the old grid network. The parkland west of Caroline Street North and south of Mulberry Street is intended to be low-density residential development. So this plan here shows you the intent of the secondary plan, and these yellow buildings are low-density built forms such as townhouses and units like that. However, the staff report recommends that the parkland be maintained with the addition of Caroline Street North extending through the park to connect to the Barton-Tiffany lands, to the proposed GO station, and to the waterfront. The justification for this recommendation is for many reasons. First of all, we received feedback from the local residents, the elementary school students who use the park for their phys ed program, the neighborhood associations, and the Ward 2 Councillor Farr. There are also more reasons why we recommend not doing the residential intensification. Staff that deal with parks and recreation have noted that this neighborhood has a shortage of parkland right now, so that would only increase when you add more units. So rather than take away parkland, we'd like to maintain it or augment it and try to get rid of that shortfall. And lastly, this portion of Central Park has environmental issues with respect to the soil, and it is unknown at this time what the cost would be to clean up and remediate those lands to a residential level, and whether low density would even be appropriate based upon that cleanup. So this is just an aerial view to show each of these recommendations. We see Caroline North extending through the park all the way to the Barton-Tiffany lands. The parkland along the south and west of Central Park will remain as parklands. The Public Works facility has been relocated, and the building in this image is a potential adaptive reuse of that Public Works building. The fire station has been relocated, and the site is converted into parkland. And I just want to point out that the layout of Central Park is totally conceptual. It's just a concept, and it will go through a master planning process through Landscape Architectural Services, who will do the proper design. The next set of recommendations relate to the built form along Barton Street along the north side. And this just is a little bit of a repeat as to what Kevin was saying. All of the feedback that we received was that the residents and the neighborhood associations would prefer to see low-rise development opposite their neighborhoods, abutting and across the street, with a gradual increase in height as you get to Bay Street and as you get closer to the new GO station. So recommendation B1 is these yellow buildings. They were meant to be 4 stories, but we're recommending that they are 3. These are the two towers that were mentioned by the consultants, and they're not a very large footprint, but they are 12 and 16 stories respectively. And then the other recommendation is that we increase the setbacks along Caroline Street to get that wide green boulevard and the sort of linear park idea. And this is just an image of the study area from Bay Street North and Stewart Street. So once again, this yellow rooftop would be those 3-story buildings, and this is the 12 and 16-story building. And although you can't see it from this angle, this is the wider boulevards along Caroline Street with Central Park there. And that's the end of the presentation.
Thank you, Julia. And we do have questions, please, if you just relax for a few minutes. Councillor Farr, Councillor Collins, and Councillor Pearson. Councillor Farr.
Thank you, Madam Chair. And I'm just going to open with a recent email I had about a couple of weeks ago from one of the residents who lives on Barton Street, one of the few actually along this corridor, but one who's been involved a great deal for many years, including our focus group recently, and a resident who was interested and attended the public information sessions. There were 3 of those as well, very well attended. But this is what she writes in a correspondence that was to Julia and I was CC'd on after focusing in on one specific issue that I'll ask of Julia in just a moment. But on behalf of my neighbors, Julia, I want to thank you so much for your patience, your consideration, your superb listening skills, and your ability to be able to stay calm while there is a charged atmosphere around you. You've done a super job, and we'd like you to know this. And that pretty much sums it up. Julia's done an amazing job on this file. I don't know who chose her to handle it, but whoever did made a great decision. So thank you, Julia.
Michelle's jumping up and down, by the way.
It had to be Sergi.
It had to be Sergi.
Yeah.
Oh, now Steve's taking credit. So go on. Just do what you have to do. Just ignore him. Keep going.
That's why I sit on this side. He can be very distracting. What about the issue, actually, that resident brought forward, and one we've discussed many times in the past? There was a concern, and it's a valid one. Certainly she's had others and has been part of the consultation process. One of the reasons why you went from 4 to 3 in that section. It was more compatible, as we noted in our presentation, to the existing residential. And they're beautiful old conjoined homes. So how can I ensure that they have no fears of having to compete with some mixed use across the street, or the potential, if all plays out the way it should, of having to constantly compete for what they've grown over many decades, some of them used to, which is, and none of them, they're right up to the sidewalk, none of them have driveways, on-street parking. What can we do here today, or is this the forum today to ensure that those residents who've enjoyed that ability to park right in front of their homes can continue to do so through you, Chair?
Hey, longest question on record. Okay. Go ahead, Julie.
Yep. Through you, Madam Chair. There's a few strategies that are in place, and I believe that the study as it stands will protect that parking. So the question is for these residences here that are heritage buildings, they're built to the street, they have no driveways. Right now, those people have on-street parking with permits. So we've designed this section of Barton Street West to maintain that on-street parking. There's still a municipal lot next to them that could be used for the commercial parking. That's one option. The other option is we don't know if there will be retail on the ground floor of these units. If there is, every development, as you may know, whether it's residential or commercial or industrial or school, has to provide parking on their own site. We don't give on-street parking as a right. It all has to happen on site. So what you can't see in these plans is that all of the parking is intended to be underground. So that's why perhaps it doesn't look like there's any parking for much of this plan, but these blocks are meant to have underground parking. If it does become retail, they have to provide their own parking on site, and I believe also that those residents have permits for those parking spots, so that may be an extra level of security. And lastly, if it turns out that we do get a whole block of retail at grade here, the boulevard is wide enough. We've done an extra wide boulevard on that side that we could shrink that a little bit to have a lane of on-street parking. So, yeah.
Yep, that's good, and certainly I'd be keeping an eye on it personally, and understand the concern, and understand all the amount of time just on that particular issue, and parking tends to take up a lot of time all over the ward. You did mention the existing city-owned parking lot. My guess is, quick comment, and maybe you've already talked to Ted Arnold, but that was to be surplused probably 3.5 years ago now. But because of, we knew that the OMB outcome on the setting sail secondary plan was imminent, although it took a lot longer, December of 2012, they held on to it, understanding its value. So has there been any, through the chair, any conversation about maintaining that as a surface parking lot, given all the tremendous development all around it?
Julia?
Or would the surplus come back into effect now that it's worth a little bit more?
Through you, Madam Chair. I haven't had any communication with that group of people about the future or the fate of that parking lot. It's obviously a great site that could be redeveloped, but as I said when I first started the presentation, the Barton-Tiffany Urban Design Study truly is the lands north of Barton. We just picked up Central Park so that we could make that design. So maybe I could ask Michelle or somebody if they have more info. Oh.
Microphone, please.
It's not part of the footprint. Notwithstanding, I'm asking a question I already know the answer to, but I wanted to get it on the record. It's not part of the footprint, so therefore I shouldn't expect an answer, but I would expect that we should not take for granted that, as it associates to my first question, that could compensate the neighbors. So in short, we'll watch closely what happens, but I'm not going to take for granted that parking lot will stay there forever, given all of the exciting development around it.
I just would like to say about that parking lot, although we didn't look at that as an opportunity site, I think you can take all of the principles and the intent of the urban design study and apply it to that site. So maybe in the future we'll look at it.
And actually, Councillor, I think Michelle Sergi wanted to make a comment. Yes? No?
Through the chair, I did have a conversation with parking regarding that specific lot, and my understanding is that, yes, in the short and medium term, they intend to maintain it as a surface parking lot. And that at least in the interim until the GO station is developed, they're going to be actively looking at that site as maintaining it as a surface.
Okay, thank you. Councillor?
And we should note that it's one of the most underutilized parking spots now, but when you look at where it's sitting clearly in the heart of this urban design study, that's going to change. The complete mobility streets, this one I'm not sure the answers to, but I do know the OMB in our setting sail secondary plan outcome said a 5-meter trail along Stewart Street. That's the, if you could turn to page 17. Okay, so I thought I read a 4-meter wide trail on the south side, and then the sidewalk was 2 meters. None of us could see it, not in our printout or even on your screen. So can you give me a little bit of relief in that we are along where we were told by a Ontario Municipal Board judge to offer a 5-meter wide trail, that we're accommodating that request from the judge as it relates to the settlement of that December 27th OMB 2012 appeal? Through you, Chair. Can we combine a 4-meter wide sidewalk with a 2 and then you get 6? Is that what you're doing there? It's not contiguous in width.
Through you, Madam Chair, the trail surface itself is shown as 4 meters, together with the abutting boulevards and the landscaping on both sides. It's wider than that. This height is killing me. The trail surface itself, we've shown as 4 meters in keeping with the city's documents. You add in the boulevards on either side of them and the treat and the landscaped areas, it's much more than 6. What we've identified, and also for the corridor itself, it was very schematically drawn. So we've had to identify where it makes the most sense in terms of alignment of that trail also.
Can I ask then, through you, Chair, does that meet to the satisfaction of those appellants? Can I even ask that here? Had they been adequately communicated with respect to a width that my understanding was in an appeal 5 meters, you're saying 4. They were there. I saw those folks very engaged regularly. And were they satisfied with what you have before us, through you, Chair?
Through you, Madam Chair, we didn't hear anything in terms of the width of it, in terms of the consultation that we held. If it is an issue in terms of the surface itself being 5 meters, there's certainly room in terms of the boulevards that could be accommodated. So reduce the boulevards somewhat and accommodate a 5-meter trail. We took it to mean a 5-meter trail that includes sort of the buffer areas on either side of the trail.
So you're bringing it all together.
Yeah.
It's not necessarily contiguous in width.
Yeah.
Okay. Is there any other staff that may address that, the question that I had?
Through the chair, with respect to the participation of the previous appellants, they were involved in both our focus group and attended all of the public information centers.
Good to know. Central Park, Julia. You hit on it a little bit. Some of my colleagues around this table who sit on Public Works will be aware that there's some environmental work going on right now there. Maybe you could share briefly what that is about, where we're at with that environmental work. I see Emil is here, or was here anyway, and how we are coordinating our efforts as it relates to the overall design, through you, Chair.
I'll definitely let the Public Works staff tell you about that.
Through the chair. Yes, we're at the stage where we're ready to do a risk assessment of the park. As Councillor Farr mentioned, there's some concern over some environmental issues, historic environmental issues related to the previous use of that, or historical use of the park or that area. So we are ready to go in terms of our next steps, and again, as it relates to the risk assessment and ultimately filing for a record of site condition. We are now, as a result of what's going on here at Barton-Tiffany, we are coordinating our efforts with both planning as well as landscape architectural services.
Well, I'm very happy to hear that. That's good. We like to see different departments working together, and certainly on a significant project like this. Through you to Julia. Julia, so it's a different plan now as it relates to Central Park. You offered up a couple of reasons why it's a benefit. One of the things you didn't mention, and I'm wondering if it is the case, so what we have lost from the original SSSP, have we not and taken out of Central, thanks to especially the engagement, what we heard from those who live in the immediate area, but all those other reasons you offered, what we've lost from a residential unit capacity, have we not gained or come close to a wash on allowing for higher densities, the 12-story and the 16-story, through you, Chair, along Caroline?
Yeah, through you, Madam Chair. I happen to have a few statistics here for you.
I thought you might.
And you have to remember that these are ranges because the amount of units in population can change. A low density single family home is going to have a different count than, say, a townhouse. So if you look at the secondary plan here, the number of people is approximately 2,700. And then if you look at the staff report recommendations, we're at about 1,900. So, but they can both fluctuate either way depending on what the final built form is. The area in Central Park, it's this block 11 here. So you can see that there would have been approximately 133 people because that was low density, single family detached, some towns. And obviously there would be 0 in our staff recommendation. With respect to where those two height components are, they're in block 2 and 4. The 12 and the 16-story tower. So we are picking up obviously picking up units and people there. So if you look at just say block 2, for example, there's 478 units as per the secondary plan, and we are, well, that's not quite right. It says 360, so I probably should just.
But it would be more.
Yeah. I can recrunch the numbers for you, but it's definitely going to be more based on that height. Unless it
Well, I'd be-
transposed a number or something.
Okay, thanks, Julie. I'd be interested to take a closer look at that. But I also would imagine that we'll see some, if everything goes the way it should here and a council strategic mandate is met along the road, we'll probably hear of others in the immediate vicinity who will look to intensify and build our residential up as well. So, I mean, I know we had that among hundreds of other discussions over the past many months, and I'm sure part of the public engagement as well. So we'll leave it at that. Finally, Julia. Yes. Or staff, maybe Steve Robichaud, who coordinated our urban design panel. Is it just the mandate of this urban design panel that Councillor Collins moved and I proudly seconded it, and they just got underway, I think, at the start of this year and have looked at a few individual development files? Is it just their mandate to look at individual files, or have they had an opportunity to participate, or will they have an opportunity to participate as it relates to this design, in particular the architecture, through you, Chair?
Through you, Madam Chair, to the Board Councillor. No, the design review panel's mandate includes both to look at city projects, and they did actually, there was a presentation on this project to the design review panel, as well as then looking at individual development applications as they come forward, in terms of providing their advice to staff on the merits and the merits of individual projects, and/or giving their advice to city staff relating to larger city initiatives, including policies and projects such as this one.
Okay, thank you. So we'll probably meet up with them along the way on individual projects. Thank you, Steve. Finally, Julie, again, to quote another resident of the area who worked with you, of the many, many that you work with, you really are a gem and have been such a pleasure to work with, end quote. Good job, Julia. Really good job.
Thank you. Julia, we have more questions, please. Councillor Collins.
Thanks, Madam Chairman, and through you, I'll save my comments certainly for later. I do have a couple of questions in terms of where we are with the city-owned lands, and so for much of this, we've waited quite some time. I mean, this is over a decade in the making in terms of getting us to where we are today, which is terrific, and certainly I'd want to understand the next steps in terms of passing the recommendations today. We've always been keen on trying to get to the point where there's for sale or for lease signs on some of our municipally owned properties, which are key to the plan that you have in front of us here. And I'm curious to know when we start divvying up, now that we have the parcels in place and the guidelines in place, obviously pending council support, when are we in a position now to start to see shovels in the ground related to now implementing our vision here that you have up on the screen? Specifically, and especially on those parcels that we own, and they're large in acreage and in terms of municipal addresses as well.
Through you, Madam Chair, this is just an image of the parcels that the councillor is talking about, and the two largest ones are north of Barton Street, and they are entire city blocks. I can only answer the first part of that question, and to be kind of simple about it, the moment you approve this study and the staff report, they can, the real estate group and the people that handle our land transactions can begin their process. And I don't know anything about their process and how long it takes, but I think Chris Phillips is here to answer that question.
Through you, Madam Chair. First of all, it's been a pleasure to work with this entire team that put together this urban design study. Council, you certainly know the importance of this study as far as moving forward, and I think Julie has articulated the fact that we're now in that kind of area where we're ready to go and hit the accelerator in the ability to put the lands now onto market. With that said, if you remember back throughout several of the waterfront discussions, our plan of attack has always been to get this urban design study done and completed, and then to roll out a public process into how we actually go about rolling the lands onto the market. We expect that to be the exact next step, and that is certainly in our beginning of the end of 2014, beginning of 2015, to bring you back a recommendation as to how we would roll that out.
That's great, and I'd ask that in the context of it's all publicly owned land. We were certainly criticized in some corners of the community that A, the waterfront development wasn't happening quick enough, and B, we purchased the stadium lands and what's to become of those lands, and they're an integral part of what you have in front of us here. And that was part of our original setting sail document. So there's a lot of, I think, there are a lot of questions being asked in the community in terms of what's next, especially for the stadium lands. And I think your document here answers a lot of those questions. And in the context of what Chris has talked about, we now have internally competing interests. So we have not just this area, Barton-Tiffany, but we have Pier 7 and 8 and everything that's part of our recreational master plan. And of course we have Confederation Park. So it's, we finally have all these opportunities presenting themselves at the same time. And I want to be certain that we're capitalizing on private investment, because we're putting a lot of money into the ground to get these lands ready for development. And the quicker we can get them out privately, the better. My other question would be the one that's bothered me almost since we adopted the setting sail policy, and I've never understood our reluctance to plan for the eventual relocation of the rail yard. And so it's the most valuable land. I know it's contaminated. I know it's being used now by another party. It obviously wasn't part of the terms of reference in terms of what you focused on. But it creates a very awkward planning situation for us 3, 5, 10 years down the road to now start this process all over again and have to start basically at square one. You've certainly taken advantage of, and it's a great plan. I'm not criticizing what you have on paper. I think there's a huge void, though, in terms of where we're going and what our vision is. And I had the opportunity, I'll just say as a preamble, had the opportunity to participate with many of the residents, I think, that participated with you in this process. Mr. Curran, Mr. and Mrs. Carr, Mrs. Renwald, all Jason's constituents that he's done a tremendous job working with. And their vision was, let's bring our plan right down to the waterfront. And again, we know we don't own the land. We know that somebody could be there even for decades. But when I look at this plan, it is a plan that is most likely decades in the making and will probably come back in a different form 10 or 15 years from now. Council will take stock of where they're at, and they'll say, you know what, let's shift gears and make some changes based on where the private sector's at, what the community wants to do. There'll be thousands of new people living in this neighborhood by that time, and that's a great thing. So help me understand our reluctance to plan for the eventual relocation of the rail lands.
Okay, I'll answer a bit of those questions and then pass it over to management. The first thing is the plan for Barton-Tiffany, it works with or without the rail yards being there. The plan is for a mixed-use community, so that that's always the most successful and thriving type of built environment. When you're mixing the uses, you've got people there all day long, and there's an active transportation network to get people to it, through it, and the ones living there. So if the rail lands go, it's just going to get better. We won't have to scrap this plan. So that's the first thing. The second thing about the CN rail lands is obviously we're going to have to keep some of the rail because of the new GO station and their need for tracks in the platform. So there will always be some amount of rail. In terms of the shunting yard and that big noisy facility that makes everyone have to, stay way back from it. We got a letter, I think, in 2012 when the OMB decision was finalized from CN saying that the city approached CN and said, how about you move that shunting yard? And they said, we'd love to, but there is no piece of land in Hamilton that has that length and that size for that function. There's just no physical place for it. That's what was said at that time, and that's the only information I have. So I don't know if anyone else over there.
That's a great answer, Julia.
Yeah,
because
but I think Chris might have more. Oh, no, he doesn't have
No, you've nailed everything in terms of historically.
Yeah.
And I think those answers are certainly all valid, and they're very relevant today. But as I mentioned, this plan, through you, Madam Chairman, is probably a 10 or 20, 25-year plan in the making in terms of getting it built out. And the fact we're not planning for their relocation, if I can use that word, I think it sends the signal we've almost given up. And I haven't given up, and I know there are many people in the neighborhood who really want to see that relocated in some shape or form, maybe even slowly over time. But I think there's public pressure that comes with having something in that swath of land there that says, whatever, it's mixed use, it's These are the height limitations. We don't want to end up like the City of Toronto and cut people off. It needs to be integrated, what you've appropriately planned here. So when I read the document, it was the only thing that I looked at and said, and it's not like we've missed something, but we haven't accommodated for it. And I think we let them off the hook by leaving it out of the document. So I know that's more of a comment than a question, but it's something that for me is unresolved as we sit here and contemplate approving this and telling the community what our vision is. And for me, those rail lands and the shunting yard is a big part of the future development of this neighborhood. So anyway, those are my questions right now. I do have some comments, and if you can put me back on the speakers list just under comments, please.
Thank you. Councillor Pearson.
Thank you, Madam Chairman, and thank you so much for the presentation. Excellent work, and I hear the compliments that are going around, so I can concur just with what you presented today. Couple of questions. I'm just going to go on to the slides where I just kind of highlighted.
Sure.
The question was raised with regards to on-street parking by the ward councillor. So on slide 31, just going back.
That's images. Oh.
Sort of developments. Those are 3-story townhouses.
Yeah,
I'm assuming I have them in my ward. When you're saying you're not proposing that this would be underground parking for these types of facilities, but they would be rear parking, so similar to what I have in my ward, where it may be where Councillor Johnson has in her ward in the 50 Road area, where the parking was designed to be at the backyard, so you had the street frontages. Is that what the proposal is?
Generally, that's the intent, that the parking for these types of units is very similar to these that were built 100 years ago, which never contemplated parking or cars. That the driveway and the parking is not the foreground and the forefront of the development. It's tucked in behind, either through a garage at the back, or you have a raised deck and you've got your amenity space. But this type of development could or could not have on-street parking, but that will be more for the people in the community, not the actual owner of those units.
Just to add to that, there actually are two forms of townhouse types shown on the concept. There's those which are the infill properties, so which was previously in and around the park, and also at the west end of Barton. And those were based on a rear lane, a concept in terms of rear garages. There's also the ground-oriented, the townhouses that are as part of the Barton blocks, so north of Barton Street, and those were contemplated with underground parking together with the other apartment buildings on the site. So there's two forms.
Excellent. No, very pleased you've clarified that. Then I'm just going to go back, only just to clarify the transportation grid and mobility grid. Way back at the beginning, slides 19 and 20. There, you've got the two circles, and it's indicating, I was trying to read it on here, that they're cycling transition points. Could you clarify what that means?
Those are points in the cycling network where it transitions from one type of accommodation to a different type. So in this regard, for instance, at Barton and Queen, it transitions from a shared lane where it's shared with traffic, goes into a dedicated lane. And there's other spots where Stewart connects with Bay Street, a similar situation, and also down at Cannon Street, where it connects from a multi-use trail into shared traffic of some form.
Those identifiers in Stony Creek are actually, I would consider it a roundabout, and I'm going, why are they putting a roundabout there? So, sorry, I had to throw that in. The next, and the last actually, is the next slide, 18, just before this one, I think, 18. You mentioned a transportation, I'm assuming that's transit corridor, which is the yellow lines running along Stewart Street and Barton Street. And does it come out, when it comes out at Barton, is that coming out to south of Barton? And what's that coming up to after that? Is that coming up to Cannon after? Not sure. Do you see where the yellow line continues and then it just ends?
Straight down. Yeah, that's Queen Street. So across Stewart connects to Queen and goes southwards. And those are showing potential transit routes in the future, obviously depending on need and warrants for a transit route in terms of population, and we've just conceptually shown that they can be accommodated on those two streets. Where it goes from there, obviously, is a routing perspective.
That's what I wanted to just visualize where that was going to continue to, because I was just thinking the dimensions of the road, and because there's parking, I think, on Queen now on both sides, et cetera, there may be some space issues. So I appreciate that information. And again, I certainly think this is exciting, and it's been a long time waiting. Thank you.
Thank you. And I have Councillor Whitehead and then Councillor Farr for a second time.
Thank you. I know the extensive work to get to this point and the involvement with the community. So I also want to provide kudos for the work that's been done. I was going to say it's not quite a Rembrandt, but we're getting there. The issue that was raised earlier also concerned me because it really is a key component to access to the waterfront is the shunting yards. And I would think that to facilitate what it could be and what it could generate would be equally important in selling the message. In absence of that, because I mean you've done a great work with the defined area, but in absence of that, I think Councillor Collins said best. It appears that we abandoned that as an important element of our vision. So I guess the question is the area that was defined, and here's the first question. We often go through, and you just did it here, plans that involve lands that we do not own. Is that correct? So there's nothing that prevented us from doing a similar plan and what the vision is for the CL and rail yards if it did ever fall back into the city's control. Is that correct?
Yes, that's correct. We can do a study on any piece of land anywhere in Hamilton. It wasn't our direction at the time that we started this process in 2012. I don't have any more info than that.
I appreciate that. I just think it's a missed opportunity, but it's something that we can still work on. When you designed and did this work, you had indicated that it's complementary to and synergistic with what those CN railway yards could be. Is that correct?
Yes, I imagine there would be similar uses being recreational, commercial, residential, institutional. All of those uses are compatible and often great when you blend them and mix them.
So there's no changes to what you put before us that you might consider or reconsider if, in fact, the CN rail yards were incorporated into this plan?
I can't predict what, I'm not really sure how to answer that. I think that the concept plan we've created is a concept plan. The grid network and the street network we've created, the transportation network, could support whether all of the, let me just go to this slide, 1 second. I see what you're saying. Let me just get to the concept plan. Okay, so I guess the point you're making is right now, due to the shunting yards, the only residential that can happen is this strip here. It's that imaginary line that's 150 meters from the shunting yard. The rest right now is blue, being commercial, because you can't have residential near the shunting yard. However, if you look at the layout of the blocks, the size of the road network, and that whole, the skeleton or the bones, whether these blue buildings in the future are commercial or retail, or whether that becomes a residential development, I think they're interchangeable. And perhaps it would remain that you would have all the bottom of these buildings retail with residential above, once again, going to that mixed use. So I believe whether the shunting yards come online, it won't negate this concept. It will, it's going to evolve and it's going to adapt, but it's not going to get thrown in the garbage.
Right. I just wanted to make sure that that was contemplated in regards to that possibility down the road, that we were locking into this concept didn't preclude those kinds of opportunities in the future. So thank you very much.
Thank you. Jason, or Councillor Farr, questions to the staff? Thank you. Thank you very much, everyone. I'm going to ask the public to come down in a few minutes. Can I just have a motion, please, to receive the presentation? Councillor Farr, Councillor Collins, all those in favor? Thank you. I know. So now I'm going to ask for Golden Horseshoe Enterprises. Jasper? Remember, this is not a public meeting. You have 5 minutes, please.
Great. Thank you very much. My name is Jasper Kujawski. Some of you in the room may know me. I am a lawyer in town, and I've done development projects dating back quite a long time, including a pitch to build the Canadian Music Hall of Fame on Pier 8 a number of years back. So I'm reminded that when I first moved to Hamilton back in 1989 as a young lawyer, the city was in a buoyant mood. There were signs everywhere talking about the ambitious city. There was an NHL expansion bid on the horizon, and there was an enormous amount of talk about the rejuvenated waterfront. And one of the things that was talked about all through the early 90s about a rejuvenated waterfront was about the opportunity to extend it all the way to the water's edge by gaining access to the CN marshalling yards. Now, that's 25 years ago, and there's been a generational story that ultimately will be the subject of a book one day. And there's no doubt there have been challenges, but Hamilton's not been the only city that's experienced urban problems and the requirement for revitalization. We've seen stories all through North America, the Pittsburgh story, the Cleveland story, the Hamilton story. And now as we fast forward 25 years to the present, there's a similar buoyancy, and one feels it in this room and throughout the city with regards to the revitalization of Hamilton, what's happening downtown, what's happening on the waterfront. And here we are talking about so many of the same things that we talked about in the past. The waterfront is essentially, I would suggest to you, it's almost like a 5-part jigsaw puzzle. And of those 5 parts, the city controls 2 of them. One of them is being discussed here today. That's Barton-Tiffany. And we're not going to relitigate the stadium issue. There were those who thought the stadium should have gone there. There were those who were just as enthusiastic in their view that the stadium shouldn't go there. The bottom line is the stadium will be built and has been built and will be at the historic Iverwin site. And now these lands that were expropriated by the city are subject to new development, and that's what this plan is all about. And I think the plan looks great. The second piece that the city controls is that Pier 8 and Pier 7 through Pier 8, and talk about revitalization and all the types of plans that are going to happen there have been the subject of discussions at this council. But the 3 parts of the waterfront revitalization jigsaw puzzle that aren't specifically in city control, I believe ultimately are going to be the key to getting complete, comprehensive, and transformational waterfront revitalization. One of them is what's going to happen to those 810 acres of U.S. Steel as we transition into whatever is coming, and those have been huge headlines over the last couple of days. The second is Randall Reef, because you can't have a toxic hotspot in the middle of a revitalized waterfront district, and that has to be fixed. And the third one, and one of the most challenging and important, is CN. I believe one of the things that's going to happen in the next number of months and years is that there has to be not just city initiatives, but I believe that with the upper levels of government, and specifically the federal government, I believe ultimately what's going to happen is we're going to have to see the leveraging of federal power, influence, and credibility to assist the city to effect transformational revitalization of Hamilton's vast waterfront properties, and specifically in those 3 areas in which there is federal overlap, being U.S. Steel, Randall Reef, and CN. So the issue is, does this plan accommodate, and that's been the subject of these last few comments, accommodate the potential for what happens if CN comes on board?
1 more minute.
I'm sorry?
1 more minute, please.
And I'll leave you with 3 points on that. One is the linkages that have been discussed in terms of pedestrian bridges. Ultimately, if CN were to come on board, there would still be 3 lines going through, 2 passenger and 1 freight. And if they were kept as far south on the site as possible, they would abut what is now going to be that commercial block. And by having glass vaults and underground connections, you could have multiple links. Secondly, is that commercial base and making sure it's consistent. And I think that if those things are done and the consideration for the future of the usage in conjunction with CN rail yards are done, we'll be able to look in the mirror and say, welcome back to the ambitious city. Thank you very much.
Thank you, Jasper. And thank you for coming under the 5 minutes. Sarah Mayo from the Social Planning Research Council.
Thank you, Madam Chair. Let me just close this.
Yes, Councillor Farr.
Thank you very much, Madam Chair and councillors, for your time. I will quickly start by saying the City of Hamilton has adopted policies to enhance affordable housing, and the Barton-Tiffany development is a prime opportunity to implement these policies. In the following slides, I will quote some of these policies to remind the Planning Committee of ways that affordable housing can be encouraged and are mandated in this and other developments. But first, here are the words of a longtime resident of the Barton-Tiffany area, Greg Tedesco, in a letter he sent to Council this week. Beyond the positive impacts on community health and well-being, investment in affordable housing also has positive social and economic impact on communities. If individuals have safe, affordable, appropriate housing, they're more likely to experience better health, be more actively engaged in their community, and participate more actively in the local economy as well. As a resident of the community, I hope to see diversity and inclusion emphasized in this development. So why do we need to create more affordable housing in Hamilton? Small reminders. City report in 2011 reported that over 5,600 individual men, women, and children slept in an emergency shelter in Hamilton. 21% of renter households in Hamilton pay more than 50% of their income on rent. And now the social housing wait list is up to over 5,600 people in 2013. There we go. In response, Hamilton, this council adopted a action plan on homelessness and housing in 2013, and I'll shorten it to HHAP in the next slides. So the HHAP made the case for affordable, addressing affordable housing and homelessness by explaining that 1, housing is a human need, 2, good housing promotes better health and social outcomes, and 3, housing investment makes good economic sense. Implementing the strategies in the HAAP would lead to several positive outcomes, including more affordable rental and ownership housing in Hamilton to help meet need and demand. But the report warned that if in 10 years this wasn't achieved, the impacts would include loss of our competitive edge in terms of being able to offer affordable housing choices and to employers and skilled professional laborers thinking about relocating to Hamilton. Outcome 2 for the HHAP would be, from adopting their strategies, would be increasing people's housing affordability, stability, and choice. Again, the report warned that if in 10 years we don't achieve this outcome, the impact will include that there'd be nearly 10,000 households on the social housing wait list. Key strategies from the HHAP that can be used to increase affordable housing in the Barton-Tiffany development include strategy 1.4, which was about inclusionary zoning. This is a longer-term strategy, but may be feasible for Barton-Tiffany, depending how long the development takes to get into to be realized. Strategy 1.5 was density bonusing, i.e. Developers gain some benefits such as higher density, greater height incentives, tax breaks, etc., in exchange for including affordable housing in developments. Another way to negotiate more affordable housing is by including reduced parking requirements in density bonusing options, which is used extensively in Vancouver and other municipalities. The Barton-Tiffany design is a perfect area to reduce parking requirements as the walkable design of the neighborhood and proximity to transit will encourage many families to live car-free and car-light. Any variance from parking requirements should be leveraged to require more affordable housing units. It is especially important that a walkable neighborhood like Barton-Tiffany have incentives to encourage mixed-income housing, as neighborhoods with a healthy design often have much higher property values. Lastly, HAAP Strategy 1.8 was to make surplus land available for affordable housing, surplus public land available for affordable housing development at discounted or no cost. The background study for Barton-Tiffany cited the requirements more specifically for affordable housing on city-owned lands.
Sarah, one more minute, please.
Yeah. So there's 2 parts where they talk about it, and specifically they say that 25% of all units should be made affordable through the disposition of city lands. Despite these requirements and resident comments on consultation events, today's guidelines and design guidelines and today's staff report have no mention of affordable housing. It is important that council makes clear to the community that affordable housing will be an important component of the Barton-Tiffany redevelopment, for example, through conditions of sale on city land and density bonusing negotiations. Councils could direct staff to recommend a target for affordable housing for both public and private lands combined. This will ensure that Barton-Tiffany will become a thriving, diverse, mixed-income neighborhood where everyone is welcome. These same considerations should apply to other developments currently before council, such as the James Mobility Hub study and the City Motor Hotel site. Thank you, Madam Chair, and the councillors for this opportunity to speak about this issue.
Thank you, Sarah. And Councillor Farr would like to ask you a question, if you don't mind, please. Questions to the presenter.
Yeah, I like what you have here. I'm supportive of mixed income communities. And as you referenced with your last slide, not only for the Barton-Tiff community, we've talked about it with City Housing Hamilton as it relates to other areas of which we operate our mandate. And of course, today, next report, Jamesville Hub, that area as well. But the 25%, I just wanted to get some clarity. Based on your presentation, I'll have a few questions of staff that will, so hopefully you hang around, Sarah. But the 25%, does that come from our HHHAP?
No, you'll have to ask staff, but it sounds like it comes in part from the official plan. But I will address them.
Okay, and I will at the appropriate time or now if that's...
If you don't mind, we'll do it all at the end.
Okay,
ask them
we'll
at
do
the
it
end.
at the end.
That'd be
But thank
fine.
you, Sarah. I did read the Ward 1 residents that you quoted today and his email the other day, and certainly we've had this discussion along the way, and I think even at a few PICs it's been bandied about. So I hope to bring some clarity to you that you can report back to the Social Planning Research Council before this item is over. Thank you.
Thank you. Thank you, Sarah. I need John Vale, please. So John is here to speak on the 8.4 Barton-Tiffany Urban Design Study and the 8.5 James Street North Mobility Hub Study, which is 8.5. So John, 5 minutes, please. Thank you.
Thank you very much, Madam Chair. My name is John Vale. I am a resident of Ward 2 and a candidate in the upcoming municipal election. So not to rain on the parade too much, with all the work that's been done and what have you of the study, I will direct my comments to the staff recommendations and request your consideration for a change of a word or two. And that should be in that the Barton-Tiffany, this is point A of the staff recommendation, to change this to read that the Barton-Tiffany Urban Design Study Concept and Guidelines attached as Appendix E to report PED 14164B and change the word to received instead of adopted. And the reason I say that is that look at the timing of this report. This is a massive document that is frankly years in the making, and we are about 5 weeks away from a brand new city council. And that will mean certainly a change in strategic direction of that new council, because strategic plans do change at the beginning of each term. And so it needs to be received such that a new council can have another look at this thing and go from there. And with respect to the with any sort of respect for the electoral process that is going on right now. If this was the federal government, they wouldn't be in session to make these kinds of decisions that close to an election. It wouldn't happen in a provincial government. It's not happening in the city of Toronto. And we're so close to an election now here that this report can certainly be received and then reactivated with a new council. I have 2 more points. The other points in the document that ask for the direction to rebuild Central Park, to relocate or to incur the study costs of relocating all the public facilities, including the public works and the fire department, and even the roads plan, again, should be left until a new council has had a chance to provide new direction for the study. Thank you very much.
Thank you, John. Just want to wait right there. Councillor Farr has a question for you.
Thanks for coming, John. Appreciate the delegation. So this term of council started with a mandate to conclude this plan. We've been working 4 years on it, and it's a strategic mandate. And would you, if you would like, if you want to hang on, I'll confirm that with staff too at the appropriate time when it's time to ask questions, just for your edification given the content of your presentation. But thank you for coming. Thank you.
Thank you, John. And I now have Steve. Steve? I'm sorry, I'm going to try to say this. It's Rednicki? I'm sorry, sir. I'm just glad I married a man named Johnson.
Good afternoon, Madam Chairman, Council, and the general public. And I'm going to make this very short and sweet. I read the report on running Caroline Street through Central Park. I read the report on Central Park being redesigned and whatnot. I live at 183 Caroline Street North, directly across from probably the most toxic part of that park. I'm standing here as living proof of the toxic, the toxic waste in that area. In 4 houses, 179, 181, 183, and 185. 5 people have died from cancer. 3 of us still have it. Or 2 of us, sorry, 2 of us still have it, and 1 has undisclosed illnesses. We're not blaming what's there now. We're blaming what was there before, what we ate from the backyard that was polluted by the fallout from, excuse me on that, from the fallout from the former tar plant, the auto recycling yards, the pollution that leached into the grounds. They're going to go in there, tear up all that area, disturb it. Last year they dug a, oh, thank you very much. Last year they went in and tore up a test pit to check the pollution. Within 3 minutes, The water, pollution, oil, tar was leaking into that pit that they could not contain it. They could not even backfill it until they brought a vacuum truck in and sucked out all that garbage that was in there. It stunk like diesel fuel for 2 days in our area. We cannot deal with having that stuff removed and then a roadway put through. Again, I lived there since '65. I know what traffic was like on that street. We residents that are there now, plus the neighbor that just moved in, that looked around for a nice quiet neighborhood, is going to be subject to an open street that goes right through and destroys a park. According to the design of the park, the main area is going to be moved down into the most toxic waste. That's going to be the most heavily used. Your own reports that were done, and I'll quote them, park likely poses very little risk to public health. Sure, the way it is right now. Come down and see all the garbage that's leaching out on the walkway that the city says, oh, very little risk. It's a lot of risk as far as I'm concerned. I'm living proof of it. And to me, it is not worth the risk of having more residents get sick by disturbing this toxic waste just to put in a walk-friendly park. Right now, we got a kid-friendly park there. The kids use that park on a daily basis. We got tennis courts up at the top end that are used and basketball courts. We got a splash pad. Where's that all going to go? Down where the big city maintenance yard is? Put the townhouses down there. Never mind building townhouses up in the west or south end of the park that aren't going to be compatible. The plans are to bring the houses right down to 179 Caroline. The houses aren't compatible with what's there now. Why would you want to do that? I think it's wrong. The rest of the plans for north of Barton, I agree with totally. I think it's a great idea, but not south of Barton. Leave that area alone. That's all I have to say. Thank you.
Thank you, Steve, and thanks for taking the time to come. Thank you to everyone who took the time to come. I need a motion, please, to receive all 4 presentations. Councillor Farr, Councillor Pearson, all those in favor? Thank you. Now we've got the, you've got 8.4 on the table right now. I'm going to go for questions with staff. Councillor Farr, you were first, and then I've got Councillor Whitehead.
In light of our last delegation, which we much appreciate, if Emil could step up to the mic through you and just confirm again for the record on the environmental assessment that was the direct result of an actual public works motion that was a direct result of citizen engagement and citizen request. What have we done so far as it relates to the environmental assessment? What do we plan on doing? Ultimately, we'll determine that path based on what we find. But if you could just sum that up one more time for the record as it relates to the environmental work that has been gone on and that continues.
And before you start, I forgot to do this earlier. Could you please introduce yourself and your job title so everybody understands who's speaking on for this question? Thank you.
Okay. Through the chair, my name is Emil Perpich. I'm the manager of recycling and waste disposal. Related to my involvement in this particular project is as our group is involved in the contaminated sites groups for public works. So it's a little bit of the background. In terms of what we've done to this point, as the gentleman explained, we have done some investigation work there to determine what materials have been there historically, and it's, as I mentioned previously, it really is related to some of the historic uses of that particular property, some asphalt recycling type facilities, something really related to petroleum tar products. So we have gone in, we have done the assessments. We are currently working on the risk assessment for that park, which will basically give us the direction of how, in conjunction with the Ministry of Environment, of how we need to remediate that park.
And thank you. And it's been about a year and a half or more now. Through you, Chair.
Through the Chair, that's correct.
Mel?
Okay.
Thank you.
And the important thing is, as we learned from Julia earlier, and if you could just confirm, Emil, this is a coordinated effort as it relates to Central, as it relates to environmental issues, and what we have before us with this design study. It's a coordinated effort.
Through the Chair, that's correct. We're trying to ensure that the remediation aligns with the design to make sure that all those factors are covered.
Thank you. I don't see the previous delegate here, so I'll pass on. I think he's left. So through you to Jason or whomever can answer the question on the strategic mandate that we devise for ourselves, certain projects with this corporation citywide that we looked to accomplish and make milestones on and make achievements on. Can someone from staff please respond to that?
Will someone from staff please respond to that?
We were hopeful as a council for this term, were we not, to get to this point before the term concluded.
So Chris Phillips, timing please.
Through you, Madam Chair, I'll just say
that
that is correct. That was part of the strategic mandate for this term of council. Was my understanding, and Chris can add to it.
Thank you.
Thank you.
Just so maybe follow up the other piece is that there were multiple simultaneous aspects in the strat plan that were all related in the same area. This Barton-Tiffany urban design study, as well as getting development going within the area, getting it to market, as well as the other aspects of the waterfront land assembly.
Thank you both.
Councillor Farr.
Now to Sarah's great presentation and all the communication, and to bring maybe some clarity as to mixed income communities. I mean, certainly we talk about it as a proud board member of City Housing Hamilton on occasion, and more of late since working with the HAP as well as Chair of Emergency Community Services. Love it. It's the way we should have done it a long, long time ago. Not great big towers where those in the low income bracket live in isolation and all in the same place. I've visited now twice Toronto and looked at their plan. It could be better, but as it relates to a major community overhaul there with Regent Park. So I'm a big proponent of this, but I wonder if through you, Chair, Michelle Sergi or Jay, this is an urban design study that's before us today. So we're looking at residential, but generally right now, where would having the conversation about mixed income come into play as we move forward? Through you, Chair.
Through the Chair, that's correct. This study really is about the form or the design of the development and the fit with the community. It doesn't really address things like affordability or tenure. That would be part of a future process dealing with the city-owned lands.
Can you identify, just for the delegate, where in the future, or roughly at what stage? Is it at the buying and selling stage? Is it a real estate thing? Where does that happen, generally speaking? Through you.
Through you, Mr. Chair, maybe I can take a stab at it. I think there'd be two elements to it. The first would be overall, it would be to look at the entire area and see what aspects could be accommodated. Specifically, though, the city owns, as we've mentioned, in this particular block, owns the two largest development blocks, and therefore that is actually from a public policy and land perspective, it's in council's control.
And through you, Chair, some references were made to exclusionary zoning. I wonder if Jason could comment on what we heard from our representative from the Social Planning Research Council on what you know of exclusionary zoning, how it could work as it relates to this area or as we move forward.
Through you, Madam Chair, inclusionary zoning is it's certainly been a popular topic in planning circles. I know a number of municipalities across the region have advocated at various points to have that included as a power that municipalities would have. At the moment, it's not something that we can do. It's not permitted under the Planning Act, but it is something that I think will hopefully be on the province's radar as we move into a new round of Planning Act reform.
And does that mean, as well as Sarah noted in her presentation, the density bonusing, where developers gain some benefits such as higher density, greater height, incentives, tax breaks? I know this area, maybe we can confirm, this area is in our current CIPA boundary, so it is eligible for all the benefits through you?
A lot of head nodding. Go ahead.
Yes. Through you, Madam Chair, that is a power that municipalities do have under Section 37 of the Planning Act to require various public benefits in exchange for density bonusing, and affordable housing can be one of those, and municipalities do use that. Our current official plan does provide for the potential for bonusing, and looking at that more specifically and what some of the public benefits might be is something that we're considering as part of our work plan for the next year.
That's what I wanted to hear. Okay.
Thank
Great.
you.
And thank you to Sarah again for that presentation.
I'm allowing for comments at this point, too, so we can ask.
I'll be brief. It's getting late in the day, and I'm hopeful that we'll have an opportunity to move a little more quickly on the James Street Mobility Hub, which is probably a big sigh of relief to hear a committee member say that for David Filletta. We may even be able to waive the presentation, but the two really go hand in hand, and a lot of what I had commented on and questioned on relates to item 8.52. So very briefly, Julia, she had her accolades, but all the rest, I really appreciate the considerable amount of time and effort staff have taken to help me address what has been probably, there's no other example of citizens, residents of Ward 2 on one single topic with a multitude of questions anywhere close. And they've been there each and every time. We've had many meetings. I've had lots of updates. I've looked at stick drawings to what we have before us here today. And there's just been a wide variety of staff from various areas that have sat through these meetings and offered these updates and always answered the call, ultimately of the residents. So I'll just say thanks to that. Very much obviously approve what's here and appreciate what's here. And I think the fact that we've had only, Madam Chair, 4 delegates, and given the significance of this project, it speaks volumes to the engagement that has gone on in advance of today's public meeting, which seeks approval of an urban design study for Barton-Tiffany. Thank you.
Thank you, and I'll take that direction. You're going to move 8.4 and probably 8.5 as well. Councillor Whitehead, please.
Yeah, 2 questions, and then I'll just make a brief comment. One is the risk assessment on the environmental, because there's questions by the individual in regards to, as soon as you upset or move something, to become higher risk. Can you explain just exactly what that risk assessment component is?
I believe he did when you were out of the room, but very quickly, please, Emil.
Through the chair. So the risk assessment will be a part of our record of site condition process. And basically what we're going to do, we've already done phase 1 and phase 2 environmental studies of the park itself and the contamination that's found there. So this risk assessment really is that next step in terms of putting the plan forward of how we will deal with the remediation. And again, that's done with the Ministry of Environment.
I appreciate that. The next question I have is water sewer servicing plan along Stewart Street. Is it value designed and engineered to accommodate the 28 acres of CN yards? Should this become part of the plan in the future?
So is the capacity up to, in case we turn the rail yards into residential, would there be enough capacity in our system, Mr. Sergi, to accommodate that future development if in fact it comes? Oh, wrong Sergi, sorry.
Through the chair, similar to the urban design study, it had the same boundaries, so that was not investigated, so I can't speak conclusively as to whether or not the capacity is there for the shuttling house.
So because it wasn't planned for, they cannot answer. Sorry.
Okay. Clearly the capacity is there for the plan.
Clearly the capacity is there for the plan. I'm going back to this guy, right? The capacity is there for the plan currently?
Yes.
Tony's throwing his voice now.
Thank you. Just briefly, my comments, Madam Chair.
Yes, sir.
I don't think we can underestimate the transformation, the evolution, the game changer, or whatever adjective you want to utilize in regards to having an actual plan that makes sense and then creates a quality of life for many of those that currently live there, and certainly enhance the lives of those that plan to live there in the future with the mixed use, the balance that they've provided, and the mobility, pedestrian mobility. The plan from a conceptual point of view is excellent. Like I said, the only reservation I have is, and I couldn't even answer the question, is if in fact it's always been our desire to have a plan right to the water's edge, that at the very least we don't bite our nose beside our face in the context of the servicing and ensuring that we do have the capacity built in this plan or in the future plan to ensure that we can accommodate those 28 acres in the future. I want to thank all those involved in this development. I want to thank the North End neighbors and those that are impacted by this development, Central neighborhood, and I want to also, obviously, can't find a better champion than a hardworking Councillor Farr, for his champion and working with staff and the neighborhood to come back with such a exciting concept. Thank you.
Thank you. Councillor Collins.
Thanks, and certainly I've always been a fan of the waterfront, and so I'm so pleased to see what we have here in front of us. And I want to say that I've always been perplexed by the whole notion of the resistance to change, and I went through that a little bit in my own area when we put the waterfront trail in on the beach strip, and there was certainly an element to the community who were uncomfortable about some of the changes that were on the horizon, and much of it means it was related to the fact that we'd have more people traveling through their rear yards on public land, and the fact that we'd see changes as it relates to development, and we've seen a number of new homes on the beach strip, and this is by far happening on a much larger scale in the West Harbour, and I've been perplexed since I've been a part of what's gone on, and certainly not as close to this file as Councillor Farr, but I've always been perplexed by the resistance and the reluctance, especially politically, to accept the investments that we've made. And this council has invested probably, I was trying to put it through my head in terms of what the trust has spent, and going back to Bayfront Pier 4 Park to present day, we've probably spent in the order of between 20 and 30, $35 million. And we're starting to see certainly the fruits of our labor, because we had a neighborhood 20 or 30 years ago where people were looking for greener pastures in other areas. They were moving out of the neighborhood, and now it's probably one of the hottest real estate markets in the city, thanks to the leadership of people like Councillor Farr. And I've worked with people who've represented that area, who have thumbed their nose at public investment, who've tried to make it difficult to approve these plans. And as soon as Councillor Farr was elected to office, it seems to have been just smooth sailing, no pun intended, ever since. And I want to commend him, because, as he rightly pointed out, we've had nothing but conflict over the years in terms of trying to implement positive change. It's not like we're trying to locate a toxic waste facility here, but it seems like every turn and every angle in the past we've been met with resistance, and that's not to suggest that there isn't room for disagreement. But I want to specifically point out Councillor Farr's leadership, because it's since his tenure in this area that we've seen some harmony and some agreement. He's pulled the neighborhood together. He's done it with a great team, certainly, as he's pointed out here today. But I've worked with 6 or 7 people now in my tenure on council who've represented this area, who've been through all that change, and no one's worked harder than Councillor Farr to accomplish what we have here today. Those are my comments, and I appreciate all the hard work that's gone into this.
Thank you very much. Councillor Ferguson?
Yeah, I've been pretty much in the bleachers of this issue, watching from the sidelines. And I agree to a comment Councillor Collins made about an hour and a half ago, when he said these lands have been sitting for a long time and the public's getting anxious about it. They're derelict, they've took the ring plant down, and we're not seeing anything happen. And we've been bogged down with the setting sail secondary plan with the railway lands, trying to figure out how to solve that problem. And then we got the resolution today. And I don't want to give Councillor Farr a bigger head than he's already got, but this is neat to sit here and this big a change, and only 4 people come in and speak about it. I think that's unprecedented.
Absolutely.
To have that type of reaction from the community to solve these problems before we show up in the council chambers. So congratulations to
Congratulations indeed. So, Councillor Farr, I'm coming to you. 8.4. The Barton-Tiffany neighborhood study. All those in favor? Carried. Thank you. We're going on to 8.5. I'm coming back to Councillor Farr. He wanted to move 8. Oh, Councillor Whitehead. 8.5. We've got the James Street. Oh, This will show you how many people were involved in this. They're all getting up now.
I would move to waive.
Plus, we got to make sure you guys get your credit. Yep, got it. Sorry, okay. Okay, so, sorry, Councillor Farr, we've got 8.5 sitting in front of you.
Do you have a presentation? Because I would waive it if you do.
Says right here, I'd like to invite staff forward. Then I have a motion to approve the item. So it's very clear cut. It's up to you.
I'll move to waive it, seconded by Councillor Pearson.
Thank you. All those in favor?
Yes, I'm happy to second that and move it, but can we just recognize the staff that were involved on this as well, please?
Absolutely. We wouldn't finish this without Councillor Farr doing his spiel. Mr. Spiel, go ahead.
Actually, could Councillor Collins do the spiel for me? He's really good.
Yeah, because, you're right, Councillor Ferguson, the big head's coming out. Right.
Sure. I want to move. I would love to move this as well. And I'll have a secondary in Councillor Whitehead. But David Filletta, who's been waiting all day, has also been the key staffer on this file. He lives in the area, works out in the area, and has also been as engaged and willing to answer the call whenever I had questions. The James Street North Mobility Hub, as many in this room know, or some may not know, along with the Barton-Tiffany Urban Design Study, which we just passed, and the Barton-Kenilworth Corridor Study, which is another key one we recently moved as a collective here. We're all part of PICs, these are called Public Information Centers, that were really well attended. There were 3 of them. The first was, let's throw the sticky pads on the wall and see what the community wants to talk about. The second was, well, based on what you're talking about, what do you think about this? And then the third meeting, another greatly attended meeting for all 3 was, this is what we've come up with based on what we've talked about for over a year. So the James Street North Mobility Hub was sort of thrown in there, given the importance of that particular area around what we know now is going to be go and likely all day go in short order on James Street North. And Dave did a very good job of presenting the visual to the community as it relates to how downtown, particularly a downtown GO station and its immediate surroundings should look, could look, and really made people comfortable as it related to the intensification question. He also, I should add, worked with individuals who are property owners at present and who have met with myself and other staff, along with David, and talked about some of their plans that actually meet the goals and objectives and actually were enhanced or brought into the discussion with the focus groups and the PICs as it related to the James Street Mobility Hub. He did a good job, so did all the rest of the staff, and I'm really pleased at the report. It's extensive and it's well done, and I'm happy to move it here today and thank everybody involved, especially the many people who were really focused on the James Street Mobility Hub in those 3 big meetings that contemplated all 3 of the studies that we'll have approved.
Here, here. So Councillor Whitehead, and then I have Councillor Collins.
Just very briefly, I didn't see, and I might have missed it, we've talked about, God forbid, the LRT east-west. There's been a huge debate that there should be a north-south route from the airport to the waterfront, or certainly feeding the GO transit station. Is that concept being incorporated in this plan?
Oh, David, you get your shot. Come on down. Waiting all day. Want to hear the question again?
Yeah, can you please
Thank
repeat
you.
through the
Councillor
chair?
Whitehead?
I just want to know conceptually in this mobility plan, and I didn't see it, there has been talk, and I think it's been part of our rapid transit study, and it's been identified the potential of, not in the near future, maybe in the far future, but having said that, the potential of an LRT from the airport to the waterfront servicing the GO station. Is that incorporated in this mobility plan?
David?
Is it contemplated?
Through you, Madam Chair, yes, it is, and that's what makes this area a mobility hub. It's where 2 transit lines intersect. In this case, it's the future rapid transit A line as well as the all-day GO.
Thank you.
That's
it's
all
in
I
the
need to know.
report. Thank you.
Thank you.
Councillor Collins.
Thanks. I'm surprised with the, it has short, medium, and long-term deliverables. And when I read the report, it says that there are no financial implications. So I understand in the context that staff may come back, it says, with information including financial, staffing, and legal implications, but in terms of next steps, I'm still unclear. So there's no financials attached to it. There is a long list of things that need to be done to accomplish what the goals and objectives in the report. Can you help me with that through you, Madam Chairman?
Okay, David?
Yep, through you, Madam Chairman. As you're all aware, as part of the study, we've hired Brooke McElroy, who's the project consultant, and David Sajecki is here with us today. And they've identified a number of items that, number of things that we can do as a city to ensure that we capitalize on the mobility hub. And the reason why we've indicated that some of those recommendations will not require legal or financial implications is because we may be able to incorporate them into existing work plans. We know that our rapid transit group in Public Works is doing a number of them already. So when our report comes back as part of recommendation B, we'll be able to sort of clarify those implications a little bit better.
Okay, thank you.
Thank you. Councillor Farr, back to you. Moving and seconding. Thank you. All those in favor of 8.5. Thank you, and thank you, David. Now we're on to 8.6. Alyssa Golden is here. Recommendation to designate 52 and 56 Charlton Avenue West, Hamilton Charlton Hall under Part 4 of the Ontario Heritage Act PED 14176 in Ward 2. Councillor Farr. Thank you. Before we do that, I just want to thank Alyssa. This was an awesome report, by the way. I loved, maybe I'm just a visual person, but I loved the pictures. I love the descriptions. It's a very thorough job. Way to go. You just don't realize how much work goes into one address. So congratulations. It's a good job. Yes, ma'am. And Alyssa would like to speak.
Through the
please.
chair, I'd just like to thank our consultants, Paul Dills and Peter Stewart here from George Webb Architect, who prepared the very comprehensive cultural heritage assessment, which is attached to the report. So really,
that's the one
they deserve the, yeah.
Thank you very, very much. Councillor Pearson.
Madam Chairman, yes, thank you. And thank you so much for the compliments to the staff and the consultants. And as you can recognize, as our list grows at Heritage Committee for designating properties, this is the type of work that's involved, and that's why the timelines get stretched out to, I'm not sure if we're down to 2018 now or 2019 now. Thank you.
Thank you. We can't approve anything because we've lost quorum, so we're going to have to wait. We're going to go on to the next one, please. If you just want to hold still just for a second, we'll wait until we get quorum. All right, so we're going to 8.7. This is the funding of external consultants for the OMB appeal. And this is for Ancaster Wilson Street and the approval of funding sources until January 2015. No questions, no comments. So as soon as we get them coming in, we're ready to go. Can you please go get them, please, Vanessa, so we can finish up this meeting, please? And it's Terry we're going to need. We just need Terry, and we've got quorum. I believe we are, but I'm going to go to our general manager first before we go to closed session. And we have a motion for Rymel Road that's sitting in front of you that needs to get resolved today. I'm sorry? And we have Matt Johnston here for he spells his name wrong. Yes, we'll do that too. I know. All right, folks, we've got 8.6 moved by Councillor Collins, seconded by Councillor Pearson with our thanks. All those in favor, thank you. 8.7 moved by Councillor Collins, seconded by Councillor Pearson. All those in favor, thank you. And right now, I am going to ask Matt to come down because he's here. I'm sorry? The notice of motion. Is this the Rymel Road one? I don't have a notice of motion. I've got the motion in front of us, and this is for Rymel Road. It's a notice of motion. It's Jackson and Clark and myself that want to get this on the board and get it quickly because of this is really detrimental getting the Rymel Road. So if we want to keep this as a notice of motion, that's fine, but that means we have to wait until the new council before we bring it forward. And if we can get Tony to speak to it, you'll understand why. Sure.
We actually deal with it.
Yes.
whenever I see cost implications,
Yep.
I don't have a problem. I'd love to see Rymel done right across the mountain, so that's not an issue. But whenever I see where they're dipping into funds that were not allocated for this particular purpose, the question is, what are the implications on other projects that may have been on the books?
Okay, so we've got a notice of motion right now. Are we okay to ask staff questions about the notice of motion? Okay, so Mr. Sergi, could you please fill us in on this? Because I think initially it was supposed to go to Public Works, but we brought it here because of DCs. Go ahead, sir.
Through the chair to the councillors. The project as it stands was put in 2013. When we finished the detailed design and the additional scope of work, the project was not, we ended up tendering it in two pieces. The first piece closed and it had a substantial increase in cost. In order to finish out the tendering, this is the money that will be required to finish out the second phase that was already approved.
Okay, Councillor Collins?
Yeah, so what was the reason? Like, it's substantially over budget. So do we know why that's the case?
Through the chair to the councillor, the number that we carried from the 2007 EA that was completed, for example, said from Glover Road to Highway 20 was around 17 million. So staff carried the proportionate cost. When we reduced the scope, we reduced it accordingly to the value that was anticipated, but it required additional works in terms of 4 or 5 additional lights at $250,000. Lights, additional asphalt, additional sewers, additional things. So the prices were low from the original estimate, and then we had an increase in scope of works.
Thanks for that. My second question is, there's 2 funding sources. The first one's identified. The second one's just an account number. Do we know what that is?
Yes, it's the monies that are collected directly by the developers that create severances and urbanization.
Thank you. And if you can take number on Rymel Road until this works gets done, and it was always going to be done, and it was going to start this fall, and because we've run into this snag, we can't start it now. So this is why we're asking staff to get this going, so we can get these developments that are sitting now on in the hopper that have been approved pending this completion. So I'll take the chair back. Thank you, Councillor Whitehead. Thank you.
And it makes perfect sense now that it was already a planned project. It's over budget, so all those things are fine and dandy. And the explanation, I guess the question is, because I've been told that the DCs and the actual revenue in the reserve is limited. So I guess it's competitive in regards to the projects that are on the books. So can you help me understand, by tapping in and grabbing more DCs, are we bumping out another project, and what would that project be?
Mr. Sergi, does this put all the others in jeopardy, or any in jeopardy?
Through the chair, I don't believe that's the case. But maybe that's a conversation we'll have through the budget process with finance, but I don't think that's the case at all at this point.
Great.
Okay, so what is the will of this committee, please?
Waive
because
the
I know
rules
it's at a notice of motion, so I've got a motion in front of us to waive the rules, to make this a motion from Councillor Whitehead, seconded by Councillor Collins. All those in favor? The motion's in front of you right now. Move it from Councillor Collins to Councillor Whitehead, seconding it. All those in favor?
Carried.
Thank you on behalf of Councillor Jackson and Clark and myself. All right, so we've got through the motions. We're going to, sorry? We've got a delegation here before we go into camera. An outstanding business list, I'm sorry. Well, okay, we'll go down to there. And we've got item V and item MM. So can I have a motion, please, on the outstanding business list? Thank you. Councillor Whitehead, Councillor Pearson. All those in favor? Thank you. And Matt, we'll go to you. And then I'm going to go to our GM, and then we're going to go in camera.
Thank you. Good afternoon. I will be brief. Not only to get you guys out of here, but I need to get home because I'm happy to say I'm closing on our new house in Hamilton today, moving from Oakville, so I need to get home. So I appreciate the opportunity to...
Which ward? No, I'm kidding.
Councillor Ferguson. Thanks again for the opportunity to address committee and staff today. I'll make this brief. As you may know, you'll go in camera later today to talk about our OMB appeals as it relates to Shoppers Drug Mart at King and Dundurn. We've got some ongoing applications that are going to the board. Quickly just highlight a few dates. You're going in camera today because we do have a pre-hearing coming up in November and a OMB hearing in February. There's 4 other key dates, so I'd like to highlight that we started this process back in 2011. We've had 2 applicant-hosted information meetings, and on June 10th of this year, we presented our current plan to the councillor and community council, and it's my understanding that they're pleased with what they see in that regard. Now I'll get quickly into the issues at hand.